Sir? Sir? What officer, sir? Sir? That's my bad. Sir? Sitting arresting and take, sir. Sir? Sir? Sir, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? Sir? 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 Sir?
ಹಲೋ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ. ಸಿಟ್ಟಿಂಗ್ ಎಷ್ಟು ಗಂಟೆಗೆ ಸರ್?
ಯಾರ್ದು ಏನ್ ಪ್ರಾಬ್ಲಮ್? ನೀವು ಮಾತಾಡ್ತಾ ಇಲ್ಲ, ನಿಮ್ದು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರಿಯಾಗಿ. ನಮ್ಗೆ ಬರೀ ಸರ್ ಸರ್ ಅಂತ ಇದ್ದೀರಾ.
ಇಲ್ಲ ಸರ್, ಸಿಟ್ಟಿಂಗ್ ಎಷ್ಟು ಗಂಟೆಗೆ ಅಂತ.
ಸಿಟ್ಟಿಂಗ್ 11:30.
11:30. ಓಕೆ, ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್, ಫೋನ್ ಆಚೆ ಮಾತಾಡಿ. ಲೈವ್ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ, ಯೂಟ್ಯೂಬ್ ಹೋಗ್ತಾ ಇರ್ತದೆ. ಅದು ಫೋನ್ ಮಾತಾಡ್ತಾ ಇದೀರ, ಆಚೆ ಮಾತಾಡಿ. ಕೊಡಮ್ಮ ಕೊಡಮ್ಮ, ಮೆಮೋಸ್ ಕೊಡಮ್ಮ. ಅಮ್ಮ ಹೊಸ ಸರ್ ಈ ಕಡೆ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀವಿ ನಾವು.
ಎಷ್ಟು ಗಂಟೆ ಸಿಟ್ಟಿಂಗ್? 11 ಗಂಟೆಗ ಸಿಟ್ಟಿಂಗ್? ಎಷ್ಟು ಗಂಟೆ ಅಂತ? 1:30.
ಹೈಕೋರ್ಟ್ ಅನ್ವಿಲ್ ವೇರಿಂಗ್ ಸರ್. ಮತ್ತೇಂದ್ರ ಉದ್ದಾರ್ ಸಾಹೇಬ್, ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಸಾಹೇಬ್, ಪರ್ಮನೆಂಟ್ ಹೇಳಿ ಸರ್. ಹೇಳಿ ಮತ್ತೆ ಸಮಾಚಾರ. ಬಂದಿದ್ದೀರಾ? ಇವತ್ತು ಬೇರೆ ಲೈವ್ ಇದೆಯಾ? ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇರ್ತದೆ ಇವತ್ತು ಲೈವ್. ಮಾಡಿದ ತಕ್ಷಣ ಶುರು ಆಗ್ಬಿಡುತ್ತದೆ ರೆಕಾರ್ಡಿಂಗ್. ತಿರ್ಗಿ ಆಫ್ ಮಾಡೋದು ಅಲ್ಲಿ ಸ್ವಿಚ್ ಆಫ್ ಮಾಡಿದ್ರೆ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ. ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇರ್ತದೆ. ಓಕೆ.
ವಿಡ್ರಾಯಲ್ ಮೆಮೋದು ಮೊದಲೇ ಮೂವ್ ಮಾಡ್ಬೋದಾ? ವಿಡ್ರಾಯಲ್ ಮೆಮೋ
ಮೆಮೊ ನೀವು ಅಟ್ಯಾಚ್ ಮಾಡಿ ಮೆಮೊ ನನ್ ಕೈ ಕೊಡಿ.
ಇಲ್ಲ, ಬಂದಿದೆ 35th ಮ್ಯಾಟ್ರು. ಮುಂಚಿತವಾಗ್ಲೇ ಮೂವ್ ಮಾಡ್ಬೋದಾ ಅಂತ. 35th ಮ್ಯಾಟ್ರು ಮೆಮೋ
ಏನಾಗ್ಬೇಕು?
ಮುಂಚಿತವಾಗ್ಲೇ ಮೂವ್ ಮಾಡ್ಬೋದಾ ಬಂದಾಗ?
ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ. ಪೇಜ್ ವೈಸ್ ಹೋಗ್ತೀನಲ್ಲ, ಅವಾಗ್ಲೇ ಹೇಳಿ ವಿತ್ಡ್ರಾ ಮಾಡಕ್. ಎಲ್ಲಿಂದ ಯಾರು ಲೇಟ್ ಆಗಿ ಕೊಟ್ರು ಅದೆಲ್ಲ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಆಗ್ತದೆ. ಎಷ್ಟೊತ್ತಿಗೆ ಕೊಟ್ರು ಹಾ ಸಿಗೋದ್ ಲೇಟ್ ಆಯ್ತು ಅಂತ ಬರ್ದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ಯಾಕೆ ಹಂಗಾಯ್ತು? ನಮ್ದೇನ್ ಪ್ರೆಷರ್ ಇಲ್ವಲ್ಲಪ್ಪ. ನಮ್ದೇನು ಗೊತ್ತಿಲ್ಲ. ನಮ್ದೇನ್ ಪ್ರೆಷರ್ ಇಲ್ಲ. ಮೆಮೊಗಳು ಅವ್ನ ಯಾರು ಸ್ಕೂಪ್ನಿಂದ ಕೊಟ್ಟದ್ ಕರ್ಕೊಂಬ. ನಾನ್ ಕೊಡೋದು ಒಂದು ವಾರಕ್ಕೆ. ನಾವು ಅವನ್ ತಂದೆ ಕೊಟ್ರು ನಿಂಗೆ ಯಾಕೆ ಪ್ರೆಷರ್ ಆಗುತ್ತೆ ಒಂದು ವಾರ? ಆಫ್ಟರ್ ಕೋರ್ಟ್ ಅದು ವರ್ಕ್ ಆದ್ಮೇಲೆ ಮಾಡ್ಕೋಬೇಕು. ಅವ್ನ್ ಲೇಟ್ ಆಗಿ ತಂದ ಅಂದ್ಬಿಟ್ಟು ನೀನು ಅದನ್ನ ರಿಸೀವ್ ಮಾಡ್ಕೊಬೇಕು. ಸಾಹೇಬ್ರು ಬಾಕ್ಸ್ ಹೋಗಿಲ್ಲ ಇವತ್ತು, ಯಾರು ನೆನ್ನೆ ಹೋಗ್ಲಿಲ್ಲ, ಇವತ್ತು ಹೋಗ್ಲಿಲ್ಲ, ಯಾರು ಆನ್ಸರ್ ಆಗ? ಒಂದ್ ದಿವ್ಸ 2 ದಿವ್ಸ ಪರವಾಗಿಲ್ಲ, ದಿವ್ಸ ಅದೇ ಆಗ್ಬಾರ್ದು. ದಿವ್ಸ ಅದೇ ಆದ್ರೆ ಕಷ್ಟ. ಯಾವ್ದು ನಾನು ಹೇಳಿದ ಫೈಲ್ ಇದು ಇವತ್ತು ಪೋಸ್ಟ್ ಆಗಿರ್ಲಿಲ್ವಾ? ಯಾವ್ದು ಇಲ್ಲ. ಫೋನ್ ಮಾಡಿದ್ದವ್ರಿಗೆ ಅದೇ ಸರ್ ಹೇಳೋದಪ್ಪ 3:15 ಇಲ್ಲ ದಿವ್ಸ ಆಗಲ್ಲ. ದಿವ್ಸ ಆಗದಾದ್ರೆ ಅದ್ ಕಥೆನೇ ಬೇರೆ. ಏನಮ್ಮ ಏನಂತ ಅಂತ ಇಲ್ಲ ಫೋನ್ ಎಲ್ಲಿ ಮ್ಯೂಟ್ ಆಗಿದೆ.
ಬಂದ್ರು ಅಂತ ಹೇಳಿ
ಮಂಜುನಾಥ್ ಆಗ್ಲೇ ಕಲೆಕ್ಷನ್ ಹೇಳಿಬಿಟ್ಟಿದೆ. ಕಲೆಕ್ಷನ್ ನಾನು ಬೇಡಿ ಬಂದು ಕಳಿಸ್ತಾ ರಿಪೋರ್ಟ್ ಆಮೇಲೆ ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ₹100 ಇರುತ್ತೆ.
Lord, I am petitioner. I appear as party in person. I'm seeking posting of this matter on 10th of Friday. I have sought some urgent interim order. It's a fresh matter.
Not Friday. It's on Monday.
13th.
13.
Very kind.
Matter 2:30 minutes for the reason.
1940, the respondent first one family had owned property in General memos ಎಲ್ಲ
ಮೆಮೊ ಎಲ್ಲ ಕೊಡಿ. ನಾಳೆನೆ ಬೇಕಂದ್ರೆ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ. ಬಾಕಿದ್ ಕೊಡಿ. ಬಾಕಿದ್ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ವಿತ್ wait. Within the week we'll post this matter. If there is any urgency tomorrow itself, you move that matter. All other matters, don't waste the time. Give it.
Within week, settlement.
1 week ಒಳಗೆ
Monday, yes.
Matter for.
What is that this thing, Mr.
Next one.
Wednesday. Yes. Wednesday. Thursday. Then we'll have it on 20th. Yes. Admur, I have given so many dates. Therefore, 6 years in 6 days, nothing will happen. Yes. Yes. No, what is that urgency now?
They are trying to invade on my property by work of the
Monday, yes. Yes, 15th. That's what I said, 15th. You said the 15th and 16th. Yes.
There are 10 petitioners. They are all constructed the house in the property of revenue land. Since from last 40 years. But now the court, because the first respondent has obtained the decree, now the demolition order has been ordered. That is why I have filed the application for the appointment of the court commissioner. That has been rejected. That is why, my lord, kindly tomorrow, because urgency, my lord, demolition is order made. Delivery warrant
Yes,
is.
tomorrow, yes.
Delivery warrant is- The petition is, my lord. The matter is posted for tomorrow for arguments for the dependent arguments, my lord.
What is the order you are challenging?
I filed application for further cause of plaintiff, my lord.
Yes.
Attachment warrant in execution, my RA is pending. Food for money recovery.
There is no stay in that RA.
No, my lord. His notice has been issued, objection.
Why can't
is
you
filed.
press for an
Only
stay
5
there?
days, my lord, his RA is only
Yes,
5
tomorrow. Yes, tomorrow.
Lord, one matter, that the process of cross-examination, the suit is based on for partition. Whether they apply, witness admitted the partition deed and the other thing. Respondent number 1 is holding the same. He sought for direction to produce the same. The court rejected the same. On that basis, we'll have to proceed further cross-examination. But day to day it is posting. But tomorrow or day after tomorrow, any day.
Yes, day after tomorrow.
Compromise petition is rejected. Compromise petition rejected. Compromise petition rejected on the grounds that partial settlement is not possible. Now this court is saying I'll dismiss the suit if you don't need evidence. The matter is on Friday. I'm requesting for tomorrow or Friday, my lords, any day.
Not Friday, Monday, 13th.
Suit is on Friday and he's saying last chance I'll dismiss the suit, my lord. That's why Friday or tomorrow, my lords, any day.
Yes, tomorrow.
Grateful.
RFA Friday.
This matter was directly posted today, my lord. Tomorrow is for final arguments. Bandila, ನಾಳೆಗೆ
Memo move ಮಾಡಿದ್ರಾ?
ನೆನ್ನೆ ಮೆಮೊ ಮಾಡಿದ್ದೆ.
Have you directed to post today?
Yes, my lord.
Then why Mr. Court Officer? Very fine. Okay. Once we have directed, why the office is
Tomorrow, my lord.
tomorrow. Verify ಮಾಡಿ.
ಹಾ, sir.
ನಾವು ಕೊಟ್ಟಿದ್ವಾ ಏನು ಅಂತ.
ಕೊಡಪ್ಪ.
Not Friday, Monday. Friday RFA matters. I have other roster also, madam. Yes. Extension of entry matter. ಏನಾಗಿದೆ ಎಂಟ್ರಿ ಮಾಡ್ರ? ಎಕ್ಸ್ಪೈರಿ ಆಗಿದೆಯಾ ಇಲ್ಲಿ? ಯಾವತ್ತು ಎಕ್ಸ್ಪೈರಿ ಆಗಿದೆ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ತದೆ. ಎಸ್
My lord,
Next week.
For argument today, amendment application has been rejected. I request my lord to have this.
tomorrow.
Today itself it is voted, but they are giving time.
No, that any arguments, it is not for an orders. Tomorrow we'll see. No, that any caveat or somebody is there, then tomorrow, yes. Tomorrow we'll have. No, today.
ನಾನು ಫೈಲ್ ಮಾಡಿದ್ರೆ 11 ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, 3 ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದೀನಿ.
Yes.
ಆಫೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಅಗೈನ್ ಐ ಮೂವ್ ಬಿಫೋರ್ ದಿಸ್ ಆರ್ ರಿಪೋರ್ಟ್ ಆಲ್ಸೋ.
Yes, 2:30. Yes.
2:30.
Yes.
my lord, I request end of the list today, my lord. The matter is posted tomorrow for arguments. The stage will be closed, my lords.
Argument tomorrow. Yes. Tomorrow. Yes.
Tomorrow.
Yes. What is that urgency, madam?
The matter is listed on Friday before the trial court.
Tomorrow.
Solution procedure. 1976 accusation, almost 50 years. Award for the technical. Max attained the minority Supreme Court 2009. He filed an execution petition before the Ramnagar court. There are 3 memo calculations, but one is commissioner, 2 Siddhartha, and he does not judge Milord, ignoring all the 3. His own calculation, 21 years of without adding Milord the additional market value.
Yes.
Now we are liable to pay only 4 lakh rupees. Milord, 1 crore 80 lakhs is due. Everything is accepted.
No, now what is that order passed by that? What is the order you are challenging?
Milord, ignoring Milord the from date of preliminary to the 97 Milord award. 1 year he has taken, 21 years he has ignored. 1 crore 80 lakh Milord. 3 generations.
No, what is the order you are challenging before me?
By the learned judge, by passing the only held liable for 4 lakh 80 municipality. 1 crore 80 lakh. As per the admitted by.
Yes, Monday. Yes, Monday.
For page wise adjournment, list number 1, page number 1, serial number 1 to 7.
My lord, serial number 2, my lords. I appear for the petitioner in this matter.
Yes, at the request of counsel for the petitioner, release this matter after 2 weeks. Yes.
Grateful, my lords.
Serial number 8, my lord. Kindly a week's time may be granted, my lord.
8, at the request of counsel for the petitioner, release this matter after 2 weeks.
Obliged.
Page number 2, serial number 9 to 17.
Appearing for the KVT respondent in that matter, my
Yes.
lord.
Yes, you have any?
I am-
Yes, at the request of counsel for the petitioner.
A date
release
may
this
be fixed,
matter
my
after 2
lord.
weeks. Why do you want, Mr. Madam, there is petition, you don't want to, yes.
Much obliged.
16, yes. Serial number 16, at the request of counsel for the petitioner, release this matter after 2 weeks.
Serial number
number
15, my lord.
Number is
Why it is connected? How it is connected? YS number is changed, why you want to connect it? No, it is not connected if it is a 2 different suits. No, Mr. Counsel. It is not connected, I am selling. If you want to post this matter on same day, I will post it. It is not connected, different suit, Mr. Yes, release this matter on 16.
Serial number 15, my lord. For petitioner, we are in the process of settlement, my lord. We request 2 weeks for the.
Yes, at the request of counsel for the petition.
Respondent in serial number 15, the matter has already been disposed by the trial court. Compromise petition's already been filed.
Then what else remains, Mr.?
My lord, we request a few weeks to file the check with the petitioner and
No,
provide the
matter
copies.
itself is disposed of, it become infructuous.
My lord, we have not yet received instructions, my lord. Therefore, we request.
2:30, you get instruction and make submission. Why unnecessary matter? Get it? If it is settled, party will not come with you. If matter is settled, they will not come. You just verify and make submission. 2:30, pass out.
Page number 3, serial number 18 to 25.
Serial number 22, your lordship.
Yes,
Kindly have it next week, your lordship.
you are appearing for.
Petitioners.
At the request of counsel for the petitioner, release this matter of 2 weeks.
Page wise.
Yes.
Page number 4, serial number 26 to 31. Page number 5, serial number
25. 25 to there, office objection.
Yes, sir,
25
office
to
objection.
28. Finally,
My lords, 26, there's an urgency, my lords, may kindly,
you have
I'll,
not complied office objection.
there are minor officer, I complain through the day, my lords, may kindly take it up tomorrow or Friday, my lords.
3 times you have taken.
No, my lords, this is the first time,
This
26
is
is,
the third time. 26, 26 first time, huh?
26 first time, I filed it day
first
before.
time, sir.
Yes. No, I will grant
To end of the day, my lords, I only need to
to
today,
comply today itself and move it tomorrow. Yes.
please, my lords.
It's 27 minutes, the matter is coming up before the trial court on 10th minute. Yesterday till 4:30 you have completed, again there is some. Have you heard, my lords?
No, you comply office objection and move that matter.
My lords,
It's because it's coming up on 10th minute.
Office objection has to be complied, is it not?
I may be permitted to complete today.
Yeah, you, see, you comply any day, I will give maximum 1 week time will be given. After compliance, you move that matter, then we'll take that. Yes.
my lords, 26, my lords, may kindly take it up
5 to-
Friday, my lords, it's an attachment order that's challenging, so date me given for day after, my lords, I'll complain through the day, 26.
You comply first, then you move that matter tomorrow, I will take day after tomorrow,
Please,
Monday.
please, oblige me.
Otherwise, if I say Friday, if you are not complied.
I
this is
quite
Friday
see, my lords.
unnecessary
I quite see,
that's
my
why-
lords.
Yes.
I'll complain, oblige.
Yes, 28. 25 to 28, finally week's time is granted to comply. Yes.
Page number 4, serial number 29 to 31. Page number 5, serial number 32 to 34. Page number 6, serial number 35.
Serial number 28, file and 800. Yes.
Page number 6, serial number 35 to 37.
Yes. Yes, learned counsel for the petitioner has filed in a memo seeking leave of this court to withdraw this writ petition. Memo is taken on record. The above writ petition is dismissed as withdrawn.
Page number 7, serial number 38 to 41.
Serial number.
Hmm. Yes, at the request of counsel for, have you informed the other side? Yes, at the request of counsel for the petitioner, leave this matter of 2 weeks. Yes.
Page number 8, serial number 42 to 47. Page number 9, serial number 48. Page number 10, serial number 49 to 55.
Serial number 50, my lord.
Hmm.
For the petitioner. Have it 1 week time.
50. Yes, at the request of counsel. Why, madam, 2022 matter? What is there? Yes, finally week's time is granted at the request of counsel for the petitioner. Interim order granted earlier is extended till next date of hearing.
Page number 11, serial number 56 to 60.
Lord, 56, my lord. The counsel for the respondent has got some personal inconvenience. It may have next week, my lord. I have informed the petitioner advocate.
Yes, at the request of counsel for the respondent, leave this matter next week. 59, you are appearing for? Yes, at the request of counsel for the respondent, leave this matter next week.
Page number 12, serial number 61 to 66.
63, my lord.
Hmm.
I'm for the petitioner. I have got some inconvenience. 63.
63, at the request of petitioner, leave this matter of 2 weeks. Yes.
Look, interim order operating may be continue.
Interim order granted earlier is extended till next date of
Problem.
hearing.
My lordship, serial number 49.
60,
seek 2 weeks time, my lords, to file my statement of.
you are appearing for?
65 for respondent.
I appear for the petitioner in the matter. Any date may be given.
No, that you are appearing for the central government.
65.
65 is that central government council only. You are appearing for whom, madam? You don't know whom you are
For
appearing.
respondent, my lords, serial number 64. WP number 3280 of 24.
Then you said the 64 or 65.
64, my lord.
My apology.
Yes. You are appearing for whom, madam?
For respondent, my lords.
Yes, at the request of counsel for the respondent. Is there any interim order?
No, my lord.
Anything before 20th, my lord, trial court date is on 20th.
64, you are there?
I'm the petitioner.
Yes, at the request of counsel for the respondent, leaves this matter next week. To the next Thursday, yes.
Serial number 49, my lord.
Serial number
Serial number 49.
49.
Yes, my lord.
Wait. We'll complete the list. We'll come back. Yes.
Page number 13.
Interim order to be extended. Yes, till next date of it.
Page number 13, serial number 67 and 68. Page number 14, serial number 69 and 70.
Yes, which is that matter?
49.
49.
Yes, my lord.
Yes, what do you want?
ಅದರಲ್ಲಿ I am the petitioner, my lord.
Hmm.
Kindly press time.
From that other side.
ಈಗ ಮಾಡ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ, ಹುಷಾರಿಲ್ಲ ಹಂಗಾಗಿ ನಾನೇ ಪರ್ಸನಲ್ ಆಗಿ
ಮಾಡ್ಬೇಕು ನೀವು.
ಈಗ ಮಾಡ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ, ಮೆಸೇಜ್ ಹಾಕ್ತೀನಿ, ಫೋನ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ.
They have filed an application for vacating.
ಹೌದು ಸ್ವಾಮಿ, ಒಂದು 2 weeks ಟೈಮ್ ಕೊಟ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ.
1 week. Yes.
ಆಯ್ತು ಸ್ವಾಮಿ.
At the request of counsel for the petitioner, leaves this matter next week. Interim order granted earlier is extended till next date of it.
ನಾನು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
List number 1, preliminary hearing matter, serial number 1, YK Narayana Sharma for petitioner, Krishnamurthy D.
For respondent.
For petitioner.
Yes.
Suit for eviction and for arrears of rent filed by the petitioner.
Hmm.
In the suit, during the pendency of the suit, the petitioner filed an application.
ಯಾಕ್ರಿ ಇದನ್ನೆಲ್ಲ ಫಸ್ಟ್ ಆಗ್ತಾರೆ? ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಇರಬೇಕು. ಇದನ್ನೆಲ್ಲ ತೆಗೆದುಬಿಟ್ಟು ಫಸ್ಟ್. Yes, mister.
During the pendency of the suit, the petitioner filed an application under section 151.
You are the plaintiff or a defendant?
I am for a plaintiff, my lord. Suit for eviction and for possession and for arrears of rent. During the pendency suit, filed an application seeking direction to the defendant to pay the arrears of rents. That application has been rejected.
Why?
The trial court said that he has disputed the arrears of rent. Kindly see the written statement, my lord. Nowhere he has disputed the arrears of rent. He has cleverly drafted the written statement.
No, is he disputing that you are the owner?
No, nothing. His main contention is that,
What is his contention?
his main contention is that he sought refund of the entire deposit amount in March 2020. I have not refunded that amount. And he was to vacate the premises. In view of that, he is not liable to pay the arrears of rents. That is the only contention he has taken in the written statement.
Yes.
But till today, he has not delivered the keys. Either he could have deposited that keys before the trial court.
No, see, his contention is he wants to vacate the premises.
Yes.
He can vacate only if you return that.
Yes. I am ready. I was ready.
No, that I will settle now.
Yes.
All this day, from the day he wants to vacate, but you are not ready to pay that deposited amount. Now, whether you can claim for any arrears is the question. Now, see, he is ready. You are sued for an eviction.
Yes.
He is ready to vacate. What is the deposit amount you have deposited?
He is not ready to vacate, my lord.
1 crore.
You are ready to give it back. 1 crore or disputing that deposit amount.
Deposit amount I have admitted.
Then give that, he will vacate.
I was ready. He never asked that money. He has filed a false affidavit written statement. He never sought that.
Sir, now we will settle. He is ready to give. You give that 1 crore. The advance.
After deducting the arrears of rent.
According to you, how much is the arrears?
Arrears as on the date of filing of the suit was rupees 63,75,000.
Or you were settling for 1 crore?
Yes, that's what I am ready.
No, as per the application, arrears from January 2020.
Yes.
Yes, January 2020.
January 2020 I asked him to refund the deposit in the month of March 2020.
No, even then you have utilized that premises.
Yes, sir. Insofar as that aspect is concerned, they are saying that 3,75,000 is a rent per month. As per the lease agreement, it's only 1 lakh. Even if it is calculated as 1 lakh, 5 years, it's around 60 lakhs.
That is what he is saying. 60 lakhs.
There are 2 agreements. There are 2 portions.
Sir, counsel, now you said that 60 lakhs is the due.
63 lakh, yes, my lord.
60, take it 60.
That is
Give it back that 40 lakhs. Take back the key. Close that case, mister. Why do you not
that is as on 20, my lord. 21, that is as on 21, not now.
From
Now we are in
January
25.
2020.
Then
Kindly-
we'll hear that matter.
Yes, yes, kindly see the reply sent by them.
We'll post
For-
it for B group, Mr.
For my notice,
Yes, this matter in B group. Service complete ಆಗಿದ್ಯಾ?
ಅವ್ರ ಮಾತ್ರ ಇಬ್ರೇ ಇರೋದು.
Yes, this matter in B group.
Kindly fix a date, my lord, next week.
Bharat.
Alla, next week, because if we vacate the premises, it is very
If
difficult
he
for
is
me to
ready to
recover.
vacate,
Let him pay
But
the
let him-
balance. my lord.
even
Oh,
for
he is a very clever man, my lord. He is not ready to
No,
vacate
Mr.
the premises.
said, deduct 60 lakhs, give it back that 40 lakhs and settle. If you want that premises, why do you want to drag this matter, Mr.?
No, now it comes more than 1.5 crores, my lord.
Then we'll decide. That I have to.
Hello,
I'll-
because why I am
Yes,
saying, no, he is very clever. That's why he has mentioned in the written statement like that.
No, I am not saying that you are not entitled. Matter requires to be hearing. We'll post it for B group. Yes.
Kindly fix a date, my lord, because the
This matter in B group of 2 weeks. Yes.
serial number 2 adjourn, serial number 3
date may be
Bharat,
given.
Bharat.
ಅಲ್ಲ ಡೇಟ್ ಒಂದು ದಯವಿಟ್ಟು ಒಂದು ಡೇಟ್ ಒಂದು ಕೊಡಿ ಯಾವ್ದೇ ಆಯ್ತು ಡೇಟ್ ಒಂದು
I placed this matter on 11th February. Yes.
11th February.
Yes.
serial number 2 adjourn, serial number 3 Ajit PB.
Lords, in this I appear for the petitioner's matter.
Yes.
Lords, suit was filed, suit for eviction in the year 2003.
You are a plaintiff or a defendant?
I was a plaintiff, my lords.
Suit for?
Suit for eviction
Hmm.
in the year 2003. I and defendant mutually agreed and we entered into a compromise petition. That was filed in the year 2005, my lords. As per the terms of the compromise petition, my lords, the respondents were supposed to vacate the property by 31st March 2019.
Yes.
The compromise petition, my lords, I have produced in page number 17,
31st March 2019.
19. Even after my lords repeated requests made by me to the respondents, he did not vacate, my lords. So I was constrained to file execution petition, my lords. In the year 2021, my execution petition is in page number 36.
Yes. Now what has happened, Mr.?
My lords, what has happened? Now the respondent has filed the objector application, my lords, which is in page 41.
Respondent to who is the party to that compromise petition or is in a third party?
No, my lords, what has happened? Now this objector who has filed this application in my execution proceedings, for the defendant, he had represented in the OS,
Represented as what?
represented as the proprietor, my lords. Now,
He is claiming that he is in the possession as a proprietor of the company or individual.
now he says that he runs a partnership firm, my lords, represented by its partner Kantilal Chopra, the very same person who represented the defendant.
Now what has happened this application?
Now this application, my lords, from the date 24/11/2022, my lords, orders have not been passed, my lords. Kindly come to page 57, my lords.
57.
57.
Hmm.
24/11/2022.
Hmm.
My lords, I have also produced the
The voucher related.
typed
to
copy.
Office check, put up the deposit amount. Advocate for the present counsel for the objector files a adjournment application.
typed copy is at page 69, my lords.
This is taken today, vote on the application filed by the council for they are so on. Now, what is that you are challenging in this petition?
My lords, I am only seeking directions, my lords, to the trial court to pass orders on IA.
Sectors in accordance with law within time bound of manner annexed D. Present Judge Bangalore to pass an order to release that amount deposited by the judgment debtor. Now, we'll directed you to dispose of that application.
Is-
IA, where is that IA?
My lords, IA is at page 41. My lords, and
41.
41, my lords, and they have deposit,
Statement of objection filed by that objector. Yes.
it's one and the same, my lords. They name it as statement of objections come.
It's
Objector
a
application.
Objector application. Yes, we'll dispose of, directed him to.
Please, my lords,
Now,
my
what is
lords,
the next
and
date?
one more submission. What has happened, my lords? Monthly, they have been depositing the rental arrears. My lords, they have filed a memo stating that the petitioners are not the legal heirs. Legal heirs of one, my mother.
If you want to release that amount, you file a necessary application there, you take an order, then you have to challenge. I can't decide here, Mr.
Please.
Yes, only you can direct that objector's application may be disposed of as expeditiously as possible. When his application has been filed. What is the date of application? 2022.
2022, my lords.
As on today, nothing has been happened.
Nothing has been happened. 21/2/2022.
Sorry.
Plus one submission. A time bound manner, my lords. Some time limit.
Yes, we'll fix 6 months. Because the evidence is required and all, let them do it.
Simply they are dragging on, my lords. I am not even entitled to get the rental arrears deposited by.
For that, you have any remedy, you file an
I'll-
application.
I'll file, my lords.
Yes. This petition is filed by degree holder under Article 227 of Constitution of India, seeking directions from this court to dispose of the IA-1 filed by the objector, respondent number 2 herein,
Respondent number 2, my
2 herein, in execution number 1314 of 2021. Petitioner is a degree holder in OS number. Which is that OS in the execution?
OS number 444 of 2003.
OS number ಎಲ್ಲಿದೆ?
Lords, I have not produced OS, but
OS number
444 of 2003.
444 of
2003.
2003.
3.
Ala, what is that suit for?
Suit for eviction.
Eviction. The petitioner is the judgment debtor. He has filed OS number 444 2003 for suit for
Eviction.
eviction. The said suit was been disposed of by compromise between the parties dated
16/4/2005. Compromise petition dated 16/4/2005.
16/4/2005. Since the other party has not complied that compromise condition in the compromise petition, the petitioner judgment debtor has filed this execution petition in execution number 1314 of 2021 before 25th Additional City Civil and Session Judge, Bangalore. The respondent herein has filed IA number 1 as a objector under Order 21, Rule 97 of CPC on 21st/2/2022. As on today, the no order has been passed on IA filed by the second respondent objector. Therefore, the petitioner is before this court. So and so learned counsel appearing for the petitioner contended that even though objector has filed an application on 21st/2/2022, even today application is not disposed of. One or the other reason, the objector is taking the time. He is seeking only a direction from this court to dispose of that application as expeditiously as possible in accordance with law. In view of the relief sought by the petitioner, thus issuing notice to the respondent is not necessary. Since objector has filed an application under Order 21, Rule 97 in the execution petition 1314 of 2021 on 21st/2/2022. As on today, that application is not disposed of. Under these circumstances and in the interest of justice, I am of the opinion that the writ petition can be disposed of, directing the executing court to dispose of that application in accordance with law. Accordingly, the writ petition is disposed of. The executing court, the 25th Additional City Civil and Session Judge is directed to dispose of that IA number 1 filed by the second respondent objector under Order 21 Rule 97 of CPC in execution petition 1314 of 2021 in accordance with law, after giving an upper to both the parties as expeditiously as possible, not later than 6 months from date of receipt of copy of this order.
Lords, may I request for 3 months? May I request for 3 months? Because
No, see, execution, the objectors, if we raise so many issues, all that issues can be considered by that
no,
executing court as in a suit.
the court has already heard both of us. Now only it has posted for orders
The-
from
Only for that orders.
orders.
You could have said that, yes, when it is posted for orders.
My lords, from 24/11/2022, from then it is posted for orders. Meanwhile, he had filed one memo stating that petitioners are not the legal heirs of one Farida Begum.
Our contention filed on so and so, matter was heard, reserved for orders,
Reserved for orders.
and court has not passed any order. In view of the above, so and so, disposed of, directing the trial court to pass an order in accordance with law, after giving an opportunity, in accordance with law, as expeditiously as possible, not later than 3 months from date of receipt.
Is my lords, and petitioners are the decree holders. My lords had stated that they are the judgment debtors. They are the decree holders.
Yes.
Serial number 4,
Correct.
VB Shivakumar for petitioner, Shivashankar K.
Yes.
Not a,
For the respond number 194.
for partition
Yes.
by the daughters against the father.
Yes.
But the suit, in the suit, the property is impleaded as is brought as item number 4. The petitioner got the property by virtue of a gift deed executed in his favor by his brother. Because there was an earlier partition between the brothers. The brother's share was gifted to the petitioner. Petitioner wanted to put up construction on the property. He filed an application under 151 seeking leave of the court to permit him to put up construction on the property at his cost. But that application is dismissed by the trial court.
Where is that order?
Order, the order is
No,
At-
if there is an earlier partition, then why that one more petition?
no, daughters are claiming partition against the father's property, where property has been divided and
No, where is
father has got the share in the property.
See, now you are that brother or an uncle?
Father, my lords.
I am the father.
You are the father.
Father.
No,
I want
there
to put up
There was a partition among the brothers
This is the suit for partition by the daughter against the father.
for your family members has filed in a suit.
Yes, ma'am.
Yes. Now that there was a partition between you and your brother,
Yes.
now then why they have included that property in that? Which is,
That
different to
property
you.
is included despite having been given by a gift to the father. Reasons in the plaint have been said that this
Then
property.
other than that, you have some other property.
There are other properties also.
Small
One item is included.
The partition, it was mentioned that it has been going to the share of your brother,
Yes,
earlier partition.
yes,
Thereafter, he has gifted to you.
yes.
Yes, mister.
No, my
I'll put
lords.
up
So,
construction.
let him put a as on today, admittedly, he is in the possession.
No, my lords, not in possession. My lords, actually,
Then-
my lords, the father, first defendant, my lords, petitioner is the defendant number 1 before the trial court. My lords, he had 2 wives. First wife had 2 daughters, my lords, they are the plaintiffs before this, my lords, before the trial court. My lords, second wife had 7 children. My lords, totally small extents of lands, my lords, all the suit schedule 4 items are, my lords, a small extents of land. My lords, if the properties have been divided among them, my lords, it comes to small extents of land. Now, my lords, the petitioner has suppressed the fact that already there was a partition among the defendant number 1 to 9. This property, my lords, the registered partition was affected among the second wife children. He has not affected, my lords, he has not given any share to the first wife children, that is the plaintiffs. My lords, this property, that is the now he wants to put up the construction. Already, my lords, this property given to the defendant number 3 and 9. That fact has been, my lords, registered partition. We have already.
For the defendant number 3 and 9.
Yes, my lords, 3 and 9. That fact has been suppressed. No, moreover, my lords, this property, it is not the self-acquired property of the petitioner. Earlier in the partition which was affected among the first dependent and his brothers, this only small extent, that is 7 guntas of land has been allotted to his share. Subsequently, my lords, with the understanding to execute the minute to avoid the execution of the said date, my lords, the gift deeds has been executed, interchanged among the two brothers.
See, totally what is the extent of the property available for the giant family with the brothers of that?
But it's earlier in the partition which
That
was
may not
effected in
be
the year
necessary,
1998. But this property survey number, let's two, the item number.
I want, what is that extent of the property which is available for the partition, first partition, Mr.
Now only 7 guttas.
Right.
Only 7 guttas.
But 7 guntas are.
Yeah, how many brothers are there in that?
But those brothers have already divided
Hmm.
out of all those properties. Now turn to the plaint. Madam.
No, see, in the partition, what is the extent is allotted to you in the first partition?
7 guttas.
Right?
7 guntas.
7 guntas. Now that is the only a 7 guntas, now it is under dispute. Which is the property which is gifted?
But the property that is gifted is item number 4, which is, kindly turn to the plaint at page 56. Page 56. Madam, Lakshmamma and Aarti are the plaintiffs.
Hmm.
Then Jairamma is the first defendant,
Yes.
who is the petitioner before the court.
Hmm.
The
Now what are
wife-
the suit scheduled property?
suit schedule properties which are incorporated are item 1.
What
1
total
acre,
extent
3
ಎಷ್ಟು ಬರುತ್ತೆ?
These are available, my lord. 1, 2, 3 are available.
See,
Item number 4,
item
I
number 4
intend
is
to
the
put
seven-
up a construction.
No, item number 4, which is the 7 guntas which is allotted to you in that?
But those aspects are not a question that is required to
No,
be.
no, I want to know which is the 7 guntas which is allotted to you in that partition.
Not to me, my lord. My brother Ganeshappa has been given property
No,
in the
you-
partition.
No, see, first gifted by your brother, you forget.
Yes,
As usual, in the partition, what is the extent you have got? Because they have any rights over only that portions of the property
Lord,
which you have inherited by the partition.
that is not their case, my lord. That's not their case.
No, I want to know that what is the extent which is allotted to you in the partition? That is the property which is available for the partition among the family members.
To me, what
Other
is,
than that, if you get by gift or anything, they are not entitled. For that, we can say that. For
Yes.
that, I want to know that.
all other properties are my self-acquired property for which the suit for partition is filed.
No, I want to
7
know
guntas of
where is
land.
that first partition deed?
I'll produce it.
To produce that.
Yes.
Yes.
My lords may have it on Monday, my lord. I'll make it.
But
up.
already issues have been framed. All are family members. There are no purchasers. Lords, if the trial court notes now we are ready to lead evidence. Within 3 months, notes the case will be
Will
disposed.
directed to dispose of the suit itself.
Within
That
already
my
we are, notes,
building
issues have been
material.
framed.
My building material is lying
No.
there. And I have taken a plan, I have taken a permission. If I have to put up construction, all that is a loss. Whether the plaintiffs are going to compensate that
That
loss.
we'll see. Then
Yes.
we'll.
All
produce
Lords,
it.
residential house is there. Only to, Lords, harass this first
No,
wife
no, no,
daughter.
no. See, we'll see that. You also produce that materials to show that you have already purchased that materials.
Not purchased, my lord. This property, brother is
No, no, not
ancestral. It is
purchased.
also an ancestral property.
No material he has purchased for construction
Yes.
of the house. Either I will permit him or I will say that if you fails, you have to pay that loss cost. to
I
him.
will also
But
produce
going
the
to-
photographs. He has already a residential house. Let's only has to, let's this harass this first wife children. Let's this,
No, no, no,
this
I'm not-
one are, let's similar
But if-
application.
If the
Let's-
father wants to
Well,
improve the property, how
Finding
does
of
he
the-
get?
let's
affected?
finding of the trial court, a
No,
similar
Mr.
application has already been
I'm
discussed.
not deciding that rights of the properties for present construction, if you are objecting, even though he has no right for then claiming any equity, if you are objecting, yes, I will not allow him to construct. But if there is any loss cost to you, in case if he fails, you have to
Yes,
compensate.
definitely, let's.
That has to be-
But I'll
that we'll
place
see
the document on file.
next week.
Bill number 5, Srikanth MP.
Lord's suit for declaration and injunction insofar as a society is concerned. Lord's, while leading the evidence, my lords, an application was made seeking for a direction to the Registrar of Society, my lords, to produce the documents. In fact, my lord, those documents we made application, the Right to Information Act not provided. We made several efforts not provided. Hence, we made an application, my lords, before the court.
Suit for,
Not declaration that, my lord, the committee or which claims to be the, my lord, the office bearers are not the genuine office bearers and they are not the genuine members except a few of them. My
then
lord,
why you have made that register as a party?
my lord, before the registrar, my lords, the returns are filed and it is accepted by the registrar,
Hmm.
which we have challenged.
Hmm.
As such, my lord, the registrar is a party.
Challenging that acceptance under section 13.
No, no,
11
suit
and-
was, yes, in the trial court, my lord, yes.
Yes.
After 2013, my lords, they are filing, my lords, every year the list of office bearers. We said it is not generally constituted, my lords, we had to produce.
What is your application?
My lord,
Where is the order which is passed by the trial?
Your lords may have a look at, my lords, page number 290, it starts with, my lord, 291. My lord,
No, order passed by the trial court.
that is right, my lord, 291, my lords, it starts, and relevant, my lords, at 292, last paragraph.
Yes. What is that order?
My lords, on perusal of the order sheet, this application is filed when the case was posted for further marking of the document. Admittedly, this suit is for declaration that the acceptance of the list of office bearers by the first defendant submitted by the third defendant for the years 2001 to 13 and audited accounts for the year 2001 to 2011-12 as illegal, improper and void, and for other declarations as consequential risks as played in the plaint. As per the pleading itself, prior to the filing of this suit, there are a number of cases led by the plaintiffs and some of the defendants. They are mentioned as so-and-so, 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 which were filed by the other members. In paragraph number 15 of the plaint, it is narrated about the challenging of order dated 4/10/2012, through writ petition before the Honorable High Court. On the face of record, there are a number of litigations between plaintiff and defendants before different courts and the Honorable High Court of Karnataka. And on 7/11/2022, the learned counsel for the plaintiff submitted the proceedings are pending before the Honorable High Court of Karnataka and prayed time to produce the documents to show such pendency on the next date of hearing, but yet to be produced. Plaintiffs have already produced number of documents. As stated by the plaintiffs in the affidavit that they filed application to RT for getting the copies of proposed documents prior to filing of the application. But this is the year 2023. Till the date, the plaintiffs have not taken any pain to produce the said documents in copies. As a general rule, such registered documents are public documents. Anyone can obtain the certified copies. Here, plaintiffs are not made of proper reasons as to why they are not able to produce the same in copies. It is the case of the plaintiffs that they have to produce the documents to prove their case, and the proposed authorities in the application to be directed to produce documents are officers of respondent 1 and 2. Their stage begin only after conclusion of plaintiff's evidence. Therefore, the plaintiffs are not made out any grounds to allow the application.
No, that they said only after that your evidence they'll be produced.
My lord, that is by the defendants, my lord, that's court says. But for me to produce, my lord, the documents, I should be given copies of that. My specific case is I'm not given a copy in spite of me making an application.
What are the copies you are required for?
My lord, it so happened, my lords, I may permitted to pass on, my lords, the copy of the application. After
What has happened in that Right to Information Act?
No, nothing has been done.
Have you filed an appeal?
My lords, unfortunately, my lords, it is not done. That is.
See, speedy remedy which has been made.
Your lordship may appreciate, my lords, it cannot be, my lords, though it is a remedy, my lords, which is provided.
Time limit has also been fixed. If they have not done it, they are
Lord,
entitled for imposing.
My lords, I bowed on, my lords, I could definitely have done, my lords, that. But fact remains that, my lord, the application was made in the year 2017. And, my lords, till the adducing of evidence, my lord, it was not provided, saying that my lords, the officers have shifted. My lords, if they give me copies, my lords, I will produce it as further evidence.
What are the documents you are required to?
My lords, a list of office bearers from 2013-14 till date, audited accounts, and the acknowledgement which has been issued, and all other documents which have been filed.
It's available public documents, you can give it.
If they give it also, my lords, that would serve my purpose.
You take notice. Government advocate is directed to take notice for respondent number.
One, my lords, 1 and 2.
1 and 2. Issue emergent notice to respondent number.
Other
respondents.
I'll take my lords notice on the counsel who is appearing before the trial.
Petitioner is also permitted to take out, permitted to serve a copy on the counsel appearing for the respondent before the trial.
Please.
Serial number 6, Ambarish again.
For the petitioner in this case, Mala, seeking direction to the trial court to dispose of the main suit within a time frame, Mala.
Where is
suit is for declaration and injunction, Mala. The matter is set down for declaration and injunction, Mala. The suit is now set down for evidence, Mala. The defendants, one or the other reasons, they are deliberately.
You are the plaintiff?
Yes, Mala, before the trial court, Mala.
Suit for?
Declaration and injunction, Mala.
Declaration and injunction.
Yes, Mala.
Now, what is the stage?
For a cross-examination period blown, Mala.
Cross-examination of PW.
One, my lord, the plaintiff, PW1. Since from 23, they are taking adjournments, so one or the other is.
You have to they are not cross-examine that.
Yes, my lord. Yes.
Yes. Kali. The only prior sought in this writ petition is seeking direction to the trial court to dispose of the suit. ಎಲ್ಲಿದೆ ನಿಮ್ದು prayer?
My lord, prayer to
Dispose of the suit
1 to the
for 1,200 2016
before third additional senior civil judge.
pending in the file of third additional senior civil judge Bangalore
Yes, my lord.
as expeditiously as possible. In view of the above prior, service of notice to the respondent is not
Yes.
necessary. The plaintiff has filed a suit for declaration
Yes, my lord.
in OS number 1200 of 2016 before third additional senior civil judge Bangalore rural district. And that chief examination of the plaintiff evidence has completed.
Completed.
Even though suit is filed in the year 2016, the same is not disposed of. Therefore, the petitioner is before this court. Learned counsel appearing for the petitioner submitted that evidence chief examination of the petitioner side is over. Respondents is not cross-examined the PW1. One or the other reason, respondent defendant is taking the time and dragging the matter. Since matter is of year 2016, suit is of year 2016, we pray for early disposal. In view of the above, without expressing any opinion on the merit of the case, the above writ petition is disposed of, directing the trial court to dispose of OS number 1200 of 2016, pending in the file of third additional senior civil judge Bangalore rural district as expeditiously as possible, not later than 6 months from date of receipt of the copy of this order, as possible in accordance with law.
Correct.
Yes.
Serial number 7, Akshata Shetty K.
For the petitioner, my lord.
Yes.
Petitioners are the plaintiff before the trial court, my lord, and my suit is for possession and injunction. My-
Serial number 7, sir.
My contention in the suit is that the defendant has encroached upon the portion of Schedule A property.
Suit for?
Suit for possession and injunction.
Yes.
I said they have encroached upon portion of my property. My chief examination has been conducted and during my evidence, it is for my evidence stage. I have filed application for appointment of commissioner. The honorable court has kept this application in abeyance, stating that let the evidence of both the parties get concluded. After that, court will decide upon it. Why I have filed this application is to ascertain the boundaries and the encroachment and also the illegal construction put upon the encroached
What's that? See, after the evidence, if court feels that still court requires some more evidence to find out that point, then see appointment of the commissioner is for the benefit of the court.
Yes.
Court can appoint. Your application is not rejected. See, if the parties to able to make out any case by evidence itself, then commissioner appointment is not necessary. Therefore, they said after completion of the evidence, they will appoint if it is
found it-
required.
Yes, my lord, I found it
See,
difficult.
now you are not in position to prove your case. You want to collect the evidence by appointing that commissioner. That is what that you are doing now.
For assertion of boundaries are concerned, my lord, because I have tried, before filing this suit, I have tried thrice for joint survey. The defendant has not came forward for that. He has not cooperated. Now through oral evidence, it is difficult for me to, these ascertainment of boundaries are concerned. Hence, it is very much necessary for
No,
appointing.
therefore,
It is,
see,
it will be a part of my evidence, the report of the commissioner, and he can be examined.
the
So,
report of the commissioner, it's not in a part of the evidence. It is for that court to ascertain that facts. It cannot be taken as a part of the evidence to, supporting your case. The appointment of the commissioner is not for a collecting of that evidence. It is for the court for an ascertaining the true fact. This cannot be any evidence of the parties. You take notice? Yes, issue notice.
Serial number 8 adjourned. Serial number 9, Punit C for petitioner, YK Narayana Sharma.
Here for the petition, Lord.
Hmm.
Lord, it is stated that petitioner number 1 is dead, my lord, on 13/11. I'll make necessary application for that effect.
Yes, learned counsel for the petitioner submits that petitioner number 1 is that he wants to file necessary application to bring LRs of deceased petitioner number 1.
Please, my lord.
And she prays 2 weeks time.
One week time will go.
1 week, yes.
Date may be fixed, my lord. So that-
File madre, application file madake the mention date, yes.
Problem.
Number 10, 11 adjourned. Serial number 12, George Anthony Cruz. Serial number 12.
Yes. Yes, Mr.
I only seek a reasonable intervention in this matter. The compromise petition went before Supreme Court. Supreme Court have decided, we both parties have agreed. Agreed to the extent, my lord, annexure, Lordship annexure D. The proceeding before the Honorable Supreme Court by way of mediation is, in the event of sale of land, some amount of 1,76 crore to pay, or the completion of trade development rights. The TDR proceeding is very much pending before this court. It is nearing the finalization. In meantime, the respondent treated me as if I am the judgment debtor, filed an execution petition. I made a very fair submission before the Honorable Execution Court. I am not opposing the execution. The only my apprehension is, in the prior, detention in civil prison is also the prior of the decree holder. That should be avoided. I only prayed before the court to keep this matter for abeyance for some reasonable time.
Why?
Because TDR has to be issued by the BDA.
What is the settlement compromise?
And my lord, that's why the settlement is, Lordship kindly see, the settlement entered into before the Honorable Supreme Court. Annexure, Lordship kindly see annexure D
Page.
at page 59, para 2. May I read, my lord? Only few lines.
Yes.
It is mutually agreed between the parties that the amount derived by Srimati Jayama, who is a petitioner here, that is respondent 1 in civil appeal, either by way of sale proceed or TDR proceeding, or after the disposal of the property, is hereby undertaken by her, that amount shall be remitted to the State Bank of India, mayor, it so and so amount according to the name in person. My submission, my lord.
It is mutually agreed between
Yes.
the parties that
Yes, my
amount
lord.
derived by that Sri Jayamma, respondent number, either by way of the sale proceedings or TDR proceedings after disposal of her property, is hereby undertaken
Yes,
by
my
her. That amount shall be, there is no time limit for that.
No time limit. My meantime, my lordship kindly take.
Now, what is the steps you have taken?
My steps is taken. I am pursuing the TDR, issuance of the TDR.
By this land is acquired by the,
Land is acquired. I have also produced the document annexed.
TDR is not issued.
No,
Now, what is that order you are challenging here?
no, the order is that the order, I filed an application before the Land Execution Court. Since the matter of issuance of TDR is very much pending, kindly keep this matter in abeyance for some time, which the IA was rejected. That IA, I am seeking the intervention of
No,
this.
you can't seek for an abeyance. You can seek
Yes.
for a dismissal because
Yes, my lord.
it cannot be enforced.
Yes, my lord.
Because the
That's
time
what-
limit is not there. Instead of that, you can ask the court to kept in abeyance. How
Yes,
can you?
my lord.
It is for the court to decide. You
Decide.
can't say that
Yes, my lord. To that extent.
your prayer is not proper.
Yes, but that's why, my lord, the only thing is, either I have to file an application before this honorable court, the stage of TDR issuance of the TDR.
Now, where is that order of the trial court which is challenged before this?
Under of the trial, annexure L, my lord.
Annexure,
Annexure L at page,
page,
annexure L. Order at page 128, page number. Ink page number 128. Orders on IA number 1 of 2024.
128, 128.
Yes, my lord.
128 ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಆನ್ IN number 1 of 2024 page number 128 page number
Page number
128 by the 128
128 ಅಲ್ಲಿ ಇಲ್ಲ ಅಲ್ರಿ 128 ಅಲ್ಲಿ ಏನೋ ವೆರಿಫಿಕೇಶನ್ ಅಫಿಡವಿಟ್ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಇದರಲ್ಲಿ 127 ನಲ್ಲಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಫ್ರಮ್ ದ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಅದರಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದೀನಿ page 127
Page which is given to me
Yes, ma'am.
128
Yes.
is an affidavit filed by objection filed by that respondent.
I'll show. Maybe some paginess in the type.
ಆಯ್ತ್ರಿ ನೀವು ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಹೇಳ್ರಿ ನೀವು ಕೊಟ್ಟಿರೋದು ಯಾವ್ದೋ ಪೇಜ್ ನಮ್ ಫೈಲ್ ಕೊಟ್ರೆ. See that pagination is not there.
I'll correct.
Yes, it is page 132 in my this thing.
Right.
Yes, what is that order now?
Yes, sir. That order is my lord. Thank you. I make permission. My lord, the instant application has been filed by the judgment debtor under section 151, requesting the court to keep the.
What is the stage in that execution petition?
This is pending.
They are not, you take
Not
notice?
mentioned.
Yes. Emergent notice.
Much.
Cell number 13, Jagdish DC.
No, ಯಾರೋ ಕೇವೇಟರ್ ಇದಾರಲ್ಲ, ಯಾರಿಗೆ ಅವರು?
I'm not there.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಕೇವೇಟರ್, ಲಾಸ್ಟ್ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್.
Not.
Cell number 13, Jagdish DC.
For petitioner. The petitioner is a judgment debtor, for the decree holder, that is the respondent herein filed a suit for possession. That came to be declared after contest and also in area confirmed. Thereafter, the decree holder has filed the execution case. In the executing court, without considering the objection raised by these petitioners, has ordered for issue of delivery warrant. The suit.
What is that objection? When that there is a
Objection
degree-
is the government land. It is not granted to either to the decree holder or to the judges. We are joint family members. The judgmenters are in possession. They have also spent money to construct the house.
No.
Application is pending for.
No, all that has been decided in that suit. Now that execution court cannot be,
But-
see, when you failed in, contending that contention before that degree, now you can't take that, it is not again one more suit. Mr.
All those contents are taken.
I thought taken, if it is
survey
not
number-
considered properly, remedy is to appeal. Appeal is filed.
Delivery warrant issue ಮಾಡಿ. I mean, I have spent money.
ಅಲ್ರಿ ಡಿಗ್ರಿ ಫಾರ್ ಪೊಸಿಷನ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಪೊಸಿಷನ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಇನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ ಡೆಲಿವರಿ ವಾರಂಟ್ ಇಲ್ದ ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ?
ಇದು ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್. ಸರ್ವೆ ನಂಬರ್ 15 is government 46 acres ಇದೆ. ಸರ್ವೆ ಆಗಿಲ್ಲ.
That is all be decided in the suit, not in the execution court. Mr.
I have filed my
If
objection.
you are not a party, if you are an objector, then this is a different thing. You are in a party in the suit, you have raised all the objections, court has considered degree, the appeal is.
In the execution, but ಸರ್ವೆ ಆಗಿಲ್ಲ ಅದು. ಹೋಡಿ ಆಗ್ಬೇಕು. Identification ಮಾಡಕ್ಕಾಗಲ್ಲ. It cannot be executed. I am in person, I have spent money and the decree holder is also my family members. We are all.
You are in that possession, but there is a degree for a possession. Why do you worry for measurement and all? He will do it. Is it your case that
It cannot be
other than
executed.
that, any other properties is also there?
But I am there. I have put up the building. I am residing there without holding any inquiry. Simply issued order delivery warrant.
Suit for
Can I
possession,
see the annex?
suit for possession file ಮಾಡದೆ ಅದಕ್ಕೆ other side position ಅಲ್ಲಿ ಇದ್ದಾರೆ.
Owner ಅಲ್ಲ. First of all, government is the owner. Government has not been made as party. My application is
Mr.
pending for the
Counsel,
committee.
All that is in the suit, it has to be decided. Mr.
ಅದೆಲ್ಲ contention ತಗೊಂಡಿಲ್ಲ. ತಗೊಂಡಿದ್ರು consider ಮಾಡಿಲ್ಲ. Here in the
ಅದಕ್ಕೆ ನಾನೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಹೇಳಿ? I am not deciding on the appeal.
in the execution case, I have filed my detailed objection containing that survey number 15 is the government land is measuring 46 acres. There is no survey
ಡಿಗ್ರಿ
conducted.
ಪಾಸ್ ಆಗಿತ್ತಲ್ಲ ಏನ್ ಮಾಡ್ತೀರಾ? ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡಿಗೆ ಇಟ್ ಇಸ್ ಫಾರ್ ದ ಗವರ್ಮೆಂಟ್.
ಅವರು ಯಾರು ಬಂದಿಲ್ಲ.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ನಾವೇನ್ ಡಿಸೈಡ್ ಇದನ್ನ ಅಪೀಲ ನಾನು ವೆದರ್ ಇಟ್ಸ್ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಅಂಡ್ ಆಲ್.
Decree holder and also judgment are all joint family members.
ಟೇಕ್ ನೋಟಿಸ್ ಸರ್.
But now there is delivery warrant ಗೆ order ಆಗಿದೆ. I am
ಏನ್
there.
ಮಾಡ್ತಾರೆ? ಡಿಗ್ರಿ ತಗೊಂಡ್ಬಿಟ್ಟು ಪೊಸಿಷನ್ ಕೊಡ್ಲಿಲ್ಲ
ಅಲ್ಲ,
ಅಂತ
once for all order without holding any inquiry, order for issue of delivery warrant.
ಇನ್ನೇನ್ ಡಿಗ್ರಿ ಆದ್ಮೇಲೆ ಇನ್ನೇಂತ
ಅಲ್ಲ,
ನೋಟಿಸ್?
enquiry ಯಾರು ಮಾಡ್ಬೇಕಲ್ಲ, who is in person, that can be executed or not decree, because government land, there is no survey conducted and identification ಆಗಿಲ್ಲ. Property.
Don't make that it's a government land. The defense is available when the suit is filed. Suit is decreed. I am not deciding that appeal to say that whether it's a government land or not, Mr.
ಅಲ್ಲ,
Is there any exception for execution if this is a government land? Execution is only to execute the degree.
ಡಿಗ್ರಿ order grant ಆಗಿಲ್ಲ. ನಾನಿದ್ದೀನಿ ಅಲ್ಲಿ. ನಾನು ಮನೆ ಕಟ್ಟಿರೋದು. I was 15 lakhs ಖರ್ಚು ಮಾಡಿ ಕಟ್ಟಿದ್ದು.
No,
ನಮ್ಮ
you are not-
application ಇದೆ. To grant ಮಾಡಿ ಅಂತ
No,
ಪೆಂಡಿಂಗ್ ಇದೆ.
You are not a judgment debtor.
Judgment letter ನಾವೇ.
ಮತ್ತೆ?
Judgment letter.
ಮತ್ತೆ?
Ah,
If
my
there is a
application-
third party objector, then matter has to be heard.
But here, I raised the contention that survey ಆಗಿಲ್ಲ, ಕೋಡಿ ಆಗಿಲ್ಲ, identification ಮಾಡಕ್ಕಷ್ಟೇ without conducting survey, sketch ಆಗಿಲ್ಲ.
And summons, we'll have it next week, yes.
ಅಲ್ಲ ಅಲ್ಲವರೆಗೂ ಮತ್ತೆ and ಅವ್ರ ಪ್ರೊಸೆಸ್ ಫೀ ಕಟ್ಬಿಟ್ರೆ they will court will
There is
issue
that,
delivery
what
warrant.
is for execute this thing?
Annexure C is the order, lottery operative portion of the order, can you see, in phase 30. Issue delivery warrant against the judgment letter, to deliver the property mentioned in the decree to the decree holder if PF is paid. A process be cut in, taxation order, they will execute they will throw out from my house. Both are joint family members.
No,
But
we are
all,
not concerned all this.
decree order he has
There
no
is a
exclusive
degree.
right.
You are not challenging that. What to do? Where is that order?
Order annexure C is the order. Order
Objector
positive.
filed by that, objection filed by the debtor so and so are found to be untenable, non-law. Issue delivery warrant against the judgment debtor under so and so. PF is to be paid.
ಇದ್ರ ಬಗ್ಗೆ ಎನ್ಕ್ವೈರಿ ಹಾಕ್ಬೇಕು. Directly order into issue delivery warrant.
Issue emergency notice. Stay of
Annexure C.
further proceedings in execution number 9 of 2023 till next date of hearing.
Please,
Issue emergency notice.
Please.
Yes.
Serial number 14, Radhika K.
Yes.
Serial number 14, Radhika K.
Yes. None appear. Use this matter of 2 weeks.
Serial number 15, passed over. Serial number 16, adjourned. Serial number 17, Chandrachud A.
15 act pass over. Yes.
Serial number 17, Chandrachud.
Lords, appear for the petition, kindly pass over.
Serial number
17.
17 next week.
My lords,
Pass over
urgency
may
is,
not be reached today.
no, my lords, urgency is there, my lords.
Yes, pass over. If it is reached, it is your this thing. Yes.
Serial number 18, Chandrasekhar P. Patil.
I am for petitioner in this case, my lord. The impleading application filed by the petitioner is rejected on the ground that the genealogical family tree does not show his father, the grandfather's name, my lord.
Shoot,
Your lord,
shoot for.
It is a LAC case, my lord. The land was acquired and I have filed a suit for partition and separate position. The said suit is pending. Since there is a dispute in respect of genealogical family tree, the KHB has not distributed the amount and it is deposited before the civil court under LAC number, in which, my lord, I have filed application for impleading.
No, that, what is the relationship between you and the claimants?
The claimants, my lord, as one of the legal heirs, my lord, have sold the property in favor of Doddabere, who is respondent number 1, who is claiming the compensation, for which we are objecting that we have also share in the property. And in OS also, he is a party. Even KHB also made as a party. Now it is rejected only on the ground that, my lord, the land does not belongs to Timrayappa. In fact, I have filed the document, my lord. Your lordship may kindly take page number 52, my lord. Page number 52.
Doddabere is claiming that he has purchased the
Purchase the property from one of the legal heirs of the Chennigaya.
Yes.
The court says that the
You take notice, yes.
and now the proceedings are continuing for exam.
What is the stage now?
Now examination of claimants, my lord.
Yes, stay of further proceedings in LAC number
15 of 22.
15 of
22.
22, pending in the file of second additional city civil and session judge. Which place?
Bangalore itself.
Bangalore.
Machu.
Emergent notice.
Serial number 19, Arjun Rao.
Lord, appear for the respondent. My lord, this is the commissioner matter from day before yesterday, my lord.
Yes.
Commissioner has given a report, my lord, before your lordships. Lordship may open it. What has happened is there has been, my lord, interference with the commissioner, my lord.
No, that we'll see. What is that information? How the police has seized that this thing? No, see, are they seized on the basis of the complaint? What are that? No, how they have seized that?
Judgment.
Now, what is that offense in that FIR? No, what is that offense? Is it that required for seizing of that this thing, Mr. Udayawala? What?
What is this? Two people are appearing today.
Seizure is not some other thing, legal investigation. Your options query on the last day was.
See, now,
Whether that is in.
now that we'll appoint one more commissioner. Now he will be conducted an investigation in the presence of both the parties.
Only difficulty would be, my lord, what happens?
No, because on issue, because he has not completed earlier.
Hmm.
Because some of them has been seized by the police. Some of them, they have not aware of that, they have obstructed under. Now that new commissioner will be conducted, in addition to that, what is already done, both the reports will be taken, then let the trial court to be disposed of that matter.
Only difficulty would be, my lord, if somebody, my lord, interferes with the commissioner, clear case of contempt. In fact, my lord, there are two judgments, one of the Supreme Court and one of the Bombay. Delhi.
But I have no dispute on that proposition. I have no dispute on that proposition.
Now that
Let us
I
see
have
there
to
is-
hear, wait. Then I have to hear, you file an application,
Yeah.
I have to hear
Yes, my lord.
whether they have obstructed,
We'll
whether there is any
very well.
violation.
I'll file.
Then we will
Yes,
see.
my lord. Yes, my lord.
Now, my lord, in the meanwhile, my lord,
Therefore, last occasion, what was the understanding is, forget about that, all this interference and all. We'll appoint one more commissioner. In addition to that, whatever left out, let him file an affidavit, report, that will be considered by the trial court and disposed of.
In that case, direct them also go.
That's what, see, it should be,
it's all seized in the police station.
now we'll see. See, even I will direct the police also to cooperate for any commissioner to examine. If
Yes.
there is anything, they have to be examined with that respondent's premises also, let them examine in the presence of the parties.
Yes.
Then submit a report,
Please, my lord.
report to the trial court, and trial court can dispose of why that matter has to be pending here now.
No, my lord, they will have to report back to this honorable court because this honorable.
What else you have to be done after that report is obtained?
Because, my lord, after the report is filed, because this is under order 26 rule 9. On last occasion, I made a submission that this is not an application maintainable under order 26 rule.
No, now,
I'm only saying that as a measure of, as an interim measure, my lord, if both parties can come to an agreement, let us appoint an independent third party person.
we'll do
We
it.
will go.
No. Now, their application for an Caesar has been dismissed by the trial court, therefore.
No, not dismissed. Notice is ordered.
Is ordered, therefore they are before this court.
Yes.
Now we are exercising that power and we have completed that. Let the trial court proceed further. Why we want to complete?
No, but on what should happen after the commissioner's report
First,
is.
let the commissioner submit a report before this court, then we'll see.
Yes. My lord, in the meanwhile, can I just point out, on last occasion, my lord asked a question, is this permissible under order 26 rule 9? Now kindly
No,
permit.
not under order 26 rule. 9.
26 rule 9 is the application.
Case of,
No, under, whether a commissioner can be appointed of this nature
no.
under 26
No,
rule.
what he has relied on the Delhi's court judgment.
Yes.
It is not under 26. See, in the case of that
lord,
intellectual properties matter.
All of which is considered by this court, my lord, by the Honorable Supreme Court. 3-judge bench of the Honorable Supreme Court has considered it.
Was a copy, please?
Yes, sir, definitely.
Thank you.
Kindly look at this judgment in the 1961 judgment of 3 judges of the Honorable Supreme Court.
Yes.
Kindly look at paragraph 2, my lord. Now, this was a case where the trial court ordered appointment of a commissioner for the purpose of going and seizing the books of accounts of the defendant on the ground that if he spend time, he will make interpolations and corrupt the books of accounts, and therefore you must appoint a commissioner. The trial judge appoints a commissioner. Now, the Honorable Supreme Court is called upon to consider whether the appointment under order of a commissioner, whether under order 26 rule 9, or my lord under section 75, or under order 38, or under order 39 rule 7, whether this can be done at all, is the question that came up for consideration before the Honorable Supreme Court. Kindly look at paragraph 2. One Gendamal, father of Shekhar Chand, appellant 2, sued Mitten Lal and others in the court of so-and-so for money on the basis of promissory notes executed by the defendant. Defendant apprehended that the plaintiff would fabricate his books with respect to payment made by them, applied for seizure of the books of accounts of the plaintiff. The additional munsif by his order dated 27th March 1954 appointed Sri so-and-so commissioner to seize the books of accounts, and the commissioner accordingly seized those books of accounts and brought them to Ghaziabad. Now, my lord, kindly skip this. Kindly go over to the next page, my lord. I'll read from the first line. My lord, in the previous paragraph line, it has been contended for the appellant that the appointment of Sri Raghuveer Prasad as commissioner was null and void, as the additional munsif had no power to appoint a commissioner for the purpose of seizing the accounts books of the plaintiff on an application made by the defendant. The power of a civil court to issue commissions being limited by the provisions of Section 75, Order 20, Rule 6 of the Civil Procedure Code, and the code having no inherent power to appoint a commissioner for any purpose mentioned in Section 75 and Order 26 of the code, etc. Now, this was a contention. Now, kindly look at paragraph 7. Section 75 of the code empowers the court to issue a commission subject to the conditions and limitations which may be prescribed, and for purposes for examining any person, for making a local investigation, for examining or adjusting accounts, or for making a partition. Order 26 lays down rules relating to the issue of commissions and allied matters. Mr. Chatterjee, learned counsel for the appellant, has submitted the power of the court must be found within the four corners of the code, and that when the code has expressly dealt with the subject matter of commissions in Section 75, the court cannot invoke its powers under Section 151 and thereby add to its powers. On the other hand, it is submitted for the state that the code is not exhaustive, and the court, in exercise of its inherent power, can adopt any procedure not prohibited by the code expressly or by necessary implication if the court considers it necessary for the ends of justice and to prevent abuse of process of the court. So this is the contention on the other side. Then Section 151. Section 151 of the code reads, nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary in the ends of justice or to prevent abuse of the process of the court. The inherent powers of the court are in addition to the powers specifically conferred on the court by the code. They are complementary to those powers, and therefore it must be held that the court is free to exercise them for the purpose mentioned in Section 151 when the exercise of the power is not in any way in conflict with what has been expressly provided in the code or against the intentions of the legislature. It is also well recognized that the inherent power is not to be exercised in a manner which will be contrary to or different from the procedure expressly provided in the code. The question of determination is whether the impugned order of additional munsif appointing so-and-so commissioner for seizing the plaintiff's books of accounts can be said to be an order which is passed by the court under section, by the court in exercise of its inherent power. The inherent powers saved by Section 151 of the code are with respect to procedure to be followed by the court in deciding the cause before it. These powers are not powers over the substantive rights which any litigant possesses. Specific powers have to be conferred on the court for passing such orders which would affect the rights of such party. Such powers cannot come within the scope of inherent power of the court in the matters of procedure, which powers have their source in the courts possessing all essential powers to regulate its practice and procedure. A party has full rights over its books of accounts. The court has no inherent power to forcibly seize its property. If it does so, it invades the private rights of a party. The specific procedure is laid down in the court for getting relevant documents or books in court for the purpose of using them as evidence. A party is free to produce such documents or books in support of its case as be relevant. A party can ask the help of the court to have produced in court by the other party such documents as it would likely to be used in evidence and are admitted by that party to be in its possession. If a party does not produce documents it is lawfully called upon to produce, the court has a power to penalize it in accordance with the provisions in the code. The court has the further power to draw any presumption against such party who does not produce relevant documents in its possession, especially after it has been summoned from it. Even in such cases where the court summons a document from a party, the court has not been given any power to get hold of the document forcibly from the possession of the defaulting party. The defendant has no right to these account books. They could not lay any claim to them. They applied for seizure of these books because they apprehended that the plaintiff might make such entries in those accounts books which would go against the case where they were setting up in court. The defendant's request really amounted to the courts collecting documentary evidence which the defendant considers to be in their favor at that point of time. It is no business of the court to collect evidence for a party, or even to protect the rival party from the evil consequences of making forged entries in those books, in those accounts books. If the plaintiff does forge entries and uses forged entries as evidence in the case, the defendant would have ample opportunity to dispute those entries and to prove them for forgeries. Then para 11. We are therefore of the opinion that the additional munsif had no inherent power to pass the order appointing the commissioner to seize the account books. The order appointing Raghubir so-and-so for this purpose was therefore an order passed without jurisdiction and therefore a null and void order. Then para 12. The learned counsel for the state, Mr. Mathur, has submitted that in the alternative, the impugned procedure adopted by the additional munsif comes within the certain provisions of the code and has referred to Order 38, Rule 5 of Order 38 and Rules 1B and 7 of Order 39 and the Rule 1 of Order 40 of the code. We do not agree with this contention. The impugned order has not passed under any of these provisions. It was clearly an order which the additional munsif purported to pass in exercise of inherent power. Now, can you look at para 13? They also discussed those other provisions. Further, the provisions of Order 5, Rule 5 of Order 38 are to prevent a decree that may be passed from being rendered infructuous. 1B of Order 39 is applicable when the defendant threatens to dispose of his property to defraud his creditors. None of these provisions has any application facts to the present case. Rule 7 of Order 39 empowers the court on application of a party to make an order for detention, preservation, and inspection of any property which is the subject matter of such suit or as to which any question may arise. The accounts books of the plaintiff were not property which were subject matter of the suit, or that about them a question could arise in the suit. The account books could at best have been piece of evidence, and if the plaintiff or the defendant had cared to rely on them, we would therefore hold that the additional munsif had no power under the code to appoint a commissioner for seizing the plaintiff's accounts books. Then, my lord, they go on to the question of whether it's a public servant, etc., because an allegation was made that there was some obstruction and public official was obstructed, etc. They said he is not even a public official because he's not properly constituted. So therefore, my lord, there is no power to collect evidence at this stage. Now, kindly look at this case. The plaintiff comes to court saying, these three people were working with me. They have left me and started some company of their own. There is no law in this country which says somebody who is working with them should not start another a company or run another company. Their contention, the entire premise is that, no, I had confidential information, which these people have taken away and they are using it in their business. Now, my lord, if I use it in my business, I will necessarily be selling, now in this case, it is drones. I will necessarily be selling drones with their technology to somebody else. The drones are available. I would have sold it to a third party, and third party will be no less than the armed forces of this country who will be using this. The court can always summon it and say, is it confidential information? Was this the drone, the same drone that these people were manufacturing? On the contrary, my lord, we are not even in the same space of drones. They make some other drones, we make some other drones. Now, all this they go to court saying, no, we did a forensic analysis, and in the forensic analysis of what? My lord, laptops were given to me when I was an employee of the company. That laptop has been duly returned to them. Now, in that laptop, they were able to access some drive. When I was working in that company, they had given me some file which is in that drive. When that file was accessed, etc., are not matters of the report at all. To say how it is part of it. Now, my lord, so this is the basis of, and the contention is, no, they are making drones. Now, if you don't go and seize all their drones, etc., we will not have evidence anymore. My lord, if they don't have evidence, how do they file the suit? There can't be a roving inquiry. And my lord, you can't file a suit and terrorize another person. The defendant can't be terrorized by saying, no, I will come to your office, shut it down. I will do all these various things. This is one. Then, my lord, second part of it. Now, my lord, if the plaintiff says something is confidential to them or something is proprietary to them, my lord, first and fundamental, my lord, for us to be able to compare whether I am using plaintiff's products, we should know what the plaintiff is using. Now, my lord, kindly see, neither in the suit, nor in the commissioner's report, nor in this writ petition, have they disclosed what according to them I am copying. What is it is there a software of theirs which I have copied? Is there a product of theirs I've copied? Is there a design of theirs which I have copied? The details must be forthcoming. Today, my lord, the court commissioner is being asked, kindly look at the order that was passed by this honorable court. This honorable court said, please go and find out Can you look at the order, my lord, of this honorable court, which is 6/12/24.
Yes.
This court said, can you look at paragraph 6 on that, my lord?
Yes.
In that view of the matter, court considers it appropriate to appoint a digital forensic expert as a court commissioner. Now, my lord, he's a digital forensic expert. That means he is person whose services are being sought for a digital forensics, nothing more. We'll see the report for what he's done otherwise. Now, digital forensic as the court commissioner to seize and drop an inventory as stated above. This is, however, subject to the condition that the commissioner appointed shall ensure that before seizing computers, laptops, servers, mobiles, external storage media, including hard disk, pen drives, networking equipment, smart devices, printed documents, packages and deliveries and other physical materials, care should be taken to ensure that they contain the proprietary information of the plaintiff. So what does he have to do? He has to make sure that my computer, my phones, my storage devices, or whatever it may be that he is looking at, has proprietary information of the plaintiff. Now, I pause here for a moment. Has this commissioner, one of the commissioner's report is before the court, has this commissioner even said that plaintiff has given me what is their proprietary information? What is he going to compare? My computer will have several, it will have figures of drones. Like in the report, he said, there are wires, there are drone pieces. Of course, I am manufacturer of drones. You will find wires in my premises. Wires will not make it, my wires are not proprietary to them. Simply because we find electrical cables, it does not mean that I am copying their product. The question is, they have to first give and disclose what is proprietary to them. Only then the comparison can be made. Now, on the contrary, my lord, as I pointed on the last occasion, after getting this order on 6th of December, because the object of this exercise is not to do any of these things. It is simply to shut me down. So what they do, on 6th, they obtain this order. When this honorable court very specifically says, my lord, I was not even here in this court. We were not even notice is not ordered even under this order. So they were the only parties in this court. Now, after having obtained this order, what do, my lord? They go and file a criminal. While the commissioner was supposed to execute the warrant on 20th onwards, he does not do so. He chooses to do it on the 25th.
That you have explained last
Yes.
session. Now, two things. We are not yet accepted that report, that will be there.
Yes.
If both are agreed, then I will appoint
Yes.
another commissioner.
Yes.
Whatever that condition already earlier court said that after intimating, if it is related,
Yes.
he can be submitted in a report.
Yes.
Then we will hear whether that earlier commissioner report is
Yes,
proper
yes.
in terms of that order, whether it can be accepted.
Yes.
Then we will decide. If they are both are agreed,
Yes.
I will appoint a commissioner.
Yes,
Or
my lord.
if
We are agreeable to that
arguing that
proposition.
there is no such power and all, then I will hear that.
Yes, my
I
lord.
think
My lord, we are agreeable to that
Absolutely
proposition.
no problem.
I may only add one more thing, my lord. But first, this petitioner should be called upon to first say what, according to them, is their proprietary information.
That is what that earlier court said, same.
But they have not done so. Till date, they have not done so.
That will be considered when you are accepting that report. If that
Allah.
accepting the report.
Allah, if he goes, kindly see what the situation now is. No, I am also a manufacturer
So
of drones.
therefore, we'll consider both of them. If both of them suggest the right person, therefore
Yes.
now this controversy will not arise because
Yes. Yes.
earlier only one side, after consulting that court has appointed.
Yes.
If both of them suggest that person,
Yes.
then you will be a right person to comply that order and submit in a report.
Very well.
If both
Have
of them
names?
suggest that person. Pass over? Pass over or tomorrow? Pass over, yes. Pass. Yes, Mr.
But afternoon, 2:30, we have some problem. Before that, my lord, because part-head matters ಇದೆ.
Tomorrow,
ಬೆಳಿಗ್ಗೆ
tomorrow,
ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ.
tomorrow, yes.
Tomorrow.
Tomorrow only you get a
Very well.
suggestion.
Yes.
All that your presence is not necessary.
There is a lawyer, who's a practicing lawyer, who does
You
this
both
forensic.
Seniors has discussed.
Very well, I'll speak to Malan.
Instead of explaining me that whether he may be a lawyer or technical. I
All
have
right,
no
we are okay
objection.
with anybody who's
If both
impartial.
are no objection, I have no objection.
Very well. Grateful, grateful.
Please this matter tomorrow.
Please.
Cell number 20, Chandrachudi FR petitioner, V. Vijay Shekhara Gowda.
But the respondent.
Yes.
Plaintiff's petition. First and foremost, I would like to apologize. When serial number 17 was called up, I was held up in another court.
Yes, yes, yes. Yes, now that you are for the petitioner.
Yes. My lord, one
Sir, is a
submission,
plaintiff or a defendant?
Plaintiff.
one submission, my lord. My lord, kindly look into page number 92, annexure D.
Let
This
me
honorable
complete,
court
let
was
me
fixed
complete.
a day.
Hold on, yeah, no,
Time
whether he
bound.
wants to submit that writ petition can be allowed.
Time bound for 12 months from 30/3/2021. Thereafter, my lord, very conveniently, my friend, filing applications on application.
Let him, I have not understand what is the case at all. You have in the middle, you are saying that.
That is the,
Let the petitioner argue, then you.
that is the direction of this honorable court.
Yes, let him argue, let him argue, yes. Yes, what is this? I will also not give more time to that party. It is under 227. We need not spend more time for
Yes,
all
no.
this. Yes. Yes, what is the suit for, Mr.?
Suit for declaration. Yeah.
Suit for declaration, you are the plaintiff.
Yes, my lord.
Yes. What is
The-
that application you have filed?
I had filed an application under Order 1, Rule 10(2),
Hmm.
seeking to bring the
Hmm.
legal representatives of one late Ramchandra Gowda
Hmm.
as parties here.
Hmm.
May I just spell out the facts of the case, Your Honor?
Yes, where is the plaint? It's annexure B.
Yes, ma'am.
Hmm.
Annexure B, ink page number 46, ma'am.
Yes, yes. Now you give that, on what basis you are claiming in a declaration?
Yes, ma'am. The plaintiff is one of the legal heirs or the grandson of one Shamegowda here.
Yes.
Shamegowda had 4 sons. Among that, Ramchandra Gowda claims to, is one of the persons. Here, the defendant number 1 and defendant number 2, there is a collusion with respect to creation of a GPA, unregistered GPA. For your lordship's appreciation, I will just produce those 2 particular documents. These are very crucial.
Yes, who has executed that GPA? Ramchandra.
Ramchandra Gowda.
Who is he?
Ramchandra Gowda is my uncle, that is Dodappa. Here, if the GPA, unregistered GPA is taken for a movement money, it says it is an unconverted portion.
Yes, yes.
Unconverted portion.
Yes.
Out of that unconverted portion, if at all a GPA was executed, based on that GPA, defendant number 2 could have executed the sale deed in favor of defendant number 1 to that particular portion of property,
Yes.
which is an unconverted portion. Yes, kindly appreciate the sale deed here.
No, now see how it is related to implead that person.
Yes, ma'am. I'll just come back here. Kindly see the sale deed. They say somewhere in the converted portion, the sale deed is executed. Now, the defendant number 1 till date has not produced the original GP, which I have just called in question. Now, by virtue of that, and in his written statement, he himself has taken a specific contention and plea that the suit is bad for non-joinder of necessary parties and proper parties for the reason that the LRs of Ramchandra Gowda are not made of parties. This is a specific contention by the defendant himself in his written statement.
Where is that? Now you are impleading the LRs of Ramchandra Gowda.
Yes, ma'am.
Where is that contention taken?
The evidence affidavit, I'll just place it on record.
Then why trial court has rejected that?
Trial court says, now I will just make my submission. Initially, I filed that application. Without issuance of notice, the trial court rejected my application. I came before this honorable court. This honorable court allowed that writ petition, directed the trial court to issue notice to the representatives or the impleading applicants for them to answer. All the impleading applicants are served. They come before the honorable court and say they have no objection to come on record.
Where is that earlier order of this court?
Yes, madam.
Annexure M, page number 139, madam.
130?
Annexure M 139. Without issuance of notice, this order was passed here.
Oh, that is okay. Where is
No.
the order of this court?
Yes, madam. Next document. Annexure N starts at 151.
Yes.
This honorable court said, may I read out the operative portion, Miller?
Yes.
The writ petition is allowed the impugned order is set aside. Matter is remitted back to the trial court for reconsideration of IA number 1, filed by the petitioner for reconsideration afresh, filed by the petitioner. Trial court is directed to issue emergent notice on IA number 3, the proposed defendants, and notify them and proceed further to dispose of IA. This was it. Trial court does that. Now, for a moment, my lordship is pleased to appreciate the next order sheet I have just produced here.
Now, why now it is rejected by the trial court?
Same answer what was given in the earlier order. Copy, paste, I should not repeat. It is the copy paste order here.
What is that reasoning?
Impugned order annexure A.
Where is that?
The impugned order starts at
Page 32.
yes, ma'am.
You just pointed out that reason.
The reasonings, the court says that under these facts and circumstances, I am the opinion the presence of the legal heirs of Ramchandra Gowda in the prison is not required for adjudicating the issues framed in the suit. This is what the court comes to the conclusion here. It is the unilateral order what was passed earlier. The same order is repeated here, which was set aside by this honorable court.
Now, where is that? Is the evidence?
I just placed it on record.
Which is the paragraph?
Paragraph number 3, if your lordship is pleased to appreciate.
Yes.
I submit that the suit is hit by non-joinder of necessary parties. As Shri M.L. Ramchandra Gowda, son of M.S. Lingya Gowda, is not arrayed as a party defendant in the suit, as the reading of the plaint is necessary party to the proceedings, and such the suit of the suit on this count itself is liable.
It is impleaded. You have also taken that contention.
My lord, they are the legal heirs of Ramchandra Gowda, who executed the register, GPA in favor of defendant number 2. But his children is nothing to do with that this one.
Ramchandra Gowda is no more. Then LRs has to be defended. Then why you have taken the defense in that affidavit?
To seek any relief, because the suit filed by Ramchandra Gowda has been declared in OS number 6183/1997, wherein, my lord, my shell deed has been produced before the trial court as Exhibit D4. Then, my lord, Ramchandra Gowda never disputed my shell deed. Now, my lord, the land in person survey number 19 is not at all the subject matter in that suit filed by Ramchandra Gowda.
No, see, the property which is in dispute is sold by that Ramchandra Gowda to you.
Yes, my lord.
Then Ramchandra Gowda.
That was his share of property he sold. In that suit, my lord, he never.
That all defense is available. Just because LR has impleaded, your defense that earlier suit has been decreed will not go.
Of course,
you have taken a contention that Ramchandra Gowda's LRs is not made in a party. They have also no objection. Why do you have to object it?
No, my lord, in page number 42, the reasons given by the trial court, my lord, can
trial court reasons, nim difficulties really.
The LRs who
allow it and directed to dispose of the suit.
Yes, ma'am. I have no objection to that aspect.
My lord, this honorable court was pleased to fix the 12 months time from 30/3/2021.
Where is that?
In CRP number 19/2020, annexure D. Page number 92, my lord.
That was subsequently recalled, and due to the pendency of a writ petition, that order was recalled, Your Honor. I moved the honorable court moved the application. The coordinate bench of this honorable court recalled that order and said, due to the pendency of the writ petition, that order is extended.
No such order has been.
ನಾನು ಬೇಕಾದ್ರೆ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ, ಇವತ್ತಿಲ್ಲ, ಅದು ನಾನು ಕೊಡ್ತೀನಿ.
Yes.
The coordinate bench of Justice Sanjay Gowda recalled that order.
Whether they have fixed any date in the.
No, my lord. It says that post the matter after the completion of the writ petition. That CRP is not reposted.
What is the stage there?
Evidence, cross-examination of DW1.
Since 2 years, my friend is unable to cross-examine the DW1.
Already, our declaration suit to Nimigan problem or delay ಮಾಡ್ಕೊಂಡ್ರೆ ಅವ್ರಿಗೆ
no purpose, my lord. The plaintiff himself has no right to sue against me or the lands against Ramchandra Gowda.
Decided his suit, he is delaying. Why do you worry? Yes, that's all. Tell. This petition is filed by the plaintiff challenging order dated
22nd November 2020.
2024, passed by 52 additional city civil and session judge Bangalore in OS number 9544 of 2011 on IA 2015 on IA 1 of 2023 filed under Order 1 Rule 10(2) of the CPC. The plaintiff has filed a suit for declaration and possession, very declaration.
Declaration and consequential.
Declaration and consequential relief. When the matter is set down for evidence,
That's a DW1.
in chief examination affidavit filed by DW1, it has taken a contention that LRs of late ML Ramchandra Gowda are the necessary parties. They have not been arrived as a party in the suit. In view of the above, the plaintiff has filed IA number 1 of 2023 for impleading that LRs of deceased ML Ramchandra Gowda. Is it their finding that they have no objection?
Yes, madam. No. The trial court has also observed that, Your Honor.
Yes. After service of notice to LR of deceased Ramchandra Gowda, the LRs are appear through that council.
Paragraph number 13.
They have no objection for impleading them as a party in the suit.
That is recorded at page number
Trial
40.
court, in spite of that, the trial court has dismissed that application. Therefore, the petitioner is before this, the petitioner plaintiff is before this court. Learned counsel appearing for the respondent number?
One.
Respondent.
One.
Respondent number 1. What about that other respondents?
Respondent number 2 is placed ex parte even before the trial court.
Service complete agidya, serial number?
I will file a memo to effect of respondent number 3 to dispense with you.
He is appearing for whom?
Respondent number 1, caveator.
What about 2?
2 has placed, he's been placed ex parte in the trial court also.
Filed in a memo.
Yes,
Filed in a memo for dispensation 2 and 3. Respondent counsel appearing for the respondent number 1 has submitted that. In respect of that very same property, you have filed in a suit, huh?
Ramchandra Gowda filed a suit, madam.
Ramchandra Gowda has filed in a suit.
Yes, madam. I have filed one suit against them.
No,
That
in
has
the
been
suit-
decreed.
In which suit he has
Suit
not
in OS
disputed
number
this?
6183/97,
It is filed by you.
filed by Ramchandra Gowda.
It was an intra-se family partition
I'm
suit.
saying that you said in the suit, Ramchandra Gowda has not disputed that sale deed executed in favor of you, which is
Yes,
the
madam. In his suit, in OS number 6183/97,
in OS number
6183/1997,
60,
183/1997.
83/1997.
My sale deed was marked as
By
Exhibit D4.
Ramchandra Gowda, in that case, he has not disputed the sale deed executed by Ramchandra Gowda in favor of respondent number 1. Therefore, he has contended that the LRs is not a necessary party. Be that as it may, the DW1, who is DW1?
The respondent number 1.
Respondent number 1.
The respondent number 1 is examined as DW1. In his chief examination, in the affidavit, they have taken a specific contention that LRs of ML Ramchandra Gowda is a necessary party. They have not been arrived as a party in the suit. Since the LRs of the deceased ML Ramchandra Gowda are the necessary and proper parties in the suit, and the LRs has also not objected for impleading, I am of the opinion that the trial court is error in dismissing that application. In view of the above, the writ petition is allowed, order dated so and so is set aside, IA 1 of 2023 is filed by plaintiff petitioner is allowed. The LRs of deceased ML Ramchandra Gowda is permitted to come on record. The trial court is directed to dispose of the suit as expeditiously as possible.
Within 3 months, my lord.
ಅಲ್ಲ ಇವಾಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ I need
ಆಗಲ್ಲ,
to
already-
ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ
ಅವರು again, they want to say something. Yes, expeditiously as
Yes,
possible. Yes.
Bill number 21, Harish VS for petitioner, G. Sugumaran.
Yes.
Defendant's writ petition.
Memo ತಗೊಳ್ಳಿ ಅವ್ರ ಹತ್ರ.
Respondent. Defendant's writ petition. Defendant's writ petition.
Yes.
Suit for declaration and injunction, my lords. The the petitioner is a club registered in the Society's Registration Act, my lords. Way back in the year 2000, my lords, the respondent, when he was an office bearer, he had indulged in certain malpractices and misappropriations in the club. An inquiry committee was constituted, inquiry was conducted, he participates in the inquiry, he was found guilty and he was terminated way back in the 2000, not challenged by the defendant so far, by the respondent so far. Thereafter, that termination was carried in review before the general body upheld the termination, that is also attention until not challenged so far. Then in the year 2019, my lords, after lapse of almost 15 years, 20 years, he comes to the club, requesting the club to allow him to contest for the election. That is when the club comes to know that 2004, the managing committee stealthily takes him back without any power being conferred on the managing committee. So therefore, in 2019, when he comes to the club to collect the nomination form, they confirm the earlier resolution saying that you cannot come because you have been terminated, my lords.
Yes.
Now in the suit, he challenges the 2019 resolution passed by the general body, and he claims injunction based on the managing committee, which takes him back. That is all the suit is for, my lords. Now, my lords, there is the short question before my lords is whether the trial court is right in framing an issue for which there is no pleading, there is no dispute, there is no relief claim in respect of a particular issue, my lords. Now the trial court says, now you prove whether the inquiry was conducted in accordance with law, whether he had indulged in malpractice, which is all foregone now, 25 years lapse, that is not the dispute at all. So therefore, now the trial court cannot put the clock back and say you prove that.
Now, what is that?
I filed an application before the court, IA number 9, say under order 14 rule 5 to delete that particular issue. Kindly see the issue framed by the trial court, my lord. Your lordship will find that page number 109, page number 96, my lord.
Yes. Yes, you take notice.
My lord, no. My lord, I
I'm
just
just saying-
bear
In
me
fact,
for
this is
2
the
minutes.
second
my
round of
lord.
litigation.
No, no.
Let me complete. Second round of litigation, the first
My
round, my
lord.
lords, when a trial court passed an order, 39(1) and 2, the club filed a writ petition challenging that order, which came before my lords, my lord. Your lordships modified the order to allow him to use the facilities of the club, however, restrain him from either contesting or casting a vote in the elections of the club, my lords. This is the first round of litigation.
No, see, now he is not seeking for an election. Now you are not challenging that.
Yes.
Your only question is that issue is not related to the pleading.
Correct.
It is beyond that pleading.
That particular
Now
issue.
you have to see what is the pleading, what is the relief, whether this issue is related to that or not.
Precisely.
That is the only.
Precisely.
My lord,
I want to go to that.
My lord,
Precisely, ma'am.
the time granted by this court is a clearly is all these aspects and all enrolled. This lordship was pleased to pass down order on 17 November 23.
Now that's now.
Giving a 1 year time for this trial court to dispose the matter. All this is detailed. Now what has happened? The trial is proceeding. The defendant did not cross-examine the plaintiff. It is dismissed. It is discharged.
When the-
Discharged. What happened after that? The defendant, now the stage was set down for the defendant's evidence. The defendant evidence did not do. They filed an adjournment application and for recasting of issues.
When the issue has been framed.
Issue was framed, my lord.
2511, my lord.
2511.
Asking him. Yes. When the issue has been framed.
25th of November 2024, my lord.
2024.
24.
Is it?
Kindly see page 59. Page 59, 25/11/2024, order sheet. 25/11, then 27/11, 30/11, 2/12, 3/12 on a daily basis.
No, see, when that, where is that page number?
Page number 59,
59.
25/11, 2024.
Fine. Yes.
Not a called out issues framed hence for plaintiff evidence, list of documents, list of witnesses.
Then 59 only, which is the date?
25/11.
Issue framed.
Issue framed.
Issue framed on 25/11/2024.
Yes, 27/11.
27/11. When the writ petition is filed?
But the impugned order was passed on the
Immediately they have filed that writ petition.
5/12 is the
Not,
impugned order.
granted
6/12 is.
matter.
No, my lord.
Now all this is not the issues.
Yes.
Now that whether issue framed is in related to that.
In a subject matter of the
Where is the plaint?
yes.
What is the return?
My lord,
statement? What
my
are the
lord,
issues?
my lord.
I
The
will point
issues,
to-
recasting issues is filed it was allowed. It was allowed. There is no agreed by the order because the IS 16 is filed. It was allowed for recasting issues. Only thing is, he says that the court has retained issue number 4, that impugned order is there in page number 20. There is no
That
ambiguity
matter
in this.
requires to be hearing, we'll hear that.
No, my lord, I'll tell you. This is the issues framed by this honorable court, trial court, in conformity of the written statement,
Mr. Counsel,
89.
this is not the case to you. You are seeking for an contesting the election. There is an urgency. It is only thing is that whether earlier you have dismissed from the service has to be decided in this case or not.
No.
We'll hear that matter.
My lord, this is in frame, what has happened, the defendant has come before the writ petition stating that
Yes,
the issue framed by the trial court is in order or not. But the issue framed by the trial court in conformity of the written statement filed by them only.
Yes.
See, it is there, your lordship, see, in page number 89.
Yes, we'll hear you today. I
In
don't
that
have-
only, issue number 4, it has been framed.
If you are allowed, I will post it next week. Otherwise, I will grant an interim order, post it.
No, I'm only trying to read the,
Admission, matter requires to be final hearing. Only thing is that you both has to be produced that plaint, written statement.
it is produced, your lord.
What are the issues?
It is produced, lordship.
Today I
They have
have
produced, my lord.
heard, admit,
They have produced.
Cell number
stay of
22,
further proceedings of the suit. Yes.
cell number 22 adjourned, cell number 23, Dilip
But the
Kumar
date may be
IS.
fixed, my lord.
That is what I am saying. I know that everything is produced. Today we sat.
Yes, yeah, no,
late.
my lord. I only just pointed out the court, my lord.
Yes.
It is not that, it is already, your lordship has,
Is that next date it is fixed there?
it's 15th it was posted
15 for what?
of this month for
For
evidence.
what it is?
It is for evidence of the defendant,
Defendant's evidence.
defendant's evidence.
Yes, lease this matter on 21st. On that day, we'll see. You both of them produce that written statement, plaint, and that order which is passed for a recasting of that. What are the grounds which has taken? Only
It's al-
that point
it's already
we'll
part
decide.
of the writ petition. It's already placed.
Yes,
It's on
we'll
record.
decide on that day.
It's already on.
All that matter is there. Why do you want all this? Yes.
In the meanwhile, the further proceedings may be.
22nd, you both of them ask that next date, that matter is posted on that. It will be
Yes,
urgent.
yes, my lord.
The difficulty is if your lordship.
No, difficulty for the court because there is a direction from the High Court to decide. Therefore, you taken a date on 22nd, matter is posted. If they are further proceeded, then I will move that matter on that.
Grateful.
Yes.
Great.
Cell number
He
23,
is also agreed that on that day, both of them as with the consent can be urgent for a next week.
Grateful.
There is.
No, my lord, we will hear that matter. It
Yes.
is all that.
If it is time permits on 22nd, we'll hear that.
Grateful.
Yes.
cell number 23, Dilip Kumar IS for petitioner, GR Mohan.
My lord, this, my lord, directed me to convince the point that in a suit for partition,
Yes.
whether the counterclaim is maintainable. So, what I am reading three judgment. Sir,
What is that, this thing, Mr.?
my lord, I have filed an application for amendment of written statement,
Hmm.
adding counterclaim, which has been rejected, which has been challenged, my lord.
Yes.
So in a suit for partition,
Suit for
in
partition.
a suit for partition.
Hmm.
So.
So that, it was posted on, 2
Howd.
days back.
Howd.
Yes.
Howd.
Now you have filed a counterclaim for what?
Counterclaim declaring me
Hmm.
as a owner of item number 1 property.
Hmm.
So, which is the subject matter of this suit. My lord, it's a declaration, my lord, if I file a separate suit and this code passes, I mean, the regular
Suit
code
is filed
in 2022, my lord.
2022.
Oh, 23/8,
So why you
2022.
have not taken this defense all these years?
I have taken in the written statement, my lord.
Hmm.
I have taken, but the prayer part was left out and the prayer has been added.
Now,
In-
what is the stage of the suit?
Defendant evidence.
And then, When it is defendant evidence, you are remembering that but this has to be added.
No, because of the direction, my lord, the court was giving a date
Even
a week,
otherwise, if the court is deciding the cases.
and the cross-examination
they-
has gone lengthy.
happy. You should be happy that now the courts are deciding by, see, otherwise.
No, I'm not, because why could not file? The issues was framed in March 2024. And then he led the evidence, and then it was posted for the cross-examination.
See,
My lord,
when you have taken the contention in that plaint itself, you should have been prepared for that. There is no subsequent event for you to make to file an application for amendment.
I have-
Suppose if they have taken any contention in the written statement, for that, it has been provoked you to file an application, then it is correct. You know that, but you have,
I will explain, my lord.
yes.
I have filed a detailed written statement. In the detailed written statement, I have claimed that this property has been purchased by me. Entire consideration has been paid by me and transferred by me. And I am the owner. Subsequently, my lord, the ownership cannot transfer unless there is either a gift deed or the sale deed or the will. So
Why trial court has dismissed?
I'm not saying that there is a direction and it has been filed at the stage of the defendant evidence. Your Honor can find the finding in page 66, my lord.
See, now problem is, once that claim is allowed,
Paragraph 18, paragraph 18.
again that he has to file an objection,
Oh.
then evidence has to be
It will be decided in one suit, my lord. Otherwise, if I file
Just
another suit.
because it can be decided one suit, after that matter has been posted for an argument, you file another application for a position. Can be done it. It can be done it for avoiding the multiplicities as proceedings.
No, I'm
You
in
can
possession
direct
of the
that
property that is not disputed.
Paragraph 4, your lordship.
I'm in
the
possession
written
of the whole
statement,
property that
after
is not
permission,
disputed, my lord.
he has pleaded all these things in written statement, paragraph 4 itself. Only you want to amend now by introducing paragraph 4A. Already he has pleaded everything. It is, I have
By
paragraph
pleading,
4, page 93.
by pleading, you will not get a
That's
decree.
what. Because it's all, he has to prove by where defense evidence is there. He can prove by defense evidence.
There is no counterclaim. Counterclaim, nothing but
Oh,
it is issued. He can also get a decree.
That's
But
what.
here, there may be a finding on that issues.
Yes,
He
sir.
will not get any degree.
Again, I will have to file a suit for the same property
Let
and
him, will direct the trial court to dispose of.
Question is, already there is an issue framed and additional issues have been framed.
Sir,
At the time of defense evidence, now, yes,
framing the issue, court can give only a finding, not give any decree. Can be given a decree either by suit or by counterclaim. That
Then
is
now-
what that his declaration will not get.
now my only response submission now, keeping all these issues, their disputes. Now already there is an earlier order of this honorable.
Now, issue is already there.
There, yes.
There need not be any issue.
Not.
Now, only thing is that his prior has to be amended, his written statement has to be amended for a counterclaim.
the direction which granted by this court in page
Yes,
109,
already
my
treated
lord.
in the
One
written statement,
submission,
paragraph,
one submission.
paragraph 4,
One
page
submission,
93.
one
your
submission, one submission. In
All these
page-
things, what he has now pleading is come already, page 93.
my lord,
For application.
Fresh is not,
109, this court has directed because the plaintiff has misled this court saying that the plaintiff is a handicap. But she is hale and healthy and walking, she's not a handicap. Because of the misled, this court directed within 1 year, it is a simple suit for partition.
page 92, your lordship, last line,
The
in the written
page-
statement.
1 year from which
He
day?
has stated all these things. Now what you want to say in
February 2024.
110.
I think we extend another 6 months and we'll say that allow this application and dispose of. What is that application? Where is that?
110 ink page
11?
0, IA 8/24.
One one zero.
Oh.
What is the prayer?
Prayer is to permit me to amend and to insert the prayer. To add additional para and a prayer.
Prayer, wherefore that namely prayer this honorable please to judgment to degree declare that defendant to absolute owner of the item or one of the property dismissing the suit of the plaintiff in the interest. Prayer in the written statement. Third. This petition is filed by defendant. Number 1, under Article 227 of Constitution of India, challenging order dated 13/12/2024 passed by 72nd Additional City Civil and Session Judge Bangalore in OS number 26400 of 2022, whereby application filed by defendant number one, IA number 8 of 2024 under Order 6 Rule 17 is dismissed. Plaintiff has filed in a suit for partition and separate position. Defendant, after appearance, has filed in a written statement, has taken a contention that which is the property is
Item number one property.
suit scheduled item number 1 is self-occurred properties of the defendant number 1. On the basis, trial court has framed the issues. Matter was posted for evidence. Evidence of the plaintiff has completed.
In fact, the trial court itself has given a finding at page 54.
Completed.
Already has pleaded, no, but it's
At that stage,
that but the case of plaintiff or the defendant.
defendant number 1 has filed this application under Order 8 Rule 6A na, Order 6 Rule 17. As a counterclaim. The trial court has dismissed that application on the ground that there is already a direction by this court in writ petition 953 of 2024 for disposal of the suit within 1 year from 9th February 2024, and also given a reason that there is already a pleadings in the written statement in these aspects and issues has been framed. Be that as it may, since the claimant, the defendant number 1 has already taken such a contention in that written statement, to avoid multiplicity of proceedings, it is just necessary to allow that application. Accordingly, writ petition is allowed. The order dated so and so is set aside. The IA number 8 of 2024 filed by the petitioner defendant number 1 under Order 7 Rule 17 is allowed. The trial court is directed to dispose of that suit as expeditiously as possible, not later than 6 months from date of receipt of copy of the
8 months.
8 months from date of receipt of copy of the certificate. Yes.
Bill number 24, Kantaraju NK for petitioner, Ashok B. Patil.
I'm for caveat or petitions. That is a plaintiff's petition. The plaintiffs have filed a suit for declaration and injunction in respect of shell properties. Well, since the first original defendant is opposing the possession and attempted to interfere with the possession. Well, during the pendency of the suit, well, an application for amendment of plaintiffs have been filed. That has been rejected, page 22,
ಅದರಲ್ಲಿ ಒಬ್ಬರೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಕೇಸ್ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ನೊಬ್ರು ಇದ್ದಾರೆ ಅವರು he is appearing for a home elevator. ಎಲ್ಲರಿಗೂ ಇದ್ದಾರಾ ತೋರಿಸ್ಬೇಕಲ್ರಿ elevator ಯಾರಿಗೆ ಅಂತ all three. Where is that council?
Dilip Kumar IS, GR Mohan.
ಹೋದ್ರ ಅವ್ರು ಮೋಹನ್ ಕರಿ. Yes. Yes, Mr.
Amendment application was rejected. On the ground that it multiplies proceedings. All that amendment is sought for is amending the pleadings and also insertion of 3 properties.
What is the suit for?
Suit for declaration and injunction against the respondent.
Malas, the application was rejected malas, as the ground that it multiplies the proceedings. Page 22 malas. Suit for declaration injunction.
Now, what is that amendment you have sought for?
Amendment is incorporating the pleadings. Certain pleadings were not properly stated, and insertion of three properties which were left out, which was earlier it was not incorporated.
Now, what is the reason given by the trial court?
Malas, reason given by the para 11 malas, page 22. This court is of the opinion to decide the matter is fully and finally the prayer sought for in under order 6 rule
Para
17 CPC
22.
is not necessary. Para 11 malas.
Para 11.
Para 11 page 22.
Para 11, yes.
This court also comes to the conclusion that if the application is allowed, it will protract the proceedings. Hence, to avoid the multiplicity of proceedings, this court declined to so on so on.
This court is also come to the conclusion that if the application is allowed, it will protract the proceedings, hence to avoid the multiplicity of proceedings. To avoid multiplicity of the proceedings, ಹೆಂಗಾಗುತ್ತೆ?
That's what.
ಇದನ್ನ allow ಮಾಡದಿದ್ರೆ multiplicity of proceedings ಆಗುತ್ತೆ. ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕ್ಬೇಕು. ಅದು it's otherwise reverse.
My first submission is there is another writ petition pending against the order restoring the present suit. Initially, this suit is filed in the year 1987 and it is renumbered in year 1989. In 1997, when the matter is set down for plaintiff evidence, the plaintiff did not lead his evidence. Therefore, that suit is dismissed for non-prosecution in the year 1997. And after 19 years, he files a miscellaneous petition to restore the suit. And that is also dismissed in the year 2018. And in the year 2018, and after a delay of 2 years, in filing a miscellaneous petition, there is a 19 years delay. And in filing a miscellaneous appeal, MA, there is a 2 years delay. And in miscellaneous appeal, the appeal is allowed. And against that order, I have filed another writ petition, which is pending before this honorable court. That is against the restoration of this suit itself.
Suit itself.
Then what the matter says
That's
to
a
be.
different fact plus. That's a different fact.
Suppose if I allowed that this writ petition is allowed, restoration itself is confirmed,
Yes.
dismissed, then what is the purpose in permitted you to amend?
No,
My writ petition
no,
is
there's-
allowed.
No, their specific case in another writ petition is that OS 166 of 1989 is restored, but it should not be other OS 31 of 1991 is to be restored. That is the ground. First, your lordship, post along with that writ petition, so
Both
that
the
both
matters
can
may
be
be
disposed.
posted along with me.
That is what he has
Please,
saying that.
please.
I'm filing a memo to that effect. I'm filing a memo to that effect.
Yes.
Plus, in the meantime, I have sought for a further proceeding. The trial court is posting day-to-day, because since it is in the suit of 1987.
I 387 in the nim suit, 5 ವರ್ಷ 6 ವರ್ಷ
ಇದರಲ್ಲಿ
ಮಾಡಿಸ್ಕೊಂಡು
ಇದರಲ್ಲಿ ಇನ್ನೊಂದು
What is
in the-
that?
No,
in the
ನನ್ನ
year
suit ಅಲ್ಲ.
1987, they
Suit
have sought
is
for a declaration of
plus
title.
he filed, plus what has happened? I have filed a suit for declaration injunction. I have obtained an injunction restraining him from interfering with our possession. Plus challenging that order, he filed MA 5 of 1989. Plus the records were called for. Records went to Tumkur District Court.
No, I am saying about this suit. This is your suit.
Yes,
It is pending from 1987.
Yes, but for the last 26 years, records were not traced. The transit, I placed the order sheet. Await records for the last 16 years. But ultimately, on 8/9/97, the suit was dismissed.
You are taking notice to other respondents also.
Only for 1, 2, 3. For respondent number 4, I have entered caveat. 1, 2, 3, I'll take notice.
1,
For
2,
respondent
3.
number 5, a notice has to be.
Yes. Caveator is undertaken to appear for respondent number 1 to
3.
1 to 4.
3. 4, I am already on caveat.
Yes, you are only caveator. Now you're taking notice. 1 to 4. Issue emergent notice to respondent number 5. Stay of further proceedings in OS number
166 of 1989.
66 of 1989, pending in the file of additional city civil and Judge JMFC Kunigal till next date of hearing. Call this matter along with that.
Along with WP number 3423.
Yes.
I filed a memo.
All along with so on. Yes.
Please.
Office objection matter serial number 25 to 28 urgent for order serial number 29 Lakshmikant K.
Yes. ಏನಕ್ಕೆ ಬಂದಿದೆ? This court by order dated 1st August 2024 directed the family court to dispose of that MC number 55 of 2022
as expeditiously as possible. After hearing the parties, direct to dispose of said as expeditiously as possible in accordance with law. L/3, extension ಅಂತ ಎಲ್ಲಿ ಬಂದಿತ್ರಿ? As expeditiously ಅಂತಿದೆ, ಅದಕ್ಕೇನಂತೆ? Intimated your authority via our letters, but regarding that interest also sent to this office, and further need action to taken. With reference to the above, submitted that we have received the transfer order for transfer of CC from Davangere to Family Court, Mysore, as the connected criminal miscellaneous 238/22/5 before Family Court, Mysore. So the said. Learned counsel for the petitioner will serve husband. Dispatch. The responsive family court seeking the maintenance and the name of the respondent has been fed into marriage as before family court by the seeking the history. What is completed? CP Family Court, Mysore, as connected KMC filed by MC number 55 before the Family Court, Davangere seeking institution of conveyance. Another 65 kilometers. MC number 55 pending in the file of the Family Court is hereby withdrawn and transferred to the traditional so CP transfer of so Davangere as connected to the Family Court, Mysore, as the connected MC is filed. Family Court, Mysore, but the said CNC disposed of, which was intimated to your authority. But when this report was sent to this office, clarify as further. Yaar advocate kar rahe?
Lakshmikant K. Serial number 29, Lakshmikant K for petitioner.
ಇದು ಚೇಂಬರ್ ರಿಕಾರ್ಡ್ಸ್ ಕೊಡಿ
Serial number 30, Naveed Ahmad for petitioner, connected matter, BK Manjunath.
What is this, Mr.?
Lords, it has been transferred to Lord the civil court.
Hmm.
Lords, now there is a family court, Lords, in Davangere.
Hmm.
But that has to be transferred to the family court, Lords. It is the only Lords clarification. Lords. Disposed of matter, Lords.
Hmm.
And the transfer petition was allowed. And matters from Chitradurga was transferred to Davangere.
Hmm.
And Lords was under the impression that there is no family court in Davangere. It has been transferred to civil court. Now the principal judge Lords has written a letter saying that there is a family court in Davangere. Therefore,
You have to mention when that case has been disposed of.
Lords.
Now that you have to file an application for modification, Mr. That has to be there in your prior, it is not there.
We have simply said in the Davangere court at Davangere, Lords.
Now you file an application, will modify this order. On this ground, you seek for a modification of this order. Instead of transferring that, it has to be transferred to that. On that basis, we'll modify and send it. Yes.
I will file it.
File application. Yes.
Next
This
week,
matter
Lords.
next week.
Deep Kumar.
All this,
Yes,
next
sir.
week you file an application, Mr.
Serial number 23,
Yena.
ಅದ್ರಲ್ಲಿ ಇನ್ನೊಬ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅಲ್ರಿ ಹೇಳ್ಬೇಕು.
Not required, my lord. I will file a memo.
Memo, ಕೊಡಿ. 1 and 2, you are taking notice 1 and 2. 3, he has filed a memo for dispensation. Next week. ಯಾವ್ದು? What you want? You want moving memo? What is that urgency? You have filed an application. Use the mic.
Notice is issued on the other side also. The 10th is judgment day. Therefore, I am seeking tomorrow, my lord. It is very urgent, therefore.
ಇವತ್ತು ಎಷ್ಟು ತಾರೀಕು?
Opposite side is one of the company.
9. Yes,
Taking out.
tomorrow. Yes.
Tomorrow.
ಅವ್ರ ಕೈ ಕೊಟ್ಟು serial number 230 ಅಂದ್ಬಿಟ್ಟು 230 ಅಂದ್ಬಿಟ್ಟು ಅವ್ರ ಕೈ ಕೊಟ್ಬಿಡು. ಅದೊಂದು ಚೇಂಬರ್ ಕೊಟ್ಟೇನಪ್ಪ ಚೇಂಬರ್ಗೆ. ದೇವಣ್ಣ ಚೇಂಬರ್ ಕೊಟ್ಟ. $67. ಯಾರ ಮುಂದೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಸರ್? ಮತ್ತೆ ಅವ್ರು ಪೆಂಡಿಂಗ್ ನವ್ರು ಹೆಂಗ್ ಗೊತ್ತಾಗತ್ತೆ? ಆಯ್ತು, ಊಟ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ, ನೋಡಿರ್ತೀನಿ ನಾನು ಅಷ್ಟೊತ್ತಿಗೆ ನೋಡಿರ್ತೀನಿ. ಪಾಟಿ ಇಲ್ಲ ಸರ್. ಕಂಟಿನ್ಯೂ 28. ಏನಪ್ಪಾ 28 ಅರ್ಜನ್ ಏನಾಗಿಲ್ವಲ್ಲ? 1 week ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೆಳಿಗ್ಗೆನೆ. ಏನಮ್ಮ? ಈ ತರ ಓದಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ. ಏನಕ್ಕೆ ಹಾಕಿದ್ರಿ? PF ಯಾರಿಗೆ ಹೇಳಿರೋದು ಇದು? ಎಲ್ರಿಗೂ ಅನ್ಸರ್ವ್ಡ್ ಯಾರಿದ್ರು ಅವಾಗ unsaved cover in respect of 2/4/21. ಇದು unclaimed ಇದು. ಎಷ್ಟು ಜನಕ್ಕೆ? ಸರಿ ಆಯ್ತು, 1 ನಿಮಿಷ. 2/4/21 return sufficient. The petition against suppression dismissed. 19ಗೆ ಬೇರೆ. ಇಷ್ಟು ಜನಕ್ಕೆ ಈ ಆರ್ಡರ್ ಅಪ್ಲಿಕಬಲ್. ಇವ್ರು PF ಕೊಟ್ರ? ಇವತ್ತವರೆಗೂ ಕೊಟ್ಟಿಲ್ಲ. ಕಂಪಲ್ಸರಿ ಚೆಕ್ ಮಾಡಿದೀರಾ? 100% ಡಿಸ್ಮಿಸ್. ಆರ್ಡರ್ ಪ್ರಕಾರ ಡಿಸ್ಮಿಸ್. ಹೌದು. ಏನಂತ? ಪೋಸ್ಟಿಂಗ್ ಮೆಮೊ ಮಾಮೂಲಿ ಪೋಸ್ಟಿಂಗ್ ಎಲ್ಲ ಬರುತ್ತಾ ಕೊಡಿ. ಈ ಆರ್ಡರ್ ಪ್ರಕಾರ ಸರ್ವಿಸ್ ಎಕ್ಸೆಪ್ಷನ್, ಈ ಆರ್ಡರ್ ಪ್ರಕಾರ ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ಸೊ ಇದಕ್ಕೆ 1 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು. ಏನ್ ಸ್ಟೆಪ್ ತಗೊಂಡ್ರೋ ಇಲ್ವೋ ನೋಡಿ. ಸ್ಟೆಪ್ ತಗೊಂಡಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ಪುಟ್ ಮಾಡಿ. ಹೌದು. ನಾಳೆಗೆ GMCPC ಅವಾಗ್ಲೇ ಒಂದು ಕೊಟ್ಟೆ ಚೇಂಬರ್ ಗಿಡಕ್ಕೆ ಇಲ್ಲ ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಕೇಳ್ತೀನಿ ನಾನು. ಇವತ್ತಿಂದ ಅದೇ ಮಾಡಿದ್ದೀನಿ. ದಿವಸ ಅವ್ರು ನಾವು ಮಾಡ್ಕೊಳ್ಳಿ. ಒಂದ್ ದಿವಸ ಅಷ್ಟೇ ಅವ್ರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಕ್ಕೂ ಹೇಳಿ ಕಳ್ಸಿದ್ದೀನಿ. No. ಫೋನ್ ಯೂಸ್ ಮಾಡ್ಬೇಕು. ಅಡ್ವೊಕೇಟ್ ನೀವು ಅದನ್ನೇ ಕೇಳ್ಕೊಂಡ್ರೆ ಅವಾಗಲೇ ಹೇಳಿದ್ರಿ ನೀವು ಬರ್ಲೇ ಇಲ್ಲ.
ನಿಮ್ಗೆ ವೇಟ್ ಮಾಡ್ತಿದ್ದೆ.
ಕೂತ್ಕೊಳ್ಳಿ ಸರ್, ಆಯ್ತಾ? ಹಾ ಹೇಳಿ. ಪಾಸ್ವರ್ಡ್ ಎಲ್ಲ ಮುಗಿಬೇಕು, ಮುಗಿಯೋವರೆಗೂ ಪಾಸ್ವರ್ಡ್ ತಗೊಳ್ಳಿ. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಫಸ್ಟ್ ಅವರ್ ಆಗ್ತದೆ. ಕೂತ್ಕೊಳ್ಳಿ. ನಿಮ್ದು ಒಂದು ಇನ್ನು ಏನು ರೀಚೇ ಆಗಿಲ್ಲ ಇವತ್ತು. ಅಡ್ಮಿಷನ್ ಅಷ್ಟೇ ಮುಗ್ದಿದೆ. ರೀಚ್ ಆಗಿದೆ ಎಲ್ಲ ಆರ್ಡರ್ಸ್ ಆಡಳಿತದಲ್ಲಿ ನೋಟ್ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಹಾಗಾಗಿ ಆಗ್ತದೆ. ಸಬ್ಮಿಟ್ ಮಾಡಿ ಇನ್ನೊಂದ್ಸಲ
ಸೀರಿಯಲ್ ನಂಬರ್ 56 56 ಟೈಮ್ ಕೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ನಮ್ಮನೆ ಡೇಟೇ ತಲೆ ಕೆಡಿಸ್ಬಿಟ್ಟು ಎರಡು ಮಾಡ್ಬಿಟ್ಟು
ಇದೇ
ಅದೇ ಹೊಸ ವರ್ಷಕ್ಕೆ ಯಾರು ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ ಅದೇ ಆಗಿಲ್ವಾ? ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿದೆ? ಇನ್ನೇ ಇದೆ ಫೈಲು? ಮೇಡಮ್ ಅದು ಸಾಹೇಬ್ ಓದಕೊಟ್ಟು
ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾವು ತತ್ತೀರಾ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಕೋಪ ಬರುತ್ತೆ.
ಆಗೋಗಿದೆ ಅನ್ಕೊಂಡಿದ್ದೆ.
ಆಫೀಸರ್ ಸೆಕ್ಷನ್ serial number 29 ಒಂದು ಕೊಟ್ಟಿದ್ದೀವಿ. 31 ಇಂದ ಶುರು ಆಗಬೇಕು. ಪಾಸ್ವರ್ಡ್ ಎಷ್ಟಿದೆ? ಎರಡೇ ಪಾಸ್ವರ್ಡ್. ಹಾ 14 ಕೇಸ್ ಇವನ್ ಕೇಸ್ ವರ್ಕರ್.
Your Lordship.
Hmm.
A small submission, Your Lordship. Serial number 67, Your Lordship. It was previously part heard, Your Lordship, but it is listed today before Your Lordship. It was previously heard by K. Natarajan here on.
Now, parted before where?
Justice K. Natarajan, Your Lordship, on 20th of December.
Yes. It is order sheet ಅಲ್ಲಿ ಇದೆಯಾ? The order sheet, it is noted that matter was parted before
Justice K. Natarajan.
Justice so and so, and office is directed to use this matter before. Matter was parted before Justice so and so, and registry is directed to place this matter before so and so.
Obliged.
Serial number 15, my lords, and for the petitioner, we're filing a memo for withdrawal, my lord, on account of settlement having been reached between the parties.
1-5,
1-5, my lords.
1-5. Counsel for the petitioner filed on a memo. I carried memo. Why 2 memos? Memo seeking leave of this court to withdraw this writ petition. Memo is taken on record. The above writ petition is dismissed.
Please, oblige, my lords.
Yes. 61.
From the other side also. Request 2 weeks ago.
For the request of counsel for the petitioner, leaves this matter of 2 weeks.
List number 1, serial number 31, T.N. Arakeshwara for appellant.
Yes.
Serial number 31, T.N. Arakeshwara.
Finishing up here, issue notice, weeks time is granted to do the needful.
Serial number 32, Alesha R.G. for appellant, Mohammad Safiullah Khan.
They have already taken notice on behalf of the others, and
This process to issue notice to R1A 4A and R5.
I had earlier filed my wakalat on behalf of these,
Advocate appearing for R15.
and R5 is a company. I don't know how they say is that.
R1A. Who is
R1A is the deceased wife. I filed wakalat for all these persons earlier. I don't know why.
You have filed an wakalat.
Yes, sir. Otherwise, I will take notice on behalf of all the others. They're all family, basically.
No, you are appearing for which respondent?
1A, 1B.
Yakre notary wakalat. Verify wakalat.
They had filed application for impleading also. Bring the LRs on record long back.
Ashok Patil, sir.
Okay.
Ashok Patil R1 and R5 dead ಅಂತ ಬರ್ತದೆ ಏನು? Ashok Patil R1, R4 and R5 dead ಅಂದ್ರೆ ಎಂತದ? ಹಂಗಂದ್ರೆ ಏನದು? What is that meaning? Since Ashok Patil advocate for petitioner number so and so is dead ಅಂತಾರೆ. ಎಲ್ಲೈತೆ Ashok Patil? Who is Ashok Patil?
Me, man.
Yes, you are appearing for the Ashok Patil.
For the respondent.
ಏನಾಗಿತ್ರಿ ಆಫೀಸರ್ಗೆ ಆ ತರ ತೋರಿಸಿದ್ರು. What is that meaning? The office
1A, 1B.
note is wrongly shown something else, mister.
It's wrongly shown, madam.
Yes, that's
Here.
what it's confusing for me also.
1A, 1B, 4A, and 5.
See, Ashok Patil Learned Council has filed an wakalat for respondent number 1A, 4A.
1A, 1B also, man.
1A, 1B gillala, 1A and 4A,
4A
4A.
and 5 is a company. I don't know how they say.
R1, R4 and R5. ಯಾರ್ರೀ ಹೇಳಿದ್ದು ಅಶೋಕ್?
R5 is a company. How can they show is dead?
No, which Ashok Patil, mister? There is a wrong in that order sheet also. I'm very sorry. I don't know why this has been noted in that earlier order sheet, mister.
I don't know, my lord.
This is what the confusions. You were not there last time.
Last time, I think I was saying more.
Who has mentioned
No,
like
that earlier, last time my mother had passed away. This is that. Last date of hearing, my mother had passed away. That's why that note is there.
But order sheet has shown wrongly.
Wrongly shown.
Why office notes associated? So, it is very unfortunate. Very sorry. This is not that this thing. Instead of that, it has shown that. Therefore, I am confusing. I am asking.
I understand,
repeatedly
but
that you- Yes. In order dated 9/12/2024, it is wrongly mentioned. It is wrongly ordered that advocate for so and so is dead instead of the mother of the arguing counsel, Ashok Patil is, see, here correct, order is correct. But in that,
In the order, in the order sheet, man.
court office has wrongly
Wrongly
noted that.
noted.
Yes. Order dated so and so, it is noted that mother of the arguing counsel, Ashok Patil, is died, hence matter was been urgent. But in that cost list, it was wrongly shown. Therefore, office is directed to correct the same and show the name of Ashok Patil for R1A and R4A. And
And
also appearing for
5 also.
respondent number 1, 4 and 5. ಯಾರ್ರೀ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಓದಲ್ಲ ಏನ್ರಿ ಅದು? ಯಾರು ಕಳ್ಸ್ರಿ ಅದು? What is this transition?
A date may fix for final hearing, my lord.
Now that it is process is completed.
Yes.
No, that application is allowed.
Yes, ma'am.
LR's application
I
is
think
allowed.
so. It has been allowed and brought in record also.
The appellants. IA is allowed. Yes. Post this matter for hearing.
Hearing, final hearing.
Post this matter in hearing list in first week of February. Yes.
Date may be fixed, my lord.
ಅದ್ ಯಾರ ಆಫೀಸ್ ನೋಡ್ರಿ ಅವರು ಆಯ್ತು ರೀ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡೋದಲ್ಲನ್ರಿ ಆರ್ಡರ್ ಇಟ್ ಇಸ್ ಕರೆಕ್ಟ್ಲಿ ಸ್ಟೇಟ್ ದಟ್ ಮದರ್ ಆಫ್ ದ ಕೌನ್ಸಿಲ್ ಏನಮ್ಮ ಅದು ಯು ಸಿ ದಟ್ ವಾಟ್ ಈಸ್ ರಿಟರ್ನ್ ಇನ್ ದಟ್ ದಿಸ್ ಥಿಂಗ್ ಕೆನ್ ಯು ರೀಡ್ ವಾಟ್ ಈಸ್ ರಿಟರ್ನ್ ಇನ್ ದಟ್ ಆರ್ಡರ್ ಶೀಟ್ see once you have to mention all these aspects you have to see twice. You are noted that something else which is not there. It is for me also confusing when council is present, it's showing something else. Therefore, I am repeatedly asking that. Yes. Yes.
Date may be fixed on a specific date.
10th, no, that you are only having 7th, yes.
Much obliged.
Serial number 33, serial number 33, S. Ramamurthy for appellant, Sachindra Karantke.
Your Honor, this, during the course of dismissal period, this objections complaint. The A1 and 2.
No, you have to furnish PF and all. Have you paid it?
PF paid on 23 October 2024.
No, after that again they have asked, not Rayawat.
Again, there are,
12/2/24. No, after that again that it has come back. Now they ask for a fresh process. Yes, week's time is granted to do the needful.
Serial number 34, R. Chandrana for appellant, N. Savanur.
Petitioner, I pray for 3 weeks' time. We are trying for settlement. This is a matter between landlord and tenant regarding the arrears
So
of
for 34.
house.
Yeah, now the maintainability regarding
Yes, my lord.
petition in section 96.
While disposing of the application, decree has been passed, but I have challenged. Now the office has raised an objection.
Writ,
But we are trying for, pardon,
no, writ is not maintainable. You have
Yes,
to
my
file
lord.
an,
we are trying for settlement. Kindly,
no,
I will-
even if it is settled also,
Yes.
you can settle it, but this, we cannot pass any order in this writ petition.
call it on after 3 weeks. In the meanwhile, we are trying for settlement.
2 weeks, my lord. 1 or 2 weeks, my lord.
What is the settlement you are now, you are,
Arrears, regarding the-
Arrears, my lord.
reach this matter on 22nd. 22nd.
Obliged.
Yes,
Much.
in the meantime, if you settle,
Aye, sir.
you withdraw that, otherwise we will dismiss it for not maintainable. Yes.
Serial number 35 disposed of, serial number 36, Kevin Narasimhan for petitioner, Nagaraja N.
Rectification of the office objection raised on.
For the respondent.
Yes, what is this, mister? Next week, he is not there.
Please.
None appear for petitioner. Leave this matter after 2 weeks.
Serial number 37, Vijay Kumar K for petitioner,
Furnishing of
H.
PF
Srinivas.
corrects.
My lords, appear for petitioner, my lords, praise time for 1 week for
Yes,
taking up steps,
2
my
weeks-
lords.
2 weeks to comply of.
My lords, kindly interim order may be extended, my
2
lords.
weeks to do the needful. Interim order granted earlier is extended till next date of it.
Grateful, your lords.
serial number 38, the party.
38, I am appearing for the petitioner, my lord. In this matter, my lord, respond number 5 is no more. LRs is already on record. Respond number 6 is the LR.
Who is
Then-
appearing for 6?
6. My lord, one submission, my lord, before that. My lord, one submission before that. Last date of hearing, my lord, there is a small error in the order. My lord, it has been stated, respond number 7 and 8 have been placed ex parte in the trial court. But they have not been placed ex parte, my lord. That may be recalled, my lord.
But I
You have
appear
to
for
file
the
an
respondent.
application.
I
My
appear
lord,
for the
they have not
respondent,
been
sir.
placed ex parte.
For that, you have to
My
file an
lord,
application for
it is a
recalling.
small.
No, this is an order of the, no, it is small.
No,
This
it is,
an
my lord, it is not order of the court. The learned counsel for the petitioner submits that respond number
That's
2,
why
7
this
and
court
8.
has passed an
I have,
order.
it is my,
Whatever this is order of the court, you have to file at least memo or something.
I'll
If one
file a
judge has
memo,
passed
my
an
lord.
order, other judge saying
I'll file a memo, my lord.
something has to be there.
Right
otherwise-
now, I'll file a memo, my lord.
Yes,
My lord, that may be recalled. I'll file a memo.
yes. Now, what is that? What else? What is that? Who is dead now? Who is dead?
Oliver Ireland is the son of the respond number 5, my
Which
lord.
respondent? I am asking?
Respond number 5,
Respondent number 5 is dead.
dead.
Who is his LRs?
Oliver Ireland is the respond number 6 is the LR, my lord.
No, what is the relationship?
Son,
Son.
son.
What about that other? His son is the only one son is there.
Two sons are there.
Then they have to be brought on record.
My lord, this is, we have only. On that application, we have not taken the.
Wait. See, now R5 is dead. Now they have to file an application. Now, that is arises only if they filed an application for bringing LRs. What is that? No, he died, she died in during the pendency of the suit itself.
Please, in the FDP, my lord. This is a matter concerning an
The
FDP.
FDP, they have already filed an application.
Please, so
Let us see if their whatever the order passed, who are the LRs, they same can be brought here.
Till such time, I am not bringing them as a LRs, my lord. This matter is filed only for the direction to dispose of the matter at the earliest. Because most of the parties have been died already. And then most of them are already 70 plus.
What is the matter which is pending before the trial court? FDP.
FDP, my lord.
No, now that prior is only to direct that trial court to dispose of the FDP.
please.
What is?
My lord. My lord.
Therefore, they want to track that suit as far as they can. The same person says, I'm far better than holder in the FD, but there he says, no, they hold the suit to the party.
Lord, one submission, my lord, here.
When that suit is pending, to say, finish off the FD, all these people, most of them are in front.
No, what is the stage in that FDP?
Commissioner's warrant has been issued.
Commissioner has executed his warrant, my lord. His report is yet to be placed. If I may take your lordship through the factual background. This is a suit amongst siblings filed in the year 2004. So there are 13 siblings and there was one patriarch, and the suit scheduled property is one item where one sibling amongst 13 contested that there was a will in his name. But then the trial court as well as the first appellate court held that there is no will and that the scheduled property be partitioned amongst the siblings. My lord, this decree, the preliminary decree, has been upheld by this court as well as the Honorable Supreme Court, and the suit is from the year 2004. And this being a contest amongst siblings, and there being only one party who's contesting the whole issue. Now, the rest of the
Suit is
siblings,
filed for what?
my lord, a partition.
Suit is filed for
A
partition.
partition in the year 2004 itself. That
Why can't you
preliminary
seek a
decree-
stay of that proceedings in the
My
FDP?
lord, one submission, my lord, here.
No, see,
Now, whoever
wait,
they're saying the
wait,
left out.
now, unless you get in a stay for proceedings of.
To avoid that from happening, the person who has represented himself as far better than holder, or the person who is in the US, all along after the Supreme Court. Now turns around and says, no, I don't have a power of attorney, which would amount to criminal contempt of court, because it means they misled the court all along. Nevertheless, the fact remains that those were children of a predeceased son. Therefore, they were they were not made parties there.
Well, the issue is simple.
They have
Our ಮಕ್ಕಳನ್ನ ಇವಾಗ
Wait,
FDP ನಲ್ಲಿ
mister.
ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
Wait,
One-
mister,
one
why
sub-
are you arguing on the very time saying that in that suit?
They have asked to stay in that suit.
No, what has happened to that application?
It is under the considerations. The matter has been heard partly.
Wait, mister,
I am for the
Wait,
plaintiff in that case.
This was a nevertheless, this was ordered to that party. It was not served so long, therefore that application
No,
was pending.
no, that ex parte order can be passed. Where is that? If Now also, if that, see.
Sir, memo, ಒಂದು sheet ಕೊಡಿ sir.
What they want is to press the FTP but not that.
No,
That
see,
is why this hit my lord.
now that suit is pending before the same court.
Same court.
No, you file a petition for seeking a direction, so consider your IA, will direct them, see. Unless FDP is stayed by that court, the FDP court cannot be proceeding, can be, now that you seek for an stay, otherwise, if the FDP proceedings is concluded, your suit will become infructuous. You sought for stay, if stay is not granted, you know that further proceedings where you have to go. Otherwise, if there is no stay, she is right to see that, to seek for an FDP to be concluded.
FTP can be concluded, we are not saying no, but what we are saying is the trial court has rightly posted both the cases on the same day.
No, that is true.
And the FTP is now pending for the LR application. The order sheet will show that in December, it was not the contest, not the plaintiffs in that suit, but the LRs or proposed LRs themselves who sought for an adjournment.
No, now this is only, no, Mr. Fernandez, this is only direction to dispose of. Please. LRs or respondent is not necessary. Please. Under 226, we can direct it. Therefore, but till that application to be decided for stay of that, you cannot say that it cannot be proceeded. You press for that application and take an order. When it is posted? 17th, you press for that your application.
One submission I want to
Submission
make,
on that.
my lord.
If that court granted an stay, then they have any remedy to do that, then this become infructuous.
One submission I want to.
Contention is that 2017 FDP is pending. Please. If court feels that without deciding that suit, FDP cannot be proceeded, let the court grant an order.
One submission I want to make, my lord.
Not say that, yes.
My lord, one submission I want to make in this matter. Whatever they are mentioning, OS 157 of 2023, that has been filed for the partition by the children of the predeceased son. He was left out in the original suit. One submission.
I understood you.
No, in that matter, we are saying no objection to grant one share.
Yes.
We are submitting, we have submitted already to grant one share, my lord.
Yes.
The suit can itself, it can be decreed.
Now that you are saying that respondent, which is that respondent?
The 8 and 7 and 8, my lord.
7 and
8.
Yes, learned counsel for the petitioner has filed a memo stating that recalling that order dated 28/11/2024 in respect of dispensation of notice to 7 and 8.
Please, my lord.
To that effect, order is recalled.
My lord, they have been placed ex parte anta agide, adondu. They have been placed ex parte anta agide, adanna they have not been placed ex parte in the trial court.
That's what I said, that
Please,
part
my
is
lord.
recalled.
Please, my lord.
Now that you have to take notice to 7 and 8.
Dispense agide notice.
You are appearing for?
The respondent numbers are 1, 4, 7 and 11.
What about 8?
8 ಗೆ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ. ಫಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲೇ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ ಬಿಕಾಸ್ ದೇ ಆರ್ ಸ್ಟೇಯಿಂಗ್ ಇನ್ ಅಬ್ರಾಡ್ ಅಂತ ಹೇಳಿ. ಬೇಡ ಅಂತ
Dispense
ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಫಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ my lord.
Where is that? Which is that date?
My lord, issue emergent notice to so and so. The learned counsel for the petitioner is permitted to serve the copies and then one submission, my lord. The week's time is granted. ಇಲ್ಲ dispense ಆಗಿತ್ತು.
Where is that?
We'll undertake to file wakalat, my lord, for
Yes.
R7 or 8 also.
Placing order dated so and so, placing ex parte before the trial court, the notice to respond, in respect of that order dated 20/11/2024. Council submission in respect of that respondent number 2, 7 and 8 were placed ex parte before the trial court.
2 has been placed ex parte.
In respect of 7 and 8, submission of the respondent for placing in ex parte and dispensation of notice to 7 and 8 is recalled. Learned counsel, so and so is undertake to appear for respondent number 7.
We filed our wakalat.
You have filed an
Please.
wakalat. Office is directed to show his name. Learned counsel for the petitioner is Praise week's time to take steps in respect of.
They are sailing with us only. We'll only file wakalat for ours.
ಆಯ್ತ್ರಿ, ನಾನು ಅದನ್ನ ಹೇಳಕ್ಕಾಗುತ್ತಾ? You are
Please
sailing
tell.
therefore, you file it
We'll
ವಕಾಲತ್.
we'll file wakalat.
To take
We'll
steps.
file wakalat.
Filed a memo on behalf of the respondent number 11. We also have a similar prayer that the FDP be
No,
concluded
have
in
you
a time.
filed for respondent number 7, you are appearing.
We are, on behalf of 11, have filed a memo,
Yes.
which is before your lordships.
11 ಗೆ ಏನಾಗಿದೆ ಇಲ್ಲಿ?
We are filing a memo to say, my lord, we have narrated the,
That, have you filed a wakalat?
please,
Here is that.
for 11. We have,
11.
it's showing in the cost.
No, why is that non-filing of wakalat ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ?
My lord, we have filed our call. We have filed our wakala. For 1, 4, 7 and 11, we have filed our wakala.
ವಕಾಲತ್ ಇದೆಯಾ?
My lord,
ವಕಾಲತ್ you have filed. ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದಾರಾ? Your name is shown.
Please, my colleague's name is shown.
Yes, no.
And we are filing a memo narrating the background of this matter and also praying that the FDP be concluded in a time-bound manner.
Yes, let them complete that. Yes.
my lord, ಈಗ ನಾವು OS ಅಲ್ಲಿ we have agreed to grant a stay. The OS itself can be, the suit itself can be decreed. ಹಂಗಂತ ಇದ್ದಾಗ, my lord, staying this FDP.
See, they have filed an application. It is for the court to decide. They have not passed whether stayed or not. If they pass any order, whoever agreed, they can be challenged. That's all. I am not said that staying that. When application is that, I am asking to press that.
FDP ಅಲ್ಲಿ ಎಂತ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅವರು.
He said suit he has filed.
ಸೂಟ್ ಅಲ್ಲಿ ನಾಟ್ ಟು ಏಲಿಯನೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
No, they have filed an application for.
ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ನಾಟ್ ಟು ಏಲಿಯನೇಟ್. ನಾಟ್ ಟು ಏಲಿಯನೇಟ್.
Application 1 you are not to alienate the property and other application for the state proceedings of the proceeding.
Then he has filed.
Both applications being heard, we have taken time to hear. I have concluded my arguments. And in fact, we are requesting.
Yes, you request for order on that. Then we will
It's an
decide.
application filed under order,
Yes, next
order 39 al agide.
Yes.
So predeceased
Let
children
the
are already
plaintiffs
on
complete.
record in the FDP.
Yes. ಆಯ್ತಪ್ಪ. Yes, you call next. Yes.
Serial number 39 adjourned, serial number 40, Pradeep Naik for petitioner, Sergeant, please, Sergeant.
The office noting is erroneous. Notice has not been issued to R1 to 4. In fact, R1 and 2 are on caveat and they are the only contesting respondents.
Lord, since I have filed caveat for R2, I will accept notice for R1. I will appear for both R1 and R2.
Trial court is requested not to insist the petitioner to file his additional written statement pursuant to the order into so on. So this petition before this court obtained the order from the Chief Justice if necessary. Is this petition before any other court after obtaining order from the Chief Justice if necessary, order dated, it shall continue till the petition. ಎಲ್ರಿ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಮತ್ತೆ ಪ್ರೋಸೆಸಿಂಗ್ ಅಂತ ಏನ್ ಇದು ಆಫೀಸ್ there is no order for issuing notice. Now you are appearing for the caveator.
Please.
For whom, Mr.?
R1 and R2 there.
Lord, I have filed caveat for R2. I will also take notice for R1.
As R3 to 25 may kindly be dispensed with.
Wait. Who is the plaintiff?
Lord, I am the plaintiff.
1, 2.
Respondent number 1, my lords, is the plaintiff.
How many plaintiffs are there?
One plaint.
One
The
plaintiff.
plaint was originally filed by respondent number 1 who had no cause of action. I filed an application under 711 for rejection of the plaint.
Yes.
When that application is heard, R2 who says he has the cause of action, he comes and files an impleading application.
Now that you are appearing for 1, 2?
Lord, I am appearing for 1 and 2.
1 and 2.
1 and 2.
What about that other?
3 to 25 are co-defendants. It's a suit for for defamation. So therefore, they are only formal parties. Notice may be dispensed.
You are
to
filing in a memo. Yes, file a memo.
I'll file a memo right away.
Yes. So and so learned counsel has filed in a memo seeking dispensation of notice to respondent number 3 to
25.
25. Memo is taken on record. Notice to respondent number 3 to 25 is dispensed at the risk of the petitioner. Now you are appearing for 1 and 2.
Please, my lords.
Yes.
For rest.
The caveator, serial number ಎಷ್ಟು ಇದೆ? Caveator 2 and 3 ಅಂತಿದೆ.
That's also an
Up
error.
to them, my lords. I filed
1 and
caveat.
2. Yes.
I have filed caveat for respond number 2. For 1, I'll take notice.
Yes.
I'll accept.
The
notice
so
for
and so learned counsel is undertake to appear for 1 and 2.
Please, my lords.
Yes. Then what is?
The suit has been filed by a party who had no cause of action. A claim is defamation
Yes.
against the husband.
Ready, my lords.
Husband is
Ready, my lords.
Post this matter for hearing because now the process is completed. Any date?
Any short date?
shortest statement.
What is that urgency in that? What is the?
Urgency is only that there is an interim order granted in their favor. The application for impleading has been allowed. The Honorable Court has directed me to file an additional written statement. My entire ground is that the suit itself must go because there's no cause of action. Therefore, to force me to file defense on merits against a party who was never a plaintiff should not arise. The Honorable Court has already passed an order that the trial court should not insist on filing of written statement. Therefore, any possible early date, there is an interim order granted to a party who had no right to seek it.
Lord.
No, only thing is that you are opposing impleading of that.
The suit has to go. The suit has to go because R1 has no right. Even her entire pleading is that my husband is defamed. So when we filed 711 saying there's no cause of action arising in your favor, husband comes and files an impleading application.
No, he wants to implead as an defendant.
Yes, but he cannot implead as a plaintiff. He wants to implead as a plaintiff and take on the cause of action as though he has filed the plaint.
Yes, yeah, he wants to implead proposed defendant antide.
Illa, he has applied as proposed and he has been impleaded as plaintiff number 2. That is what I have challenged.
You see that impugned order is page 32. Which is that order you are challenging? Page 32.
The impugned order, please, page 32.
You see that for proposed defendant number 2.
Page 40, your lordship, please see, my lords. Page 40.
For
Proposed,
impleading
that
the
is an,
applicant
I think, a
proposed
typographical error.
under
Page 40,
rules.
proposed applicant is permitted to come on record as plaintiff number 2.
Lord, Ganda, he was in jail. He was in custody. That time, why filed the suit? Then they raised a technical
We'll
point.
see whether
Still-
law permits for that.
It does not
That's
permit.
the only-
That's all.
that's the only a
The
point.
law is
That's
very
the only-
clear, it does not permit.
Yes.
And there are also judgments to say if the suit is filed by someone with no cause of action, it cannot be repaired by bringing a person.
That is
He
the
has to
only
file a
point.
fresh suit.
Supreme Court has said it is permissible. I'll show it.
That is the only a point. When do you
A
want?
short point. Any early possible date.
On 23rd, please, 23rd, yes, 23rd.
Great.
Reach this matter on 20. Now that the process is complete, please. Yes.
Deeply obliged.
Great, till number
Because there's an
41.
office objection that was raised on my, that noting is also there.
What is
One
that?
certified copy of annexures A and D, I had applied together. The stamp, the heading is there only on annexure A because I had to separate the two orders. The covering sheet is there only for annexure A. So an objection was raised.
Non-compliance of the office objection. What are that office objection?
As the annexure A, if your lordship sees at page 28,
Preamble portion of the annexure D to be furnished.
annexure D and annexure A were given to us,
Annexure A, same preamble filled to the said annexures. For this before the.
only the
Yes.
cause list, madams.
Yes, let us. Yes.
Please.
Please.
Serial number 41, Shivakumar N for petitioner.
Right, this is the matter which was
G. Hegde.
yesterday, without informing me, it was.
Who has taken the time?
Nobody is there.
Where is that council? Nobody has filed an wakalat. Yes.
Serial number 41.
For the petitioner minutes, we filed an NOC wakalat minutes. today
Yes,
morning.
yes.
So
yes.
therefore, yesterday morning, 10:30, we made a submission saying that, to seek time to file the.
But you
wakalat.
have not mentioned that you are filed on this thing because day before yesterday, there was an understanding that it has to be posted yesterday.
No, on
Yes.
sixth matter was listed.
Now that only condition order has been passed.
Yes,
Only subject to that payment of 5 crores.
subject, it is a successive default committed by the petitioner.
The petitioner, in order to show the bona fide, has agreed to pay the sum of rupees 5 crores to be respondent on or before. The learned counsel caveator agreed to above submitted, no circumstances time shall be extended beyond that so and so. The court dispose of petitioner, learned counsel for the petitioner submitted, petitioner would pay the sum of rupees. Learned counsel of petitioner and learned counsel of caveator respondent in the court was about to dispose of the petitioner. Yes, about to dispose, you have undertaken. that.
Yes, they are about to be dismissed.
Hmm.
At that point of time, it was, a proposal
But
was
no,
made.
In terms of
And-
that, I will dismiss it. You
No,
do.
no, I am not aware, my lords, as to what has, today morning I have got the wakalat.
No, that is not, we are not dismissing your case. We are dismissing the case of the petitioner. You are in a council on record.
In fact, the
No, no.
party was present.
This is how
the
that
other day.
party says playing that party was present. He said, I will engage in a council. When you are taking in a no objection brief, you have to say what has happened in the earlier proceedings and all. That is how that council's duty is that.
No,
It is
but
the-
kindly have it tomorrow afternoon, my lords, I will.
No, this is
what-
how that every day you are pushing that matter.
No, I was not aware, my lords, if that is the case, my lords, even I will also.
But when you are filing in a wakalat, see, if filing in a fresh case is easy. When you are filing in a wakalat NOC, you should be very careful.
Agree, my
This
lords.
is how that this is happening, this.
I was not aware, my lords, kindly have it tomorrow afternoon, my lords, 2:30.
Nothing happened for 1.5 years, and I don't know what will happen by one day, because substantial amount that's why I have submitted that successive default, not just before this court. In fact, before this honorable court, it is an undertaking given by him. And the relaxation was also given to him because I have been strongly opposed for this move. From April, August 2023, it's a decree on admission. It is not a contested matter.
Yes, that execution. No, that
Execution
if you-
illa ide.
If you don't want to, insist for the property for this
yes.
thing, you leave it.
And the
You have
trial
to-
court
You filed in a specific performance, they have agreed.
they have agreed, and time was granted. 2 months, again time was granted. Ultimately, we have filed a 28 application for rescission of the contract. That was done. But he filed
It has been challenged.
two writ petitions. The connected matter, what he has said is the granting of 1 month time, extended 1 month time was not sufficient. So that's why he has filed this writ petition, and in the first one is challenging the order passed in our favor under section 28(1) application.
This court,
No, kindly have it tomorrow, my lords, I will keep the petitioner present.
no, we need not wants to.
I filed my
Wakalat is
wakalat-
Filed, we need not.
No, no, I have filed my wakalat today, my lords, I have already filed my wakalat today.
No, before
I'll
that,
keep
you
the
should be very
petitioner present.
careful. He is playing with the court. He was there day after tomorrow before the court.
My lords,
He
I was
said,
not-
I will engage that council.
Lord, I was not aware, my lords, kindly have it tomorrow, my lords.
If it
Whatever-
were
I will record that and I will.
If it were to be any other facts, my lord, I would have,
On
said no. objection
18,
for my lord, that's,
2024. After hearing the parties, it's about to dispose of the petition. Learned counsel appearing for the petitioner submitted that petitioner would pay sum of rupees 14 crores 69 lakhs on or before 31st/1/2025. To show the bona fide, he has agreed to pay sum of rupees 5 crores on or before 5/1/2025. 5 ಕೋಟಿನೇ ಇನ್ನೊಂದು 15 ದಿನದಲ್ಲಿ can you give that 14 crores, Mr. Even when the matter is posted on 6/1/2024, they have not complied that order passed by this court.
Kindly observe that the advocate has,
On that day, the counsel who has undertaken before the court has filed an NOC.
please.
The party was present on that day on 6/1/2025.
No, no, NOC wakalat has been filed today, my lords.
Wait, Mr. On 6/1/2025, he prays 1 day time to engage the council. On 7/1/2025, without intimating that other side, in the 10:30, time was sought. Matter was urgent, granted week's time. Alva.
ಹೌದು.
Thereafter, respondent counsel has mentioned the
Post lunch session, my lord, I mentioned it.
post-lunch session. Thereafter, matter has been directed to post today. When the today's matter was called, so and so learned counsel arrested has appeared on NOC. And he submits that he was not aware of that earlier order passed by this court. He prays time till tomorrow.
Yes, my lord.
Please this matter tomorrow. Please, tomorrow, nothing doing, it will be dismissed. Only for your request, it is granting till
No, no, I
tomorrow.
am highly obliged.
Yes.
Worship's permission, my lord, the previous matter, the IO may be extended, ma'am. Serial number 40.
40,
40.
interim order granted earlier rejection. Yes.
Serial number 42. Ashok,
Appearing
Bunny.
for some urgency, my lord.
Hmm.
That will be called after the, immediately after service of the thing.
Awaiting service of notice to R4. Post immediately after service of
Interim
notice.
order to be extended.
Lazy.
Yes.
Only
May I make
short
one
point, my lord.
My lord. R4 is the formal party, my lord. It is in between the, my lord, plaintiff and the defendant number 1, my lord. It's regarding the impounding of the document I have produced, my lord. I am the plaintiff in the suit, my lord. I have, at the time of examination in chief of PW1, my lord.
No,
we
you are the
raised
plaintiff or a
objections.
defendant.
Is a plaintiff.
But I am the plaintiff.
Is
Your
plaintiff.
document has been impounded.
My lord.
Not impounded.
My lord, it is
There was
allowed.
a memo to that extent. There was earlier, there was an application has been filed by the plaintiff to refer this matter for impounding and to the registrar for the non-payment of GPA because it's an unregistered GPA. Thereafter, that question has been erased. Then he withdrew that IA by filing a memo to that effect, and the memo on the order has been passed. Kindly page number 19, my lord.
What is that order you are challenging? That
Order is, my lord, at page 21, my lord. There was an unregistered GPA. It's a matter of pertains to bare injunction suit, my lord. Basing on the unregistered GPA, subsequently, a registered deed has been executed on the strength of unregistered GPA. Now, in the course of evidence, my lord, that unregistered GPA came to be filed. Thereafter, an application has been filed to refer this matter of the unregistered GPA to the for the adjudication. Then again, the memo was filed to withdraw that IA. Then again, my lord, once again, basing on the memo, the trial court has proceeded further and heard this matter with regard to unregistered GPA, then passed an impugned order at page 25, my lord. The prayer of the LRs of plaintiff to permit them to mark the GPA dated, that is unregistered, my lord. GPA dated 7/9/1994 is allowed. That is unregistered GPA. The prayer of the defense to impound the said document is rejected.
No, that GPA is allowed.
Allowed,
Just
and it has been marked.
It already marked.
It has been marked.
It is observed that on execution of the sale deed which encompasses the term of the agreement of sale.
Reason is only for collateral purpose. Even if it is collateral purpose, so on the Supreme Court says, my lord, even if it is collateral purpose, it has to be stamped.
For an relief of permanent injunction. Then to be GPA. Yes, Mister.
My lord, in
Is
view
it
of,
not required for registration?
my lord, it is not required for registration, my lord. So far regarding the, my lord, impounding of document, my lord, the decision, my lord, the dishonorable court, my lord, recently passed. My lord, once the sale deed is executed, my lord, subsequently based upon the GPA or, my lord, agreement of sale, the GPA or sale agreement is redundant, heard by this honorable court in the June, my lord, I have, that decision has been referred in the order, my lord. My lord, may I, my lord, record. It's not necessary, my lord.
No, that
If
can that
Subsequent-
document, no, it can be marked.
It can be marked, my lord.
I'm sorry, my lord.
This judgment
Without, my lord, impounding of the, my lord,
There are a number of judgments.
my lord, in fact, my lord, the GPA is not the conveyance, my lord, it not required, my lord, registration. It's sufficiently, my lord, notarized, my lord, it is sufficient for that, my lord.
No, if you are says that GPA need not be registered,
Yes, my lord.
then you need not rely all these things. Why do you want to rely on these things once it has been sold it?
Because,
If
my
you
lord,
say
my
if
lord,
it is not registered, if you prove that, then therefore there is no question of impounding.
my lord,
What is, you have to be firm stand whether it requires to be registration or not. If requires to be registration, but after the sale date, even though if it is not registered, it is not a consequence anta andre, it is different argument. If the argument is it doesn't require for any registration, it is a different argument. Which are the points you have to be canvassed on that related judgment you have
my
to
lord,
place.
it is regarding, my lord, impounding of the document, my lord. My lord, that has been rejected, my lord. Their prior is rejected, my lord.
For you that documents, GPA, even if it is not registered, it can be filed in the court. It doesn't require for registration. Therefore, it cannot be impounded. Is it your contention?
No, no, no. That is not. They have not raised that point, my lord, in
I'm
the,
sorry, we
at
have
the
filed
time
an
of
application.
execution, my lord.
Sorry.
Registration ಬಗ್ಗೆ ಅವರೇನೆ ಚಕಾರ ಎತ್ತಿಲ್ಲ ಅವರು.
I'm sorry, madam.
Impounding of document.
No, if
And as
The
per my submission,
documents which require for registration, if it is not required, nobody can raise. It is a duty of the court to impound. That is
my lord,
what
it
law
is 94, my lord, it is executed in the year, my lord, 1994, my lord. At that time, my lord, my lord, it was executed in the stamp paper of 400 rupees, my lord. It is sufficient as per the law, my lord. My lord, if the GPA is, my lord, notarized, it is valid, my lord.
ಆಯ್ತು ರೀ, ಅದ್ರ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಮುಗಿಸಿ ಅಂತ.
My lordship are aware about in the
refer
case of
ಮಾಡಿದ್ದಾರೆ.
Savitrama's case, my lord, where court has clearly distinguished.
ಆಯ್ತಪ್ಪ, ಅವ್ರು ನನ್ನ ಕ್ವಶನ್ ಆನ್ಸರ್.
I'm sorry, ma'am. Sorry.
You place a judgment saying that 100 rupees stamp paper is enough, it cannot be registered ಅಂತ ಕೊಟ್ರೆ ಆಯ್ತಪ್ಪ ಅಲ್ಲಿಗೆ.
My lord, ಇಲ್ಲಿ ಓದ್ತೀನಿ ಮಾಡಿ. As for my lord, Article 41 power of attorney, my lord. Clause C, my lord.
ಕೊಡ್ರಿ.
My lord, clause A, when executed for the sole purpose of procuring the registration of one or more document in relation to a single transaction, or for admitting execution of one or more such document, 10 rupees, my lord. But clause B, when authorizing one person or more or to.
Court said it is not because of that this thing, not
Yes.
required for registration. They said
It is only for.
in view of that execution of the sale deed, it's become redundant.
Yes, my lord.
Now, it's become redundant. Can you place this as an marked as an
Exhibit, my lord.
My lord,
the issue? Here, that is issue has been considered.
my lord, that has not been considered because, my lord, it is only for the collateral purposes because of the subsequent sale deed, my lord. Execution of subsequent sale deed.
ನಿಮ್ಮ ಕೇಸಿನ ಫ್ಯಾಕ್ಟ್ಸ್ ಗೆ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಬೇಕು. See, you want to mark that documents. Can it be marked? You have to be placed in a judgment. That's all. Next week. See, mark ಮಾಡ್ದಾನೆ ಸುಮ್ಮನೆ ಡಾಕ್ಯುಮೆಂಟ್ ರಿಲೇ ಮಾಡೋದು, ಇಟ್ಸ್ ಇನ್ ಎ ಡಿಫರೆಂಟ್ ಥಿಂಗ್. ಅದಕ್ಕೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಕ್ಯಾನ್ ಬಿ ಅಪ್ಲೈಡ್ ಬಿಕಾಸ್ ಒನ್ಸ್ ಸೇಲ್ ಡೀಡ್ ಇಸ್ ಬಿನ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್, GPA is in consequence.
Yes.
You are not marking that.
Yes.
When you are marking a documents, GPA need not be registered, or after the sale deed, it can be marked without registration. Judgment ಕೊಟ್ರೆ ಮುಗಿತು. That is the point.
Yes, my lord.
Grateful.
My lord, ಇದು notarize ಆದ್ರೆ ಸಾಕು ಸ್ವಾಮಿ.
ಅಂತ ನೀವು
ಯಾಕಂದ್ರೆ
ತೋರಿಸ್ಬಿಟ್ಟು ನನಗೆ
as per the power of attorney rules, my lord, if it is executed, ಮಾಡ್ತೀವಿ.
ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್ ನೋಟರೈಸ್ ಆದ್ರೆ ಸಾಕು, ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಮಾರ್ಕ್ಡ್ ಅಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರೆ ಸಾಕು ಅಂತ ನಿನ್ಗೆ
Provision itself, my lord.
ಏನಂತ ಇತ್ತು ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ?
As power of attorney can be executed on the stamp paper of 100 rupees, my lord.
100 rupees can be marked.
At present, my lord.
See,
Earlier, my lord,
it can be executed by 100 rupees sale deed. 100 rupees this stamp paper. Can it be marked? That is the question you have to be answered and given a judgment. If it is marked under mugitapa. Yes.
My lord, date, my lord. Short date.
Next week.
Grateful.
next week.
Cell number 43.
ನಾನೇ ಕ್ವಶನ್ ಫಾರ್ಮ್ ಮಾಡಿ ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳು ಇದನ್ನ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಜಡ್ಜ್ಮೆಂಟ್. ದಿಸ್ ಇಸ್ ದ ಕ್ವಶನ್, ಯು ಹ್ಯಾವ್ ಟು ಗೆಟ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಆನ್. 2 ನಿಮಿಷದಲ್ಲಿ ನೀವು ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರೆ ಇವ್ರ ಕೇಸ್ ವಜಾ ಮಾಡ್ಬಿಟ್ಟು ಮನೆ ಕಳಿಸ್ತೀವಿ.
Interim order to be extended.
Yes, interim order granted earlier is extended till next date of hearing.
Grateful.
Proceedings may go, my lord. Proceedings continue ಆಗ್ಬೋದು.
ಏನ್ interim order ಕೊಟ್ಟಿದಾರೋ ಅದನ್ನೇ
Next week on date ಕೊಡಿ next month ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್. Next week ಬಂದ್ಬಿಡುತ್ತೆ.
ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ತಗೊಂಡ್ ಬನ್ನಿ ಮುಗಿಸ್ಬಿಡಿ.
Next week on date ಕೊಡಿ ಮೇಲೆ.
Yes.
Let me fix my date.
Next week ಬರುತ್ತೆ Thursday.
Grateful.
Cell number 43, Siddharth B. Muchandi.
My lord, one small submission, my lord. Serial number 27 of today's matter, my lord. That is WP 149 of 25. In this matter, office objection was raised, my lord. Morning we took permission to do compliance, my lord, but the file we haven't received it, and it's a little.
ಕಳಿಸಿದ್ದಾರೆ ಇವಾಗ. Now you do it. ಫೈಲ್ ಹೋಗಿರ್ಬೇಕಲ್ಲ. Now it has sent. You have to sign and send it.
Much.
Yes.
Cell number 43, Siddharth B. Muchandi.
I appear for the petitioners in this matter, your lords. For the directions of the court, a copy has been served on the counsel appearing for the respondent number 1 before the trial court, your lords.
I will undertake to file wakalat in this matter, my lords. Serial number 43 and 44, my lords.
You are appearing for whom?
My lord, respondent number 1, my lords.
Yes.
With respect to the respondent number 2 to 4, your lords. ಅದು ಏನಾಗಿದೆ ಅಂತ ಅಂದ್ರೆ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪಿಟಿಷನರ್ ನಂಬರ್ 3, ದಟ್ ಇಸ್ ಬಸವೇಶ್ವರ ಟಿಂಬರ್ಸ್, ಅದನ್ನ ಮಿಸಸ್ ಬಸವೇಶ್ವರ ಟಿಂಬರ್ಸ್, SB ಟಿಂಬರ್ಸ್ ಅಂತ they have repeatedly mentioned, so that may be dispensed of, your lords. Notice
ಏನಾಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ it is set for judgment. But my limited prayer in this writ petition is that, your lords, there are certain machinery. It's basically a sawmill. It's a suit for eviction.
Whether you want to issue a notice to them or you want to dispense.
Dispense.
For your
It may be dispensed of.
now that
2 to 4.
2 to 4.
Yes, your
File a memo.
I'll file a memo to that effect, your lords.
So and so learned counsel undertake to appear for respondent number 1. Counsel for the petitioner has filed a memo seeking dispensation of notice to 2 to 4. Memo is taken on record. Notice to 2 to 4 is dispensed. Yes. Yes. When do you want? You are ready, mister?
No, my lords, any date, my lords, next week.
Next week.
Next
Next week.
Yes.
Until then, the interim order may be extended, your lords. There's an interim order in both the petitions.
Yes. ಎರಡರಲ್ಲೂ same respondent.
ಎರಡರಲ್ಲೂ same respondents.
Same order.
But interim order was granted, my lords, subject to payment of arrears, my lords. They have not paid.
The dispute here is, your lords, with respect to the rents itself, your lords. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
From today shall also pay that twice the amount rent from July till that vacant. No, you have to pay, complaint.
I may be permitted to submit, your lords. ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಅಂದ್ರೆ I claim it is 40,000, but their claim it's 80,000. There is no written agreement. There was an arrangement between the petitioner herein and the respondent number 1's mother. So that is in dispute before the.
No, I am not on that. There is a court order. Have you deposited?
Whether 40,000 should be taken into consideration or 80,000 is to be. That is the question, your lord.
No, what is you have argued before that earlier bench? Earlier bench has said, pay the twice the amount of the rent from July. You have agreed. You are not argued there. Now you can't say such a thing. Now you have to comply that order. By changing the bench, you can't change that to your.
I'm not changing my stand, your lords, but problem is
there
that
should be a sanctity of that order passed by the court.
Certainly, your lords.
Just because some other judge has passed an order, I can't say that, no, mister. Have you complied this?
No, your lords, for the reason
there
that
is no extension of interim order.
for the reason that whether 40,000 has to be taken to
I
consideration,
don't know if
80,000
you have
as such
argued before the court. We have to say before the court, what is the twice? When you accept it before the court and saying something before this court, saying that not complied, what is this, mister? Yes. Please this matter of 2 weeks. Interim order extension illa. Yes. Great. Unless he has pointed out, you have not mentioned that I have not paid because of this reason. He has mentioned that interim order is not complied, so and so. This is not, you should be fair to that. First, you are officer of the court. Second, you are in representing that client, mister. You are all youngsters. Don't lost the confidence of the court. ಏನಿದೆ ಫಸ್ಟ್ ಹೇಳಬೇಕು. This is the confusion. ಏನಿದ್ರೆ it is between that. Either if you want to get a clarification, you have to file an application before the same court. You have to clarify. This is the doubts and all. Don't take. ನಮಗೆ ಇಷ್ಟು ಜನ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ, ಲೀಸ್ಟ್ ಫುಲ್ ಇದೆ, ಎಲ್ಲದೂ ನೋಡೋದಿಲ್ಲ ಅಂತ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. We hope that advocates will assist properly. Therefore, I am not seeing that any order sheet and all. Yes.
Serial number 45, KN Aravind.
Appear for petitioner here in the matter.
Yes.
I have complied with the copies have been served with to the lower court advocate as per the orders of this honorable court, and I have placed the records before this court, your honor.
But process is paid.
Process has already been paid, your honor.
But still it is not served. We have to wait for the service, mister.
Swami, ಅಲ್ಲಿ ಒಂದೇ ಒಂದು ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ 18/1 ಡೇಟ್ ಇದೆ. I have to comply the order by 18/1. At least stay ಕೊಟ್ರೆ ನನಗೆ ನಾನು ಇದು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
Now, why that last occasion you have insisted for stay, mister?
Stay insist ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ, but notice was ordered. At least may kindly turn to the page number 15, your honor. Exercise for power conferred under the plaintiff is ordered to be returned by the plaintiff on or before 18/1/2025.
Respond before the trial court.
At least stay ಕೊಟ್ಬಿಟ್ರೆ.
What is that, mister? Stay ಕೇಳ್ಬಿಟ್ರೆ ಕೊಡಕ್ಕಾಗಲ್ಲ. You have to argue, mister. What is your case? Yes.
I am the plaintiff before the lower court, your honor. I have filed a suit for declaration.
Yes.
It is an agriculture property.
Yes.
For the sake of pecuniary jurisdiction, I have invoked provision 2024A.
Now,
as it is an agriculture.
What is the order you are challenging?
The respondent number 4 has filed an IA seeking IA number 2 before the lower court, seeking the.
Mr. Counsel, return of
Yes,
the
sir.
plaintiff has been ordered. What is the stay you want, mister?
not,
Return of the plaintiff stay ಮಾಡಿದ್ರೆ proceedings will be continued tomorrow if it is dismissed. Therefore, earlier court has not granted. What is this? Yes. Avoid service of notice. PF ಕೊಟ್ಟಿಲ್ವಾ? You have not paid the PF.
I'll
Process
pay
continue. Yes,
sir.
each time is granted to pay the PF.
Serial number 46, Kumar SJ for petitioner.
My lords, in this case, appear for petitioner, my lords. In this case, I served the copy of the petition on the council appearing for respondent number 7, who is defendant number 4 in the suit, my lords. And on 30th itself, last month I have served, he has not put in appearance.
But we can't compel them to appear.
That's true, my lord.
Ah,
But
but
I have also
notice-
taken steps. But here, what has happened is, today the matter was posted before the trial court, my lord. It's
You have
posted
paid
for
the
our.
process.
Yes, my lord.
What is that urgency?
Because on 30th, because this month 16th, the matter is posted for argument.
What is
And
that? What is
today,
that?
I had filed the application for summoning of the document, my lords.
You are the plaintiff. or
I am the
defendant?
plaintiff in the case, my lords. I have filed the suit for partition separate portion. One, ordinarily Jairam was the plaintiff, my lord. Jairam died, my lords. These legal aids came on record and they have contesting the proceedings, my lord.
What is that application you have filed?
I filed the application to summon the ordinal sale deed, through which defendant number 4 is claiming title to the property. They say that my father had executed, he has put his signature. I am denying that my father has executed the signature.
Where is the order of the court?
My lords, annexure
Annexure J.
J, my lords. Here now the learned judge says, it can by summoning the document, it cannot be established that your father was suffering from paralysis. This is the finding, my lord. And certified copy has been produced.
Now matter is posted for what?
Argument, my lord. That's the reason, my lord. I'm seeking stay, my lord.
Yes. Stay of further proceeding. OS number
9436 of 2004, my lord.
pending in the file of
City Civil Court, Bangalore, my lords. Court
City
order 44.
Court shall raise City Civil Court allow City Civil Court of Bangalore.
City Civil Court 4. 53rd,
43rd additional
53rd
Civil
additional,
and
please.
Session Judge. Bangalore till next date of hearing.
Please.
Yes.
Hello.
Hearing interlocutory application matter, serial number 47, Ranganath R for appellant, connected matter, Vigneshwara U.
Senior bench. What is this matter, Mr. Sir? Who is appearing for
Manjunatha SV for appellant,
Ranganath?
I am Rangnath present. I am not representing 942.
Now, who has submitted that it is appellant in 942?
connected.
Yaradu?
Manjunath
Manjunath SV. Still is settling. Yes, what is that matter is under consideration of settlement? Yes, Mr. Yes. Where is that? You also get that Manjunath first. Yes. Manjunath SV. Yes. Leave this matter.
If it is better to refer for mediation if it's settlement.
ಆತರ ಇದ್ರೆ ಮಾಡೋಣ ಮಾಡ್ಕೊಳ್ಳೋದು. Yes.
All the parties
At the
are
request of the parties, Bangalore. At the request of the parties, refer this matter to Karnataka Mediation Center at Bangalore. When will be present? ಎಲ್ಲಿ ಎಲ್ಲ ಪಾರ್ಟಿ ಬೆಂಗಳೂರು or outside?
Let them be present on 13th minutes. ಇಲ್ಲಿ ಅವರೇನೆ ಎಲ್ಲ family.
Date ಹೇಳಿ.
13th, let them go. Minutes, let them.
16th ಆಗಲ್ಲ. 16th or 17th? 17th.
16th ಆಗ್ಬೋದು.
Parties
So that
are
when the matter
directed-
comes back before 24th or 25th, ಒಂದ್ ವಾರದಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ whether we can go ahead or not.
No, let us see. Once if it is progress is there, they will give some date and all. But you have to inform all the parties, Mr. Our Manjunath or whoever that parties are there, you have to. Yes, directed to be present before the Karnataka Mediation Center at Bangalore on 17th. Yes, office is directed to communicate this order.
3 PM.
3
PM.
At mediation center.
ಏನಿಲ್ಲ ನೀವು at 3 PM.
ಅಲ್ಲ ಅದು ಹೇಳಕ್ಕಾಗಲ್ಲ ಅಲ್ಲಿ. They will
ಯಾರಿಗೆ
fix the
ಹೋಗುತ್ತೆ,
time.
ಯಾರಿಗೆ
ಏನು
ಅಂತ
ಅನ್ನೋದು
ಗೊತ್ತಾಗ-
ಗೊತ್ತಾಗಲ್ಲ.
ಅಲ್ಲ
That day you present at 10:30, they will allot that.
They will allot it and then the parties ಹೋಗ್ತಾರೆ ನಾವೇನು
Yes.
ಅವಶ್ಯಕತೆ.
Yes.
Serial number 48,
47? 47.3 interim order granted earlier is extended till next date of it. It is better settled it, Mr. It's partition suits. Yes.
Serial number 48, Pattabisi for petitioner,
Petition in this case. my lord.
Priyanka.
The case filed with the respondent was specific performance agreement, my lord.
Hmm.
In respect of the 2 acres, 2¼ acres of agricultural land. For 76 lakhs, the agreement was entered.
No, you are,
Out
for-
of his
you are for
15
a plaintiff,
I'm for dependent, my lord.
dependent.
Yes, madam.
Yes.
76 lakhs is the sale consideration. 15 lakhs of advance has been paid. Within 3 months, they have to pay 61 lakh rupees. But he has not paid within 6 months. Immediately after next day of 3 months, they issued notice. Thereafter, within 15 days, they filed the suit. After 2.5 years, the matter was compromised. After the compromise, in the compromise, it is ordered within a month, he has to pay the 61 lakh. But he has not paid 2.5 years.
Hmm.
Thereafter, after 2.5 years, the matter was, he filed the execution petition. my lord. In that execution, at the time of filing execution petition, he has not deposited the amount. I filed section 28 of the application. On that day, he has not filed objection. He has filed objection. He has not deposited the amount. Then this honorable trial court has passed on a 2 months time giving to him. Hence, I am before this honorable court.
You are the degree
Kind-
holder.
My lord,
You are the degree holder.
Is the judgment.
I am the judgment debtor.
Judgment debtor. Yes.
I am the judgment debtor. I filed the 2 citations of this court. This honorable court advised me to pay 15 lakh plus 18% interest and referred the mediation to speak about subsequent payments, except that he should not speak anything, but it is decided 15 lakhs and 18% interest. I have to return.
My lord, that is an absolute untruth. Please see the order sheet.
No, there is no order sheet, but is the direction given by this
No
court.
direction was given, my lord.
In the
In fact-
mediation, in his colleague agreed, yes, it was the order.
So for the respondent is direct.
If you want to argue, no problem, but it was the order by this honorable court.
Why that there is a direction to place that article?
I produced
My lord,
few
I'll-
citations, I produced few citations, my lord.
No, no,
My
no,
lords,
earlier order.
Yes, I'll explain. And I have the RTCs. My lords, my lords, just one. My lords, what happens is in 2016, my lords, an agreement is entered into under which I pay a sum of rupees 15 lakhs as advance.
Yes.
And the property is supposed to be conveyed to me. Property is not conveyed. Immediately within 2 months, I file a suit for specific performance. Suit for specific performance is settled between the parties. Before it is settled between the parties, on 20th of July 2019, it is settled between the parties on it is set on 23rd of July. But before that, 3 days before that,
Yes.
a fresh agreement is entered into between the parties. Under the fresh agreement, my lords, the fresh agreement is produced, my lords, along with my statement of objections.
Yes.
Kindly see page number 16 of my statement of
Yes,
objections.
yes, you just.
My lords, I'll explain. My lords, under that, what we agree is, I will pay him 90 lakhs, not 76 lakhs. I will pay him 90 lakhs.
No, first you said 15 lakhs for advance
Advance had been paid.
But
So
what
the
is the
total consideration was 76 lakhs
earlier.
earlier,
Now it is enhanced to 90 lakhs.
enhanced to 90 lakhs.
Yes.
After it is enhanced to 90 lakhs, it is admitted that 35 lakhs advance has been paid. 90 lakhs only, 35 lakhs has been. Balance 55 lakhs had to be paid after he gets the Lebanese sketch for the property. He had to get the Lebanese sketch for the property. After he gets the Lebanese sketch for the property, she had to get Lebanese sketch. After she gets the Lebanese sketch for the property, I had to pay. Thereafter, on 23rd of July 2019, suit is compromised. When the suit is compromised, this agreementally 55 lakhs antiroda, they say no, 61 lakhs payment madbeku. Within 1 month, he shall get the Lebanese sketch, and thereafter I will and give me all the documents. Thereafter, I will
It's the
execute.
final. Now
That
you
is-
have
that
to
is
see
the-
that compromise degree.
Yes. No, my lord, this happens in July 2019. There is no Lebanese sketch obtained. Admitted fact, there is no Lebanese.
Now you come to that compromise degree
Compromise decree, my lords.
page
Compromise decree is at page 48 of the writ petition.
48.
Yes.
What are the conditions?
My lord, request my lord to kindly come to page number 40. I'm sorry, my lords, page number 40, my lords.
40.
Yes, my lords.
Yes.
It is ordered and decreed that as
So
per,
page number 40 is annexure D.
my lords, I'm sorry, page number 50, my lords, page number 50. There are multiple page numbers I got.
Yes.
Page number 50, my lords.
Yes.
My lords, it
Yes,
is
yes.
ordered and decreed that as per the terms of the compromise petition, the GPA holder of the defendant agreed to execute the sale deed in favor of the plaintiff within 1 month from 23/7/2019 by receiving balance sale consideration of 61 lakhs as the defendant has to obtain survey sketch in respect of the scheduled property for which the plaintiff has agreed for the same. If the defendant or the GPA holder do not come forward to execute the registered sale deed in favor of the plaintiff within that period, then the plaintiff has a right to execute the decree as per law. The defendant and the GPA holder have agreed to give all the original documents at the time of registration. Now, after this happens, my lords, in 2020, the defendant expires. 2021, the GPA holder of the defendant expires. Lebanese sketch is not open. I file an execution in March 2023. In that execution, they file an application under section 28 of the Specific Relief Act on 15/12/2022. In that application, they say that, but before that, my lords, what has happened is that in 2020 itself, when the defendant was alive itself, what the defendant does is she gifts half the property to her grandson. She gifts the other half of the property. She bequeaths the other half to her daughter-in-law. For that purpose, they get a Lebanese sketch. When they get a Lebanese sketch, I realized that this was during the COVID time. Immediately when the courts reopen after COVID, execution petition is filed. In the execution petition, they come and file this application. Now, my lords, may kindly see the finding of the trial court, my lords, at page number 26, my lords.
Yes.
I'm sorry, page number 24 onwards, my lords. May I request my lord to take. Section 28 is extracted.
Yes.
Upon a plain reading of the above provision, it is clear that when the court has fixed a fixed period for payment for balance sale consideration and which period has not been subsequently extended, despite which an amount paid by then the court with which the decree has been made has power to rescind the contract on the basis of default of decree holder. It is in this backdrop when the decree holder original suit is carefully gone through in page 3, they extracted that I have read, my lords. Now kindly see the finding, my lords. Upon reading of the above para, this court has made a direction to the JDR to register the sale deed within 1 month by receiving balance sale consideration and also directed obtain survey sketch in respect of suit property for execution of sale deed. As per the words of the decree, it is the JDR who has to arrange the survey sketch and be ready to execute the sale deed in favor of the plaintiff after receipt of balance sale consideration. But he has not complied with the same. He has issued notice to the DHR on 18/11/2019, which is almost after expiry of 3.5 months of decree, clearly shows the conduct of the JDR not to comply with the order of the compromise decree. Further, in the compromise decree, there is no direction to DHR to deposit the balance sale consideration within fixed period as required under the provision of law under section 20th of the Act to attract rescission of contract. Accordingly, the application filed by JDR is devoid of merits. Further, the subsequent agreement, which is entered before the compromise decree as averred by the DHR in the reply notice and objection has no force of law. This execution petition is filed on the basis of compromise decree and the said decree, which is a subsequent to an alleged sale agreement. As such, it has no force of law. There is already a compromise decree between DHR and GPA holder of JDR. Further, it is contended by JDR that DHR is deliberately evading to pay the balance sale consideration. As such, the contract required to be rescinded.
No, that application is rejected.
Then, not just rejected. There is a direction given to me to deposit 61 lakhs within 2 months, which I have complied. After I comply, they come before this honorable court. I think before I comply itself, they come before this honorable court. They obtain an order. Now, my lords, on this aspect, the law of the Supreme Court is that in an execution petition, he could not have filed the application under section 28. He was required.
Now you are not ready to execute the sale deed.
No, my lord, I am not ready to do
You are
that.
not ready.
Because already 7 years over.
Then we'll decide that matter on merit.
Yes, my lord.
Yes. Yes.
And the 11 case, what they are asking, my lord, that is at the time of registration. Before that, they should deposit the money.
No, forget everything.
Yes, my lord.
Your party is till today ready to execute that after taking that money? Yes. Otherwise, we will decide that on merit.
Yes, my lord.
I have already
And also,
deposited
I'm
the-
also requesting that the 2 citations are produced before. One is Supreme Court, one is our court.
We'll hear the matter on
Yes,
merit and
please,
decide.
please, my lord.
My lords,
Fix that. We will fix the date. Yes. Leave this matter on 20th.
Yes, my lord.
20th, 21st, can I request? 20th, I have something. 21st.
21st, yes, 21st.
Much.
21st will decide on merit. That's all. Whether such a application is maintainable or not. Yes.
They have an interim order in their favor.
Interim order granted earlier is extended till next date of it.
Cell number 49 adjourn.
ಇದು ಮೂಡ್ ಮೀಟರ್ 60. ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಬೇಸಿಕ್ಗಳನ್ನು ಮೂರು ಮಾತ್ರ 70 ಇರ್ತದೆ. ಆಟೋ ಲಿಸ್ಟ್ 60 ಒಳಗಡೆ ಬಂದಿರ್ತದೆ. ಇನ್ನೊಂದ್ಸರಿ ಮೂವ್ ಮಾಡಿಬಿಟ್ಟು ಅಥವಾ ಇದಿದ್ದು ಹಾಕ್ಬಿಟ್ಟು ಟೈಮ್ ತಗೊಳ್ಳಿಲ್ಲ. ಇವೆಲ್ಲ ಅದು ನಾವು ಡೇಟ್ ಕೊಟ್ಟವು ನಮ್ಮ ಮೂವ್ ಮಾಡಿದವು ಇದ್ರೆ ಇಟ್ ವಿಲ್ ಕ್ರಾಸ್ 70. Yes.
233 matter. Shivaram HC.
Petition. The petition has filed a suit for partition and separate possession.
Yes.
Time of filing the suit, your lordship. There is one gift deed executed by.
Wait, any caveat?
Caveat. You are not served with any copy.
Yes.
There is a gift deed said to have been executed by the
For
mother.
a plaintiff or a defendant?
Plaintiff, my lord.
Yes, suit for?
Suit for partition and separate possession of 1/4 share.
Yes.
One of the ancestral property, my lord, which was said to have been executed a gift deed
Yes.
in favor of one trust by the mother of the petitioner, your lordship, without taking consent of all the proportioners, your lordship.
Yes.
It has come to the notice of the petitioner, my lord, very recently. By that time, my lord, the evidence, everything was over. At that time, we filed an application for amendment. Seeking amendment, my lord, kindly see the amendment application, my lord, filed by me, my lord, annexure, page 5, my lord.
That you want to amend?
Amend to declare that the gift deed is not binding on us. That is the prayer, my lord.
Why it is rejected by the trial court?
Rejected, my lord, on the ground that, my lord, that the matter, page 54, my lord, may kindly see, my lord. After five to 6 lines. At the same time, with respect to gift deeds are concerned, in OS number 83/2001, we have not filed this suit. It was filed,
You want to stay of your own suit?
my lord.
Issue notice.
Yes, sir.
Stay of further proceedings in OS number 93 of 2018 pending in the file of
On the file of the
which court?
learned principal senior civil judge and CJM,
Principal Senior Civil Judge and CJM at Mandya.
Mandya.
Next date of hearing. Emergent notice.
Yes, sir. After appearance, it
What
could
is
be-
that office objection, mister?
Office objection, I will check up, my lord.
Next, sir, A series to be attested by the competent authority.
That I will check it up.
Further verification of the office. No, now that you get it attest.
No, my lord, I will get it.
Yes.
Get it now.
Subject to that only will issue that interim order.
No, I will just, if your lordship permit me, my lord, I will get it
Without
done.
attesting that documents.
I will get it
Yes.
done now itself.
Yes,
My lord, may order for end delivery, my lord, now itself I will get it.
yes. Well, when is that suit is posted? Tomorrow?
Actually, today, my lord, it is posted, your lordship. I told that matter will be taken up at 2:30.
Anyhow, your suit is going to stay that, what is that?
Well, after disposal, my lord, after appearance, my lord, it could be disposed
Yes,
of on
yes.
the day, my lord.
Yes, yes,
Please, I don't want to stall my proceedings.
yes.
B group matter. Serial number 50 adjourned. Serial number 51. Prithviraj BN for petitioner. Sandeep K.
Correspondent.
Transfer petition filed by the petitioner under section 24 before the district judge was dismissed. There were two suits. Partition suits filed by, one by the sister, one by the brother. Sister files a partition suit only with respect to 5 properties, leaving out many of the properties. So subsequently, I file a partition suit in Nagar Taluk, Nagar town. Sister had filed the suit in Mysore city. Most of the agriculture properties are situated in Nagar Taluk. There are about 12 properties in the 12 immovable properties in my suit. So I, for sake of convenience of parties, even for FDP and all, so I filed a transfer petition before the principal district judge Mysore, saying that it would be convenient if my sister's partition suit is,
ಏನಾಯ್ತು ಆಮೇಲೆ?
it was dismissed.
Transfer petition is dismissed.
Yes.
ಹಾ.
Only on the ground that my sister's partition suit is prior in point of time.
No, it should be CP.
ಅಲ್ಲಿ miscellaneous ಅಂತ ಏನೋ ಮಾಡ್ತಾರೆ.
Before principal
Miscellaneous,
district concession,
page 10.
civil petition, civil miscellaneous petition is fine, my lord. It
Before,
can be dismissed.
before senior civil judge.
Before principal district concession.
Within the district ಅಲ್ಲಿ under section 24 ಅಲ್ಲಿ district judge will have the powers.
Or you have filed it before the district judge. There it is dismissed.
It is dismissed.
Yes, where is that order?
Page 10, my lord.
Page number 13.
Why it is dismissed?
On the ground that sister has filed the suit prior in point of time.
In respect of same properties.
Please.
Only 5 properties. My sister's suit is at annexure B,
No,
page 14.
Your OS number?
My OS number is
48.
48.
48. Before which court?
Senior Civil Judge Karnataka.
KR Nagar. Your sister is filed where?
In
Before
first,
Mysore.
first
Senior Civil
additional
Judge,
Senior Civil Judge, Mysore,
OS number?
487 of 2019.
482.
487
of 90.
19.
2019. Mysore. Now that application, you have not sought for any transfer.
No, may I submit, my lord? My lord, respondent has filed in suit for partition and separate portion before the Mysore court in OS number 487 of 2019, wherein, my lord, the petitioner has appeared. He filed a written statement. Issues has been framed. Thereafter, he goes and files another suit before Karnataka Taluk.
No, that's why I'm asking, you have not sought for transfer of that.
Transfer
Then
of Karnataka.
I have not appeared before the Karnataka court. I have been placed ex parte, whereas my father hasn't appeared. He had filed an application under section 10 of CPC, which came to be stayed. Said order has been produced at annexure.
That suit is stayed.
Stayed, my lord.
My partition suit is,
At
further proceedings is
At
stayed
annexure H, my lord.
till my sister's partition suit is decided.
Then why do you want to press this, mister, for transfer?
ಅಲ್ಲ ಇವಾಗ ನನ್ನ ಸೂಟ್ಸ್ KR ನಗರದಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ. This honorable court has stayed the Mysore suit in this.
He has sought for
In
stay of
repetition,
this
ಈಗ ಎರಡು ಸೂಟು ಸ್ಟೇ ಆಗಿದೆ.
ಆಯ್ತು.
My lord, here both the parties resides
See,
in the same address in the Mysore.
Same, it is in respect of the same properties.
ಇಲ್ಲ. She has filed partition suit only for 5 properties,
You have filed it,
12 properties.
12 properties. Then what about that other shares?
Other shares, my lord, which are the self-acquired properties of my father, which was alienated by my father. During his
Instead of
lifetime.
that, will transfer that your case to Mysore,
My
mister.
lord, the problem of this respondent is, my lord, she is aged about 50 years.
No, I am asking that this case has to be transferred to Mysore.
Please, my lord.
I will seek it, sir. 1 week.
Better anyhow, you are there, will transfer instead of that case has to be stayed.
Yes.
Then
It has
you
to be
have to,
stayed, man.
you have to file an application for inclusion of other properties here.
That will
Either
become-
you will be permitted to include and that suit may be withdrawn.
I will seek it.
That, see, it's better.
Correct.
You
I agree.
withdraw the suit there.
Yes.
And I will permit you to file an application for including that properties which is not included by them.
Please, man.
Or lordship rightly pointed out, my suit can be transferred to Mysore.
cannot
KR
be
ನಗರದ-
two
KR
suits.
ನಗರದಿಂದ ಮೈಸೂರು ಸಿಟಿಗೆ ಹೋದ್ರೆ as it is.
Ali order passed staying that has not been challenged before me. Now that is the problem. Therefore I said. That is not challenged before that.
Can include those properties in this.
See, only problem is here only a 5 properties, there it is 12.
12.
There are other 7 properties is not there in this suit. You can file an application to include that properties also.
Yes.
Then can be, there all contention is left open. You can take a contention, it is a self-acquired or it is a gift properties, anything can be taken that contention. Only thing is that all properties should be there in that one suit.
The same has been opined in the impugned order, my lord.
Let us see, you take.
A
When do you
date
want?
may be given. my lord.
Next, week after next. Week
Date
after.
may be given.
Yes, at the request of the parties. Release this matter on 23rd.
Please.
Yes, interim order granted earlier is extended till next day.
Bill number 52, Prasanna VR for petitioner, Pratik KC.
Petitioner, my lord.
Hmm.
This writ petition is arised out of IA number 4 filed under section 10 of CPC, my lord.
Hmm.
The prayer in the CPC is that application is that stay of suit till disposal of SLP number 5828 of 22.
No,
Now
you are,
the SLP is disposed of, my lord, on 23.
Just now.
Therefore, the present writ
Not
petition
for
becomes
stay of the
infructuous.
suit, because one of them, not the property in the partition suit was subject matter before the SLP in Supreme Court.
Hmm.
So therefore, they sought for the stay of the suit. Now SLP is disposed before the.
now that application is rejected.
Yes.
Against that they have come. Yes.
Please, my lord.
Yes.
Now it becomes
It is
infructuous.
learned counsel for the party submitted that in view of the subsequent event, the writ petition will not survive for consideration. Accordingly, the writ petition is dismissed having become infructuous.
Please. my lord.
Bill number 53, Rangaramu V for petitioner, Syed Amir.
Lordship, may kindly have it next week, my lord.
Yes, Mr. Next week.
My lordship, the writ petition itself is not maintainable. They have not exhausted remedy. The honorable court has passed the order relying on the Supreme Court. It is an ex parte order. He can prefer a miscellaneous first appeal.
Can order challenge ಮಾಡಿದಾರೆ ಅವರು.
ಅವರು he claim rights without the existence of any right. Her.
What is that order you are challenging?
File 41-5. Next week it will.
ಅಲ್ಲ maintainability ಅನ್ನ ಹೇಳ್ತಾ ಇದ್ದಾರೆ letters.
ಬಗ್ಗೆ ಹೇಳ್ತೀನಿ ಫೈಲ್ ಬೇರೆ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮ್ಮ ಕೊಲೆಗೂ.
What is that order they are challenging?
They are challenging the order, order 41 rule 5, my lordship. He is said indigent person and seeking permission to permit the court to without paying court fee, claiming that he is facing economic hardship and he has filed a regular appeal before the honorable court. This 32 ಒಳಗೆ seek for that.
I think you have to file an appeal.
ಇಲ್ಲ sir, appeal ಅಲ್ಲ. ಇಲ್ಲಿ they have not given the order because of the reason they are.
Next week he wants to argue. Yes, let us.
Next week, sir.
Yes, at the request of counsel for the petitioner. Read this matter on 16th.
Very much.
16th. You get ready on that. What is that? You
Very much.
16th. On 15th.
Very much.
Yes.
Cell number 54, Venkatesh R. Bhagat, Narasimha Raju.
15th early, sir, because I got some other case in.
Yes, on 16th.
16th or 17th. Can we?
16th.
16th.
My lords, I am for the petitioner. I may be permitted to argue online, my lords.
Yes.
Yes, my lord.
Appearing for respondent.
Respondent. Yes, ready,
Yes.
Mr. Venkatesh.
That's when the short accommodation is given. I will come personally, my lord. Some 3 judgments has to be given. Short accommodation next week, my lord.
Yes, Mr. Yes, at the request of counsel for petitioner, release this matter next week.
Date.
One date. 20th.
Much obliged, my lord.
Almost a short question.
What is that?
Yes.
A person who is in permissive possession subsequently entered into an agreement of sale to purchase that bit of property. Possession granted permission earlier is also recited under the agreement of sale. Would it attract Article 51E or not? Trial court said it attracts, therefore you have to pay the stamp duty and penalty.
Yes.
That is under challenge.
Yes. Then
Yes.
where is the state?
State may not.
State has to be necessary. part of-
Normally they have to be heard.
Yes, where is the state? Our cursory. Government advocate.
Notice may be directed to take, we will serve the copy on.
Yes, government advocate is directed to take notice. Government advocate, yes, the learned counsel for the petitioner is directed to serve one set of copies on government advocate.
Yes, my lord.
Since matter is involved in payment of court fee.
Stamp duty, my lord. Stamp duty. Stamp duty.
Yes.
Stamp duty and penalty.
Stamp duty and penalty.
The issue relating to
Yes.
revenue of the state.
Yes. Therefore, notice has to be served to government advocate.
Yes.
Counsel for the petitioner is directed to serve one set of copies on government advocate.
Yes.
Either of them.
Stay may be kindly extended, my lord. Stay may be kindly
order
extended.
granted earlier is extended till next date of hearing.
Yes,
Office is directed to show the name of government advocate in the cost list.
Cell
Much
number
obliged, my
55, Rajeshwara PN for petitioner.
For
DP
petitioner,
Dinesh.
my lord.
ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ
Senior relative ಯಾರೋ ಸತ್ತೋಗಿದ್ದಾರೆ. Kindly have it next week, any date, my lord.
Yes, madam. You have any objection? No objection. Yes, at the request of counsel for the petitioner, leave this matter next week.
Serial number 56 adjourned. Serial number 57, Rahul S. Reddy for petitioner. Connected matter, Kumar JC.
Petitioners in
Mr.
this matter, my lords.
Hmm.
This petition, my lords.
Ready, madam? Yes, mister. She wants time.
Okay.
You have no objection?
No objection.
Yes. At the request of counsel for the respondent, leave this matter next week.
Interim order may be extended.
Interim order granted earlier is extended till next date of hearing.
Serial number 58, Vamshi Krishna C for petitioner.
Lords, I appear for the petition. I appear for the petitioner, my lords.
Hmm.
In this matter, the respondents have not filed their objections. This arises out of an execution matter, my lord.
Hmm.
So
Why do you worry about their objection, mister?
I understand, my lords. Now, any short accommodation next week, my lords, the senior will appear and argue.
If you want time, you ask the time, not for, this is not a writ petition. And
Right, my lord.
file an objection. Yes. At the request of counsel for the petitioner, leave this matter next week.
Serial number 59 adjourned. Serial number 60, Vijay Kumar K for petitioner. Serial number 60.
B group entry.
Ah, sir.
Service ಆಗಿದೆ notice respondent ಇದೆ.
Served on representatives.
Vijay Kumar.
Serial number 60, Vijay Kumar K.
ನೋಡಿ ಏನಾಗಿದೆ ನೋಡಿ ಸೂಟ್.
Serial number 61, B Ramesh for 61 Arjan. Serial number 62, Subramania R for petitioner, PM Siddamalappa.
Yes.
Petition numbers.
Where is Siddamalappa?
Serial number 62.
What is this, Mr.
Notes, this is a matter where,
Government
notes,
advocate.
the evidence of DW1 is discarded. And my lords, the application filed seeking restoration, my lords, and setting aside of the discarding of evidence and restoring, my lords, the evidence of DW1 that has been rejected, my lords.
Why discarded?
Lords, discarded, my lords, is that the dividend, my lords, DW1, my lords, could not be present for the reason that, my lords, she was on maternity leave. Lord, she was the engineer, my lords, in charge of that particular area, where, my lords, the petitioners, the respondents, my lords, are seeking for a direction, my lords, in a civil suit, seeking compensation, my lords, and also the, my lords, the cost of demolition of charges. Lords, so far as those evidences are concerned, my lords, the concerned engineer, my lords, would be, lords,
I think we'll permit you. Where is that? What is there? Instead of pending here from
yes, my lords.
thing, it could have been done.
Yes.
Now, what is the stage there?
My lords, the stage, my lords, is of DW1 evidence, my lords.
Where is other side?
Government advocate, PM Siddamalappa.
Government has no role. Only Siddamalappa is the this thing.
They have also arrayed, my lords, the government as a party in the proceedings, my lords, before the trial court. That is why, my lords, we have also arrayed them as a
No,
party.
now that he is the contestant.
Yes, my lord, contesting it. My lords, the order, my lords, is 3/2/2024 at page number 32.
Dismissed with the cost of rupees 1,000. Yes.
But thereafter, my lords, the
The reasoning given at this stage, entire order sheet is perused. It shows that from 2015 suit shall be filed. Already 9 years over. Now we will fix the date.
Yes, my lords.
On that day you present, let them cross-examine. and
Very well, my lords, very well.
Where is
My lords, kindly see, my lords, page 57, 56, 57, and my lords, 58.
Yes.
The justification, my lords, is that it is a statutory, my lords, leave that has to be granted. And my lords, she was on leave, my lords, till 22/2024.
What is the next date? When is that next date?
My lords, there is no next date, my lords, because the further proceedings are stayed.
Then we'll fix the date and ask them to present on the day. Let him
Please.
cross-examine. Where is he? We'll have it tomorrow.
Very well.
Yes. Leave this matter on tomorrow. That is the only, you get him, we will dispose of him.
Yes.
Serial number 60.
There is an interim order, my lords.
Interim order granted earlier is extended till next date of hearing. Leave this matter tomorrow.
Serial number 63, 64 Arjan. Serial number 65, Abhilash Raju for petitioner.
Respondent.
Not
aware of the urgency. Because of the urgency, my lord, I kept on moving. And the last 3 occasions also matter came, but unfortunately it got reached.
What is that matter, Mr.?
My lord,
You are appearing for petition.
my
Yes.
lord, this is regarding challenging the plenary jurisdiction before the senior civil judge.
Yes.
So it's been, it's only regarding the plenary jurisdiction.
Hmm.
And he has challenged the recital in the client saying that it is not affecting me. It's a daughter who's claiming the partition. And once she claims the partition suit, she has to narrate the history of the family. She has to narrate what is happening in the family. She has narrated the same incident in the client. That he says to discard. That the Honorable Trial Court rejected that application, number 1. That's IA number 4. IA number 3 is regarding the pecuniary jurisdiction. Pecuniary jurisdiction, it is allowed, saying that that should be treated as a preliminary issue and to take it up and tried immediately. So that's all, my lord. That has been challenged before the Supreme Court.
2 weeks. Somebody has mentioned and I have signed the order sheet also.
No problem. Send
No,
us, next week.
Now 2 weeks ಅಂತ ಹೇಳ್ಬಿಟ್ಟು it has been signed. ಅದು 2 weeks ಅಂತ ಅಂದ್ರೆ it should be posted on 22nd. It may come on 22nd, but one thing, 10:30 should be there.
I'll be.
Generally, maybe it may inconvenience to the advocates. I am granting an adjournment in the morning saying that instead of waiting for till end of that day, if there is any urgency, they can take any time. They are misusing this thing. If any counsel, if there is any urgency, if you have any doubt, you have to come and object for adjournment. I will not grant.
My cases will be there 10:30, rushing up to all the court.
See, otherwise, if I stop for adjournment, some of them is genuine cases are there for an adjournment. They have to wait. Therefore,
Date will be fixed and
maybe it will come on 22nd.
please, madam, date will be fixed, madam.
Yes, 22nd. You can put 2 weeks correct ಆಗುತ್ತೆ. 22nd, yes.
Lordship permission, may I make a submission, my lord? Serial number 60, I was late by a minute. My recall and reopen application is rejected.
Serial number
60, my lord. Can it be had on tomorrow, my lord? Respondent I was late by a minute, my lord.
Next week ಹೋಗಿದೆ.
ಅಲ್ಲ.
ಏನಾಗಿದೆ ಕೇಸ್ ಅದು?
Yes, it is for final arguments on 10-1. Can it be had on tomorrow, my lord? Nale.
ವಿಜಯ್ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ? ಅದರ್ ಸೈಡ್ ಯಾರಿದ್ದಾರೆ?
Notice ಆಗಿದೆ sir.
Third under
Sir,
present.
B group ಅಲ್ಲಿ ಇದೆ. ಅದಕ್ಕೆ.
Yes, it is passed over. Wait. Yes.
Serial number 65, Abhilash Raju for petitioner, CGSC.
Respondent, they had filed the similar application, which was rejected. That order has not been challenged. Matter was for final arguments.
That you just give that very facts.
I need some time because not even my objections have been placed on record. And earlier what they have filed, that also has not been placed on record. I would like to file it on Monday, maybe taken. They have not placed all the material before this court. It is a kind of submissions. How can we make it, minutes? This is a 227 jurisdiction. Papers are required to be looked into. That matter has been adjourned to 13. They have taken 6 adjournment for final arguments. Then they have filed this application. 2023 is the order.
When do you want?
Which order? Monday, man.
What is this matter?
Matter, my lords, they have sought for an application.
Recollect, it is for production of certain documents.
That documents.
That's a commercial court. I will demonstrate what is their case is, my lords. It is not the way it can be produced. That is their own document. They did not whisper. They
Sorry,
did not
what am I
file.
learned in saying, Lord? It is, we have shown in lordship what documents are there. It's not our documents, it's your
Because my
documents.
learned friend courteous approach was should have at least placed all the application filed, objection filed. Not even that. They are also same suppression. I will demonstrate. They are not entitled for that. Matter was put for final arguments. 6 adjournment they have taken.
25th November 24 is the order.
They want certain documents.
Their own documents.
No. If their own documents or it is your documents, it is available with you, has to be seen and pass an order.
I will make submission, manners.
Documents which is available with you, you are appearing for the central government.
Yes, ma'am.
You are an authority government.
No, it is a contract. It is a tender. It is not some document which is nothing to do with a public document. It's a tender document.
Tender documents between you.
Yes, it is all placed on record. He did not. I have placed in cross-examination more than 35 documents. He suppressed it.
He don't want 35 documents. He wants certain documents. Whether that documents is available with you or not, that issue.
My
If it
lords.
is available, you have to furnish. That's
My lords, firstly, 3 documents what he has sought, his own documents. Why he not produced? Because he is making an application at this juncture when the matter is posted for final hearing. Why I should produce? It is in his possession. Why did he not? He is not explaining that.
No, but
No.
you have that document.
Then it is his document. He has got, in his possession, he has got.
Not answering your lordship's question.
I am answering.
My learned friend can't refuse,
Answering.
being a
My
senior
learned
counsel
friend.
to not to answer the
My
question.
lords,
No, you
Under
have
the-
that document.
No, he has got his own document. Why I should
Okay.
produce?
No,
Then he
I
doesn't
want to
answer.
say,
Now,
he has that document.
Yes.
You have also have that
no,
document.
no, I have got a document copy. We has got a document original, whatever is there.
Ian,
One more thing, my lords.
When
First,
when do you want to?
kindly have it next week, my lords, I will place on record.
Yes.
It's a commercial court. They have made all statement. Now
there
they
is
can-
no special for commercial court.
No, it is a special for
Production-
commercial court with time bound.
No,
that is there
no,
is-
that is there.
Ah.
But production of the documents.
Production of the documents, even as far as commercial court proceedings are concerned, there is an amendment to CPC. We have to go by that only. There cannot be any leniency. And there is no reason for the plaintiff to say that I have in my personal property, the documents are there, you produce it.
15th.
15th.
The matter before the commercial court is coming on 13.
No, they have not said even the filing of the writ petition here. Man. Today only it has been mentioned. Court has adjourned, you place the material on record, we will adjourn it. They have taken more than 6 and adjourned for final year.
Adjournments, my lord friend
I
talking
am
about.
saying that.
I don't know what he's saying, Lord. All kinds of
Oh,
things he
you
says.
are also there in the party. You
Yes,
also
ma'am.
know that the writ petition is there.
Certainly.
Why that court?
I am not saying
The
that.
court wants to make an a party here.
Nothing.
Yes.
Not required.
They already told it morning, today it was there. Today they mentioned, court said that, okay, you place it on record, you will adjourn. Court has not adjourned already.
Place
Material-
that record that matter is.
They are supposed to place on account. They are also same thing they practice. They did not produce all the documents.
No,
That's it.
no, see, if you are objected that there is no writ petition is pending,
No.
then court can ask that to.
No,
produce
that is
any
not the
record.
issue. Today it was
What the
mentioned,
advocate said,
court adjourned. Today it was mentioned, it has been adjourned. No,
yes, on 15th,
15th.
yes. 15th.
Man had seen the cause this yesterday. My colleague's name has been printed. Kindly that may be deleted. It's
Yes,
Vishal Kumar.
office is directed to delete the name of
Mr.
Vishal
Vishal Kumar.
Kumar. Yes.
Obliged.
Yes.
Fast over matter.
Serial number.
Serial number 17.
67, sorry. 67.
Chandrachud, yeah.
Serial number 7 ಅಲ್ಲಿ ಇದೀವಿ. ಆಮೇಲೆ
It was, I was in the other.
67 ಏನಾಗಿತ್ರಿ? 67 ಇನ್ನು ಬಂದಿಲ್ಲ ತಡೀರಿ, ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ ತಗೊಂಡಿ.
ಅರ್ಜನ್ ಅಂತ ಹೇಳ್ತಾರೆ.
67 ಅರ್ಜನ್ ಆಗಿದೆ. 67 it is an parted matter
Yes,
before
it's
the
a
other
parted
court.
matter.
Then they have taken a time to place before the same judge. Yes.
Serial number 17. Yeah, Chandrachud.
Yes.
Note, this is the petition by the respondent here. On the application being orders on IN number 2, the
You are the
application
defendant.
was filed, I am the defendant here.
Yes.
I had filed a suit for declaration. I had filed an application under section 11 of CPC, res judicata, my lord. For the reason that earlier the son had filed the suit against the defendants, same defendants, but only the plaintiff is changed in this present suit, your honor. This is also suit for declaration.
What has happened that case?
Suit was dismissed, your honor.
On the ground that he has.
On
paid
the
the-
ground that the ancestors had executed the sale in favor of my father, and we are the 3 sons of our father. On the death of our father, we have got a partition deed executed in our family, and all the 3 brothers, that is the 3 defendants, are in peaceful possession and enjoyment.
No, but
Sale deed
your
is of the
father
year.
has purchased from
Yes,
them.
sale deed of the year 1958, your honor.
Then court has held that sale deed is valid.
Yes, your honor.
Now,
Yes,
what
your
is that contention in this plaint?
Now, the father now files a suit. During my lifetime, my son did not have the right to file that suit.
Adbidi, but the grievance is the same.
Yes,
That
that is all. That if your lordship please to appreciate, paragraph number 10, court comes to the conclusion that it is between the same parties. Ink page number 22 of the.
Could be the case. He has to challenge that.
Yes, your honor. That was exactly my case,
Yes.
and I had filed this application because it is burden. 7.5 years inquiry was conducted.
Trial court finding.
A trial court. If your lordship is pleased, directly I will read without wasting time. Page number 22 of my paper book, your honor.
Yes.
Paragraph number 10 of the trial court finding, conclusion findings. here.
Yes.
Admittedly, previous suit in OS number 1370 of 2017 was filed by the son of the present plaintiff, namely Mahesh, against the present defendant
in respect of the present suit schedule 40 for the relief of declaration of title and permanent injunction, claiming that he was the absolute owner of the suit schedule property, as it is his ancestral property. The said property belonged to one Venkatappa. After his death, Naga and Mutta became the owners of the said property. Therefore, it is crystal clear that the subject matter of OS and the suit in present suit and OS suit in OS 1370 are one and the same. Court admits, Your Honor. Further, the relief sought in the suit is permanent injunction and declaration to the effect that the judgment and decree in OS number so and so is not binding on the plaintiff herein. OS number 1370 for 2007 was for the relief of declaration and permanent injunction. Therefore, it is for a comprehensive suit. Hence, definitely competent.
There he sought that it is not binding on the plaintiff.
Yes.
That is there.
The judgment is already available. So until and unless.
No, now the question is.
He has to challenge that. He cannot say it is not binding. There are two different words, Your Honor.
That we have to see.
So let me read out res judicata, Your Honor.
Yes.
May I read res judicata? Yes. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any one of them claim litigating under the same title. It is the ancestors, Naga and Mutta. They sold it in favor of my father, Bette Gowda.
Or issue notice. Stay of
and more than one more thing I would like to bring it to you all. Even though the plaintiff is not insisting, I don't know, the court is insisting me, it is a senior citizen who is before the court, continuing with the case.
Case number 1261 of 2019, pending in the file of Principal Civil Judge, Bangalore, Rural District, Bangalore, till next date of year. Issue emergent notice.
Serial number 29.
Maybe I'll just take, I might be permitted to serve the copy on the trial court advocate.
Petition. The petitioner is permitted to serve a copy on the counsel appearing for respondent before.
Immediately after service of notice, it may be.
Remove that matter.
Yes, ma'am.
Serial number 29, Lakshmikant ke
29. With reference to the above, I humbly submit that we have received the transfer order CP that is for a transfer of MC from Davangere to family court. So, as the unfair communication is for the steps in which disposed of, which was intimated to the party regard by Really? The MC number 55 of 2022. The matter is posted today on the basis of the letter received by the registry dated 12/11/2022, received from Principal Judge Family Court, Mysore, dated 12/11/2024, seeking a clarification. This court by order dated 1st August 2024 has transferred that MC number 55 of 2022 pending in the file of Family Court Davangere to the 4th Additional Principal Judge Mysore on the ground that it caused inconvenience to that petitioner wife, since from Mysore to Davangere she has to travel 350 kilometers. It is not on the ground that Criminal Miscellaneous Petition 238 of 2022 is filed before the family court Mysore. Even though criminal miscellaneous 238 of 2022 has been disposed of, the family court Mysore can proceed in MC number 55 of 2022, which is transferred from family court Davangere. Yes. Registry is directed to communicate this order to Principal Judge Family Court Mysore.
Serial number 60, Vijay Kumar K.
For the petitioner in this matter, my lord. Petitioner has questioned the order at Annexure A. Petitioners are the defendants number 11 and 12 in a comprehensive.
What is that order you are challenging?
My recall and reopen application are dismissed, my lord. Impugned order is at Annexure A, page number 18 and 19. As on the date of passing of order, my lord.
For a plaintiff or a defendant?
Defendant, my lord. Defendant number 11.
I'm opening the stage of cross examination, the PW1. Yake cross examination madilla?
The only ground passing of the impugned order is that
Also filed.
it was a.
Now party can't contend that ವಕಾಲತಿ is filed. ಏನ್ರಿ
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಲ್ಲ 3 cases.
ಕಡೆಯಿಂದ ಹೇಳ್ಕೊಂತ ಹೋಗ್ತೀರಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ಗಳು ಡಿಸ್ಪೋಸ್ ಆಗಲ್ಲ ಪಾರ್ಟಿಗಳು ಹೇಳ್ತಾರೆ
One submission, major ground.
2006 ಇಂದ ಪಾರ್ಟಿಗಳು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಲ್ಲ, ರೀಕಾಲ್ ಮಾಡಿ ಕೊಡಿ ಅಂತ.
Major reason in this application is that suit is, it is posted for judgment ಅಂತ.
13 years in spite of being recorded is properly explained. In view of that, what is there?
One submission, man. One ground is that the case is posted for judgment and after passing of this order, the presiding officer has changed. Now the case is set down for arguments. That is one ground. And along with
No,
this.
presiding officer is transferred for 13 years.
No, now after passing of this order, my lord, and 3 cases were clubbed together. In one case, I am not a party. This is order is passed in one case and another case also I've had another writ petition. There are totally 3 cases. After clubbing of these cases, the client was unaware of the proceedings for some time. Hence, he could not have filed application on the meanwhile, my lord. So my only reason is now the presiding officer has changed and the case is now set down for arguments. If an opportunity is given, this is a comprehensive suit for declaration and cancellation of sale deeds, my lord. If date may be fixed.
This is not that, Mr. 1 year, 13 years, ನೀವು ಕೇಸ್ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು our purpose of filing the case, client will become
I
defeated.
clearly explained my reason in
So
the
all that
application, my lord.
Tactics played by that parties to delay that process.
Only after clubbing of this
Otherwise,
cases,
simply blaming the judicial officer saying that matter is not decided.
when this.
ಅವ್ರ ಪೇಪರ್ ಅಲ್ಲಿ ಕೇಸ್ಗಳಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತೀವಿ. These are all the reasons nobody knows.
But impugned order is passed only on the ground that the matter is set down for judgment. Thereafter, presiding officer.
ಆಯ್ತ್ರಿ, ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ಒಂದೇ ಗ್ರೌಂಡ್ ಅಲ್ರಿ, 13 ವರ್ಷ ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
My governments may kindly be seen, my lord. There are 3 cases clubbed together.
ಆಯ್ತ್ರಿ, 3 ಕೇಸ್ 13 ವರ್ಷ ಏನಾಗಿದೆ ಅಂತ ನೋಡಕ್ಕೂ ಹೋಗಲ್ವಾ ಪಾರ್ಟಿ?
3 cases, one case OS number 7. I am not a party at all, my lord. Trial was commenced in that case.
ನೀವು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿದಿರಾ, 13 ವರ್ಷ ಆದ್ರೂ ಕೋರ್ಟ್ ಮುಂದೆ ಕೇಸ್ ಬಂದಿಲ್ಲ ಅಂತ ನೋಡಕ್ಕೆ ಹೋಗೋದಿಲ್ವಾ?
But application all have taken.
You are not interested. ಈ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ 12 years ಇದೆ ನೋಡಿ. ಅವರು ಆತರ ನೀವು 12 ವರ್ಷ ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಡಿಕ್ಲೇರ್ ದಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ ಇದ್ರಲ್ಲೂ.
ಅಲ್ಲ, we are interested in only in respect of one property itself. That's just.
Yes, heard issue notice.
ಅಲ್ಲ, notice issue ಆಗಿದೆ. They are served unrepresented. It is listed in B group. Case is set down for 10-1 ಗೆ arguments ಗಿದೆ sir.
ಯಾವತ್ತಿಗೆ?
10ನೇ ತಾರೀಕು.
ಅವ್ರು ಯಾರು ಅಪಿಯರ್ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ, respondent number 1 is served unrepresented. Other respondent.
ಕೊಡಿ ಕಾಪಿ ಬರ್ಲಿ ಅವ್ರಿಗೆ.
Other respondent. Till that time and further proceedings may be stayed.
Respondent is served unrepresented. Learned counsel for the petitioner is directed to serve. ಈಗ ಸ್ಟೇ ಕೊಟ್ಬಿಟ್ಟು ಹೇಳಿದ್ರೆ ಬರ್ತಾರೆ. Heard issue notice. Respondent is served unrepresented. Notice ಆಗಿದೆ, notice ಬೇಡ.
ಆಗಿದೆ sir, respondent number 1 ಗೆ.
Further proceedings in OS number 9300
9,300
of 2006 pending in file of principal. ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ರೀ?
ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಗೂ ಸರ್ವ್ ಮಾಡಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕಿದೀವಿ ಸರ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ಇದೇ ಕೇಸಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಆಲ್ಸೋ ಇಸ್ ಫೈಲ್ಡ್ ಇನ್ ದ ಕೋರ್ಟ್.
They are not coming forward.
They are not coming forward.
ಆಯ್ತು ಕಳಿ.
On 99/24 itself, we have filed the acknowledgement.
IA defendant number 2 and 2 filed an application so and so in 17 for recall, reopen on the cross-examination of PW1. A suit for
declaration and cancellation of.
ಎಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಏನೋ ಕಂಪನಿ ಗಿಂಪನಿ ಎಲ್ಲ ಇದಾವಲ್ಲ ಏನಿದೆ
ಇಲ್ಲ, they are not, ನಾವು ಇದರಲ್ಲಿ respondent number 1 is the plaintiff. He alone has objected my application.
respondent number
Respondent number 1 is the plaintiff.
yes third in this case the defendant number 11 has filed this petition under 227 of Constitution of India challenging order dated 22/4
22/4/24.
22/4/2024 whereby 24th additional city civil and session judge has dismissed that IA filed under order 18 rule 17 of CPC in OS number 9300 of 2006. The respondent number 1 is the plaintiff has filed in a suit for
declarations.
Suit for
Declaration and possession. Declaration that plaintiff is the absolute owner in lawful possession.
declaration and possession.
He is in possession of somebody. He suit for declaration.
Suit for declaration.
And mandatory injunction
Service
and
of
other.
notice, respondent has appeared, defendant has appeared and filed in a written statement. The court has framed the issues. The plaintiff has examined PW1. Matter was posted for cross-examination of PW1 by the defendant. Even after giving in a sufficient opportunity, petitioner defendant has not cross-examined the PW1. Hence, discarded at PW1 evidence has been closed. Hence, evidence of PW1 has been closed. Thereafter, the petitioner has filed this application under order 18 rule 17. Petitioner defendant number 11 and 12 has filed an application under order 18 rule 17 for recall and reopen the case for cross-examination of PW1. The trial court has rejected the application, being agreed by the same. The defendant number 1 and 2, defendant number 11 and 2 before this court. The respondent has served unrepresented. Even copy has been served to the counsel appearing for the first respondent before the trial court. None appears. Heard the learned counsel for the appellant. The suit filed by the plaintiff is for a declaration in the year 2006. The plaintiff has examined as PW1. The time has been granted to cross-examine the PW1 by defendant number 1 and 2. The court has granted in a sufficient opportunity time to cross-examine the PW1 by defendant number 1 and 2. In spite of that, they have not cross-examined. The court has rightly, the evidence of PW1 has been closed. Be that as it may, I am of the opinion that to give one more opportunity to the plaintiff, the IA filed under order 18 rule 17 has to be allowed with imposing a cost. Accordingly, writ petition is allowed. Order dated so and so is set aside. The application filed by the defendant number 1 and 2 under order 18 rule 17 is allowed. Recall that order dated ಯಾವತ್ರಿ? ಏನು ಬರೀ recall ಅಂತ ಹೇಳಿದ್ರೆ
22/4/2024. ಅದಲ್ಲ.
ಕ್ಲೋಸ್ ಆಗಿರೋದು ಯಾವತ್ತಿನ ಆರ್ಡರ್?
ಹೇಳ್ತೀನಿ.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಐತ್ರಿ? ಏನ್ ಅವನ್ನೆಲ್ಲ ಬರ್ದಿಟ್ಕೊಂಡು ಹೇಳ್ಬೇಕ್ರಿ. ವೇರ್ ಇಸ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್?
Annexure email.
Annexure
5/7/2023.
ಪೇಜ್ ಅಲ್ರಿ?
110.
11
ಹೇಳಿದ್ದೀನಿ ಸರ್.
ಎಲ್ಲಿದೆ recalling? ಯಾವತ್ತು recalling ಆರ್ಡರ್?
For this note stated in the accompanying affidavit, this honorable court may please to recall the order dated 5/7/2023, posting the case for final
5/7/2023. Order dated 5/7/2023 is recalled. The defendant number 11 and 12 is permitted to cross-examine the PW1 in next date of hearing, which is fixed by the trial court. Without seeking any further adjournment, respondent has to, defendant number 1 and 2 has to cross-examine the PW1, subject to payment of cost of rupees 10,000 payable to the plaintiff.
No, we are defendants number 10, 11 and 12, my.
11 and 12.
11 and 12.
Yes, subject to payment of, yes. With that observation, petition is disposed of.
Final hearing matter, serial number 66, R. Vijay Kumar for appellant, M. Venugopal MS.
Yes,
Lordship,
Mr.
I appear for the appellants in this matter, your lordship.
And
In this-
appear for him only. I'm instructed to appear.
In that, you are for appellant, Mr. Counsel.
Yes, please, please.
Yes.
Senior is appearing through VC, your lordship.
Ready?
Your lordship,
Ready means it requires some time.
Yes, next week. Yes,
Next
at the
week.
request of counsel for the appellant. please this
Next week,
matter.
but 21st start.
After, release this matter after 2 weeks.
Please, 21st date may be given.
ಬರುತ್ತಲ್ಲ 21st ಅಲ್ಲ, ನಾವು RFA only Friday ಬರುತ್ತೆ, ಒಂದು
ಆಗ್ಲಿ, ಬರ್ಲಿ. Please.
Serial number 67.
ಕೊಟ್ರೆ ಒಳ್ಳೇದು.
ಅವ್ರು ಯಾವತ್ತು ಹೇಳಿದ್ರು? 21st ಅಲ್ಲ, 21st ಬರಲ್ಲ,
ಹಾ.
24th ಆಗ್ಬೋದು.
ಆಗ್ಲಿ ಸ್ವಾಮಿ.
ಆಗ್ಬೋದು. Yes,
ಆಗ್ಲಿ.
because RFA will be have it on 24th, because other
Please.
day writ petition matters are there.
Please, please.
Serial number 67 adjourned, serial number 68, Shankar Reddy for appellant, connected matter, Somashekar HM.
Appearing for appellant, grant 1 week time.
Yes, he wants time, Mr. At the request of counsel for.
My lord,
The
even
fixed date,
68,
my lordship. 2014, specific performance.
68.1 connected matter, my lord. In that admission is not taken. Even it can be taken as a final hearing.
Opposite for admission.
I think, yeah, why it is connected?
Same property, 2 suits.
ಅಂದ್ಮೇಲೆ ಇದ್ರನ್ನು
Same first matter, fixed date now.
Yes, fixed. At the request of counsel for the appellant. Leave this matter. ಯಾವತ್ ಬೇಕು?
Any day. Next week, any date.
Huh?
Next week, any date.
17. Applications ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದಾವಲ್ರಿ, ಏನದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್?
68.
Who is appearing for Somashekar HM?
Somashekar HM.
Process ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಅಲ್ಲ? ವೆರಿ ಈಸಿ.
ಅಲ್ಲ, ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಪೇರ್ ಆಗಿಲ್ಲ ಅಷ್ಟೇ.
Respondent, my lord. In second connected matter, we are respondent.
No, IA is filed for bringing LRs. Who is that?
Respondent number 3, sir.
Respondent number 3 is dead. Complete ಆಗಿಲ್ಲಲ್ಲ ಇನ್ನು. Yes, next date we'll see on that day. Yes. Let's ask the Somashekar to be present on that.
17.
Date fix ಮಾಡಿದ್ವಲ್ಲ 17.
Much of.
Serial number 69,
Appear for
Devaraj
appellant,
Ji.
senior Visharila, 2 weeks time.
The respondent members. They want time, not well.
Lord, the matter is adjourned, my lord. Only this time they have not mentioned at 10:30. Otherwise, my lord, we have had this problem, my lord, 2014 appeal.
You could
My
have
client-
informed in the morning that council.
ಬಂದಿರ್ಲಿಲ್ಲ ಅಂತ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ, ಸೀನಿಯರ್ ಕಾಲ್ ಕನೆಕ್ಟ್ ಆಗ್ತಾರಿಲ್ಲ, ಮನೇಲಿದ್ದಾರೆ.
ಆಯ್ತು, ನೀವು ನಾವು ಟೈಮ್ ತಗೊಂತೀವಿ ಅಂತ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ they could have attended other cases in other court.
ಅಲ್ಲ, my
ಅಂತ ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ, my lord.
My
Yes, Mr.
client, my lord, my client is very aged. He wants to see the end of this litigation, my lord. He does not want to pass it on to his children. Suit,
Yes.
my lord, for declaration with regard to a particular site, my lord, in Jayanagar, my lord, which is dismissed. There is no interim order, but this appeal, my lord, has been pending.
The suit for declaration is dismissed.
Dismissed by the plaintiff's appeal.
Then you are in the possession.
I am in possession, my lord. I am in possession. But my lord, he wants to see the end of the litigation in his lifetime.
At least that now the degree is in your favor. In some
Yes,
of the
yes.
cases, yes. Yes, next week.
Next week, my lord, kindly.
Yes,
Someday next week.
The appellant leaves this matter on 17th.
Grateful.
Yes.
Bill number 70, Manivandan G for appellant, connected matter, Zulfikar.
Lord, some appear for appellant. Parties are ready to settle the matters. Parties are ready to settle the matters. I seek
Next
for
week.
after 25th, my lords.
Yes, at the request of counsel for the appellant leaves this matter after 2 weeks.
Oblige, my lords.
Yes.
Lords, may I make one mention, my lords? My lords, I've just filed the writ petition. There is some urgency. The executing court has issued attachment of movables, and in spite of the company being struck off, and without the liquidator being made a party or the registrar of companies being made a party, the liability is sought to be fastened on the erstwhile director, my lords.
Day after tomorrow.
My lord, serial
Tomorrow
number
is already over, mister.
Day after
tomorrow.
my lord, serial number 58, interim order I forgot to submit, my lord, may be extended.
58 ಏನಾಯ್ತು?
My lord, I had sought time. My lord, interim order may be extended.
No, you could have asked at that time itself, mister.
My lord, my mistake, my lord, my humble request.
ಏನಾಗಿದೆ?
Next week ಅಂತ ಆಗಿದೆ.
ಅಲ್ಲ ಬರ್ದಾಗಿದ್ಯಾ? ಸೈನ್ ಆಗಿದ್ಯಾ? ಬರ್ದು ಬಿಟ್ಟೆ.
Lords, one request, my lords. I had moved a matter for tomorrow, my lords. I'm told there is some issue, my lords. My request that matter will be listed tomorrow. It's a trial matter is coming on Friday. There is some merging.
No, you have moved that matter. What is that problem?
I'm told, my lords, it's already in the board, my lords.
Huh.
I'm told they're saying list, there is it's being closed, something.
Then you have moved.
Today morning I moved, my lords, for two.
Then ಏನ್ ಬರ್ಲೇಬೇಕು. Morning move ಮಾಡಿದ್ರೆ what is their problem? They have to be posted. ಯಾಕೆ ಕೇಳ್ರಿ?
My lord, 2:30, the matter was listed, and tomorrow memo for posting. For hand delivery.
Hand delivery.
Hand delivery. Much of
ತೊಳಿ ನಿಮ್ ಕಾದ್ ಮುಚ್ಚಿಟ್ಟು ಬಂದಿದೆ ತೊಳಿ. ನಾಳೆಗೆ ಇರ್ಲಿ. ಯಾವ್ದು ಹೇಳಿ? ಇದೊಂದು ಸ್ಟಾಪ್ಲರ್ ಕೊಡು.
62 ಮತ್ತೆ 41.
ಹಾ.
ಅದಷ್ಟಕ್ಕೆ ಕೊಡಿ ಸೆಪರೇಟ್.
ಯಾವ್ದು ಈಗ ನೀವ್ ಯಾವ್ದು ಕೊಡಲ್ಲ ಅದು ಹೇಳ್ಬಿಡಿ, ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೇನೆ. ನೀವ್ ಯಾವ್ದು ಇವಾಗ ಕೊಡಲ್ಲ.
62 ರೆಡಿ ಇದೆ.
ಅಲ್ಲ ನೀವು ಯಾವ್ದು ನನಗೆ 41 ಕೊಡಲ್ವಾ? ಅದ್ ನಾನು ರಿಪೀಟ್ ಮಾಡಿಸ್ಕೊಬೇಕು, ಬೆಳಿಗ್ಗೆ ನೀವು ಕೊಡ್ಬೇಕು 41. ಆಮೇಲೆ
62 ಇದೆ.
ಹಾ ಕೊಡ್ತೀನಿ, ಆಯ್ತು. ಆಮೇಲೆ ಇದ್ರಲ್ಲಿ ಅದೇ ಅವರು ರವಿ ಸಬ್ಮಿಟ್ ಮಾಡೋದು 22 ಅಂತ ಬರೀಬೇಕು ಡೇಟ್. ಇನ್ನೊಂದು ಬರ್ಬಿಟ್ಟು ಲೇಟರ್ 4:30 22 ಅಂತ ಮಾಡಿ. 30 63 22 ಎಕ್ಸಾಕ್ಟ್ ಆಗಿ 2 ವೀಕ್ಸ್ಗೆ 22 ಅಂತಾನೆ ಮಾಡ್ಬೇಕು. ಏನ್ ಹೇಳಿ? ನೀವು ಮಾಡಿದ್ರೆ ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ. ಹಾಕೋದು ಬಿಡೋದು ಅವ್ರಿಗೆ ಸೇರಿದ್ದು. ಅವ್ರ ಅದನ್ನೇ ಇವ್ರೆ, ನಾನು ಅದನ್ನ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ. ಹಾಕೋದು ಬಿಡೋದು ಅವ್ರಿಗೆ ಸೇರಿದ್ದು. ನಾನು ತಿರ್ಗಾ ಅಲ್ಲಿ ಹೋಗಿ ನಿಂತ್ಕೊಂಡು ಹೇಳಲ್ಲ ಅವ್ರಿಗೆ. ನಾನು ಹೇಳೋದಲ್ಲ, ಅದನ್ನೇ ಹೇಳ್ತೀನಿ ನಾನು. ಹಾಗೆ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಹಾಕ್ತಿರಿ ಅಂತ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. ಲೀಸ್ಟ್ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದೇ ನೀವು ಅವ್ರು ಸರಿಯಾಗಿ ಹೇಳಲಿಲ್ಲ. ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆ ಅಂತ ಅವ್ರು ಹೇಳಿರೋದು ಬೋರ್ಡ್ನವ್ರು. ಟೈಮ್ ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋಗಿರೋ ಲೀಸ್ಟ್ಗೆ ಇವಾಗ ನಾವೇನ್ ಮಾಡೋಣ?
ಸರ್ 3:30 ಅಂತಂದ್ರೆ ಬೆಳಗ್ಗೆ ಫೈಲ್ ಮಾಡಿ ಮೂವ್ ಮಾಡಿದ್ವಿ. 3:30 ಅಂದ್ರೆ ಕೆಲಸ
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಲ್ಲ, ಅದು CJ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಬೇಗ ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಅಂತ CJ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇರ್ತದೆ. ಇವರು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ. ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ವಿ, ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ನೀವ್ ಹೇಳಿದ್ರಿ. ಅವ್ರು ಅದಕ್ಕೆ ಆಯ್ತು ಹೇಳಪ್ಪ, ಹಂಗೆ ಹೇಳು. ನಾನು ಹಾಗೆ ಹೇಳ್ತೀನಿ ಅವ್ರಿಗೀಗ. ಅವ್ರು ಹೇಳಿದಾರೆ ಸಾಹೇಬ್ರು ಹಾಕಿ ಅಂತ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. ಅದನ್ನೇ ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೇನೆ. ಮೇಡಮ್ ಇವ್ರು ಮೂವ್ ಮಾಡಿದ್ದು ಬೆಳಗ್ಗೆ, ಫೈಲ್ ಹೋಗಿರೋದು ಲೇಟು, ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ಇವ್ರು ಮಧ್ಯಾಹ್ನ ಬಂದು ನನಗೆ ಹೇಳಿದ್ರು, ತಿರುಗಿ ಇಮಿಡಿಯೇಟ್ ಆಗೋದು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆ ಸರ್, CJ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಈಗ ಇವರು ಅದನ್ನ
ನಾವು ಇವಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲಿಲ್ವಾ? ಸರ್ ಅವ್ರಿಗೆ ಹೇಳಿಲ್ವಾ?
CJ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆ ಅಂತಿದ್ರೆ ಅವಾಗ ಅವರು ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತಿದ್ರೆ
ಅದೇ ಆದ್ರೆ
ನೀವು ಹೇಳ್ತಿರೋ ಇಲ್ವೋ? ನಾವು ಅದನ್ನ
ಯಾರಿಗೆ?
ಈ ಬೋರ್ಡಿಗೆ.
ಬೋರ್ಡ್ಗೂ ಹೇಳಾಯ್ತು, ಅವ್ರಿಗೂ ಹೇಳಾಯ್ತು. ಬೋರ್ಡ್ ನಾನು ಅವಾಗ್ಲೇ ಹೇಳಾಯ್ತು, ನೀವು ಹೇಳ್ದಾಗ್ಲೇನೆ ಹೇಳಾಯ್ತು ಹಾಕಪ್ಪ ಅವ್ರು ಓಡಾಡ್ತಾ ಇದಾರೆ ಅಂತ. ಅವ್ರ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆ ಸರ್, ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದನ್ನೇ ನಾನು ನಿಮ್ಗೆ ಹೇಳಿದ್ದು.
OS number 139 was list ಆಗಿತ್ತು ಕಂಪ್ಲೇಂಟ್ಸ್. ಕಂಪ್ಲೇಂಟ್ಸ್ ಫೈಲ್ ಕೊಡ್ತಾ ಇಲ್ಲ
ಎಲ್ಲ ನಾನು ಹೇಳಕ್ಕಾಗಲ್ಲ. ನಾನು ಏನಂತ ಹೇಳಲೆ, ಕೊಡ್ತಾರೆ ನಾಳೆ ಕೊಡ್ತಾರೆ, ಈಗ ಹೋದ್ರೆ ಕೊಡ್ತಾರೆ ಅವರು. ಆಗ 4:40 ಈಗ ಕೊಟ್ರೆ ಪಾಪ ಅವ್ರ ಮನೆಗೆ ಹೋಗೋದ್ ಬೇಡವಾ?
ವೆಕೇಶನ್ ಪೋರ್ಟಲ್
ಏನ್ ಮ್ಯಾಟರ್? ನಾವ್ ವೆಕೇಶನ್ ಕೊಟ್ಟು ನಾವ್ ಇರ್ಲಿಲ್ಲ
ಇಲ್ಲಿ ಕೇಳಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅದೇಮ್ಮ, ನಾವಿರ್ಲಿಲ್ಲ ಅವಾಗ. ಇದು ಪೋರ್ಟಲ್, ವೆಕೇಶನ್ ಪೋರ್ಟಲ್ ಇತ್ತು. ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಯಾರಿದ್ರು ನೋಡ್ಕೊಂಡು ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು. ಈಗ ಇದು ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್, ಇದು ವೆಕೇಶನ್ ಕೋರ್ಟ್ ಅಲ್ಲ. ನಾವಿರ್ಲಿಲ್ಲ.
ಮತ್ತೆ ಯಾರನ್ನ ಕೇಳೋದು ಸರ್?
ಬೆಂಚ್ ಮೇಡಮ್, 5ನೇ ಕೊಟ್ಟಲ್ ಬೆಂಚ್. ಚೇಂಬರ್ ಹೋಗಿ ಸೀದಾ ಚೇಂಬರ್ ಹೋಗಿ ನಾವು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇಲ್ಲಿ
ಕೋರ್ಟಲ್ 5 ಅಲ್ಲಿ ಕೇಳಬೇಕು. ಓಕೆ ಸರ್.
ಡೇಟು ಫಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್, ಸೆಕೆಂಡ್ ಇಂಪಾರ್ಟೆಂಟ್. ಮೆಮೊ ಇದ್ದಾಗ ಅದ್ರಲ್ಲಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಬೆಳಿಗ್ಗೆ ತೀರೋಗ್ತಾರೆ ಅಂತ ಅರ್ಥ. ಯಾಕಪ್ಪ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತೀರಾ, ಇಲ್ಲಿ ಬಂದು ಅವ್ರು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ತಾರೆ, ಸಾಹೇಬ್ರು ನನ್ಗೆ ಹೇಳ್ತಾರೆ, ಸಾಹೇಬ್ರ ಹತ್ರ ಅವ್ರ ನಾನು ನಿಮಗೆ ಬೆಳಿಗ್ಗೆ ಅಲ್ಲ, ನಾನು ಹಿಂದಿನ ಇದ್ರಲ್ಲೂ ಹೇಳಿದ್ದೀನಿ ಇಂಪಾರ್ಟೆಂಟ್ ಯಾವ್ದು ಕೊಡಬೇಕು, ಡೇಟ್ ಕೊಡಬೇಕು, ಕೋರ್ಟ್ ಮೆಮೊ ಕೊಡಬೇಕು. ಕೋರ್ಟ್ ಮೆಮೊದಲ್ಲಿ ಹಿಂದೆ ನಾನು ಏನಾದ್ರು ರೆಡ್ಡಿಂಗ್ ಕಲ್ ಬರ್ದಿದ್ದೀನಿ ಅಂದ್ರೆ ಅದು ನನ್ನ ಮಕ್ಕಳು ಟಿಗಿ ಆಗ್ತಾ ಇರ್ತದೆ ಅಂತ. ಮತ್ತೆ ಅಂತದನ್ನ ಯಾಕೆ ನಿಮ್ಗೆ ಯಾವ ಬಂದು ಬೋರ್ಡ್ ಮೇಲೆ
ಫೈಲ್ ಸಿಗ್ತಿಲ್ಲ ಅಂತ
ಆ ಮೆಮೊದಲ್ಲಿ ಫ್ಯೂಚರ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ ತೆಗೆದು ಬಿಡೋದು. ಅವನು ಯಾವ ಸರಿ ಆಯ್ತು 65 ನಾನು ರಿಸ್ಕ್ ತಗೊಂಡು ನಾಳೆ ರೆಡ್ಡಿಂಗ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ, ಅದನ್ನ ಯಾವ್ದೋ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೆ ಅಂತ ಅವನು ನಂಬರ್ ಕೊಡ್ಲಿಲ್ಲ. ಮಧ್ಯಾಹ್ನ 3:15 ಬಂದ. ಅವ್ನು ಯಾರೀಗ ಸಬ್ಮಿಟ್ ಮಾಡ್ದ ಅಂತ ಕೇಳೋ ಕೋರ್ಟ್ದಾಗ ಹೋಗಿ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ಯಾ ಅಂತ. ಹಾ ಹಲೋ, ನೀವೇನ ಮಾತಾಡಿದ್ದೀಗ ಸಾಹೇಬ್ರ ಹತ್ರ ಕೋರ್ಟಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಹಾ ಮತ್ತೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರಂತಲ್ಲ ನಿಮ್ಗೆ ಲೀಸ್ಟ್ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆ. ಹಾ 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 ಮತ್ತೆ ಅದಕ್ಕೆ ಬಂದಿತ್ತು ಅದಕ್ಕೆ ಅಂತ ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ, ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆ ಅಂತ ನಾವು ನಾಳೆ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು. ಅದು ನನಗ್ ಗೊತ್ತಾ ಸರ್, ನನಗ್ ಗೊತ್ತಾ ಅವ್ರಿಗೆ CJ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಏನಿರ್ತದೋ. ಹಾ ಹಂಗಲ್ಲ, ನೀವು ಹೇಳುವಾಗ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ಸಾಹೇಬ್ರಿಗೆ. ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳಿದ್ರು ನೋಡ್ರಿ, ಮೆಮೋ ಮೂವ್ ಮಾಡಿದ್ಮೇಲೆ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅವ್ರು ಅಂತ ಅಂದ್ರು. ಕರೆಕ್ಟಾ? ಹಾ, ಪೋಸ್ಟ್ ಆಗಕ್ಕೆ ಅಲ್ಲಿ ಲೀಸ್ಟ್ ಇದ್ರೆ ಅಲ್ವಾ ಪೋಸ್ಟ್ ಆಗೋದು, ಕಾಮನ್ ಸೆನ್ಸ್ ಅಲ್ಲಿ ಸರ್. ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗೋದಿದೆ ಸ್ವಾಮಿ, ನಿಮ್ಗೆ ಏನ್ ಹೇಳಿದ್ರು ಅದನ್ನ ನಾನು ಹೇಳ್ಬೇಕು ಸಾಹೇಬ್ರಿಗೆ. ಅವಾಗ ಅವರು ಲೀಸ್ಟ್ 2 ಮಾಡಿ ಅಂತಾರ, 3 ಮಾಡಿ ಅಂತಾರ. ಹಾ ನಾವ್ ಹೇಳಾಯ್ತು ಅವ್ರಿಗೆ, ಅದನ್ನೇ ಅವ್ರು ನನಗೆ ರಿವರ್ಸ್ ಹೇಳ್ತಾ ಇದಾರೆ. ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿದೆ ನಾವು ಅವ್ರಿಗೆ ಹೇಳಿದ್ವಿ, ಬಿಡಿ ನೀವು ಫೋನ್ ಇಡಿ ಅಂತ. ಆಯ್ತು ಬಿಡಿ ಬಿಡಿ ಆಯ್ತು. ಯಾವ್ದಪ್ಪ?
Party one connected case ಇದೆ.
ಆಮೇಲೆ
62.
ವಿಷುವಲ್ ಕೊಡಿ ಸರ್. ಹಲೋ, ಪಾರ್ಟಿ ಅಭಿವೃದ್ಧಿ 32913. connected with the 308424. ಇದು ನಾಳೆ ಕೊಡ್ಬೇಕು. ಇವಾಗ ನಂಬರ್ ಇದೆ ಕಳ್ಸಲ್ ಮತ್ತೆ ಫೋನ್ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ ಇನ್ಯಾವುದಪ್ಪ 41 ಮತ್ತೆ 62 ಸೀರಿಯಲ್ ನಂಬರ್ 62 W27599 24 ನಾಳೆ. ಇದು ರಿಪೀಟ್ ಇದನ್ನ ಓದ್ ಹಾಕ್ಬೇಡ. ಅದೇನ ನಾನು ಹೇಳ್ತೀನಿ ಹೋದಾಗ ಹಾಕಲ್ಲ ಕರೆಕ್ಟಾ? ಇದೇನು ಹೇಳ್ಬೇಕು ಸರಿ, ಹಂಗೇನಾದ್ರು ಕನ್ಸಿದ್ರೆ ಇದು 4 ಹೆಚ್ಚಿಗೆ ಆಯ್ತು. ನಾನು ಎಷ್ಟಾಗ್ಬೋದು ಹೆಚ್ಚಿಗೆ? ಆಯ್ತು
Repeat that.
ಏನಲ್ಲ ತಪ್ಪಾಗಿ ನಾ ಹೇಳಿದ್ರೆ ಇಲ್ಲ ತಪ್ಪಾಗಿ ನಾ ಹೇಳಿದ್ರೆ
ಕೂಗಾಡ್ಬೇಕು, ನೀವು ಕೂಗಾಡ್ತೀರಾ, ನಾನು ಕೂಗಾಡ್ಬೋದು, ಅದಕ್ಕೆ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ದೆ.
ಇಲ್ಲ ಇಲ್ಲ
ನಾನು ಹೇಳದ್ನಲ್ಲ,
ನಾವೇನೋ ಮಾತಾಡಿದ್ವಾ?
ಇಲ್ಲ ಸರ್ ಅವರು ಆಗುತ್ತೆ ಆಗಲ್ಲ ಒಂದೇ ಮಾತು ಹೇಳಿ, ನಮ್ಗೆ ಅವೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಅಂದ್ರು ಸರ್. ನಾ ಬೋರ್ಡ್ ಹೋಗಿ ಕೇಳಿದೆ ಸರ್, ಅವಾಗ ಫಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದಾಗ ನಾನು ಆ ಕಡೆ ಹೋಗಿ ಕೇಳಿದೆ. ಅದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟರೆ ಅವ್ರು CJ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿದೆ, ನಾವು ರೀಕಾಲ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅದೇ ನಮ್ಮ ಮೆಮೊ ಎಷ್ಟೊತ್ತಿಗೆ ಹೇಳಿದೆ ಟೈಮಿಂಗ್ಸ್ ಎಲ್ಲ ನಾನು ಕೊಟ್ಟಿರೋದಲ್ಲ ಎಷ್ಟೋ ಕರೆಸ್ತೀವಿ ಕೇಳಿದೆ. ಲೀಸ್ಟ್ ಕ್ಲೋಸ್ ಆದ್ಮೇಲೆ ಎಲ್ಲರಿಗೂ ಕರ್ಸಿ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು ನಮ್ಮ ಕಡೆನೇ
ಅಷ್ಟೆಲ್ಲ ಲೈಫಲ್ಲಿ ಮ್ಯಾಟರ್ ಬರುತ್ತೆ ಹೋಗುತ್ತೆ
ಅಲ್ವಾ ಸರ್? ಅವ್ರು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೀನಿ, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗೆ ಕಾಪಿ ಕೊಡ್ಬೇಕು. ನೀವು ಬೆಳಗ್ಗೆ ಬಂದು ಫಸ್ಟ್ ಏನ್ ಕೇಳಿದ್ರಿ ನಂಗೆ, ನಾಳೆ ಬರ್ಬೇಕು ಇದು ಆಗತ್ತಾ ಅಂತ ಕೇಳಿ. ನಾನೇನು ಸ್ಟ್ರೇಟ್ ಅವೇ ಹೇಳಿ ಸರ್, ನನ್ನ ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಅಲ್ಲ, ನೀವು ಜೊತೆಗೆ ಇದ್ರಿ, ಅರ್ಧ ಗಂಟೆ ಇಲ್ಲೇ ಇದ್ರಿ ಅನ್ಸುತ್ತೆ. ಎಲ್ಲರಿಗೂ ನಾನು ಅದೇ ಹೇಳಿ ತಗೊಂಡೆ. ನಿಮ್ಗೇನಿದೆ ಸರ್ ಪರ್ಸನಲ್ ಇಂಟ್ರೆಸ್ಟ್? ಅವ್ರು ಹೇಳಿದ ತಕ್ಷಣ ಅವ್ರು ಇಲ್ಲ ಅಂತಾನೆ ಹೇಳಿದೆ ನಾನು, ಇಲ್ಲ ಸರ್ ಆಗಲ್ಲ ಅಂತ. ಈಗಲೂ ನಾನು ಹೇಳಿದೆ, ಈಗಲೂ ಹೇಳಿ ಅವ್ರು ಒಪ್ತಾ ಇಲ್ಲ. ನಾನೇನು ಈಗ ರೀಕಾಲ್ ಮಾಡ್ಬೇಕು ಲೀಸ್ಟ್ ಅಂದ್ರೆ CJ ಪರ್ಮಿಷನ್
ಅಷ್ಟೆಲ್ಲ
ಸಾಹೇಬ್ರಿಗೆ ಹೋಗಿ ಹೇಳಿದೆ CJ ಪರ್ಮಿಷನ್ ಬೇಕು ಅಂತ. ನೀವು ಹೇಳಿದ್ರೆ ಅವ್ರು ರೀಕಾಲ್ ಮಾಡ್ತಾರೆ. ನಾನು ಹೆಂಗೆ ಹೇಳ್ತೇನೆ, ಅವ್ರು ಯಾಕೆ ಅಷ್ಟು ಗಲಾಟೆ ಮಾಡಿದ್ರು ಅಂದ್ರು. ಸರಿ ಬೆಳಗ್ಗೆ ಬರ್ತೀನಿ ಅಂತ ಹೇಳೋಗಿದ್ದಾರೆ ಸರ್, ಬೆಳಗ್ಗೆ ಬರ್ಬಿಡಿ ನಾನು.
ಓಕೆ ಥ್ಯಾಂಕ್ಸ್.
ನಮ್ಮ ಕಡೆಯಿಂದ ಯಾವತ್ತು ಎಲ್ಲೂ CPC ಅಡ್ವೊಕೇಟ್ಸ್ ನನಗೋಸ್ಕರು, ಮತ್ತೆ CPC ಸಬ್ಜೆಕ್ಟ್ ವಸ್ತು ನಮ್ದು. ಬಟ್ ನಾವು ಇವತ್ತವರೆಗೂ ನಾನು ಎಷ್ಟು ಕೆಲಸ ಮಾಡಿದೀವೋ, ನಾನು ಯಾವತ್ತೂ ಎಲ್ಲೂ ಯಾವ ಅಡ್ವೊಕೇಟ್ ನನ್ನ ವಿರುದ್ಧ ಓದೋರು ಇಲ್ಲ. ಅವ್ರು ಹೇಳಕ್ಕಿಂತ ಮುಂಚೆ ಅವ್ರು ಕೆಲಸ ಮಾಡ್ಕೊಟ್ಟಿರ್ತೀನಿ. ಇವತ್ತು ಯಾಕಪ್ಪ ನೀವು ನಿಮ್ಮ ಕಲಿಗೆ ಹಂಗೆ ಮಾತಾಡ್ಬಿಟ್ರಿ, ಆಗುತ್ತೆ ಇಲ್ವೇನ್ರಿ ಅಂತ. ನಿಮ್ಮ ಸಲುವಾಗಿ ನಾನು ಇಷ್ಟೊತ್ತು ಬೋರ್ಡು, ಪೆಂಡಿಂಗು, ಸ್ಕೂಟ್ನಿ 3 ಜನದ ಹೆಸರು ಅಲ್ಲಿ ಕರೆಸ್ದೆ. ಅವ್ರು ಕೊನೆಗೆ ಒಂದೇ ಮಾತು ಹೇಳಿದ್ರು, ಸರ್ ರೀಕಾಲ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ CJ ಪರ್ಮಿಷನ್ ಬೇಕು, ವೆಬ್ ಪೋಸ್ಟ್ ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ರೀಕಾಲ್ ಆಗಲ್ಲ. ಏನೋ ಆ ಥರ ಇದು ಮಾಡಿದಾರಂತೆ ಸಾಫ್ಟ್ವೇರ್. ಸಾರಿ, ನಮ್ಮ ಕಡೆಯಿಂದ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ತೊಂದರೆ ಏನಿಲ್ಲ ಸರ್, ನನ್ನ ಡ್ಯೂಟಿ. ನನ್ಗೇನು ಗೊತ್ತಾ, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಕಾಪಿ ಕೊಡಿ, ಅವ್ರಿಗೇನೋ ಒಂದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇತ್ತು, ಅರ್ಧ ಗಂಟೆ ಒಳಗೆ ಅದು ಹೋಗ್ಬೇಕು ಅಂತ. ಆ ಮೇಡಮ್ ಪಾಪ ಇವ್ರೋಡೋಗಿ ಫೋನ್ ಮಾಡಿ ಕರ್ಕೊಂಡ್ಬಂದ್ರು. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. ಆ ಟೈಮ್ ನಿಮ್ಮವ್ರು ಬಂದ್ರು, ಆಗಲ್ಲ ಅಂತ ನಾನು ಹೇಳಿದೆ. ಯಾವುದು ನೀವು ಬೆಳಗ್ಗೆ 10:30 2:30 ಮೂವ್ ಮಾಡ್ತೀರಾ, ಅದು ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ ಸಾಹೇಬ್ರಿಗೆ, ಬೇಡವಾ? ಸರಿ ಸರ್, ಒಂದು ದಿನ ಬ್ರೀತಿಂಗ್ ಟೈಮ್ ಕೊಟ್ರೆ ನನ್ನ ಕೈಲಾಗಿದ್ದು ಮ್ಯಾಕ್ಸಿಮಮ್ ನಾನು ಮಾಡ್ಕೊಳ್ತೀನಿ. ಎಲ್ಲಿ ಇಲ್ಲೇ ನಿಮ್ಮ ಕಡೆಯಿಂದ ತೊಂದರೆ ಆಗಿಲ್ಲ ನಿಮ್ಗೆ. ಅವರು ತೊಂದರೆ ಆದವ್ರು 3 ಜನ ಕರ್ಸಲ್ಲಿ ನಿಲ್ಲಿಸ್ತೆ. ಈಗ ಅವ್ರು 3 ಜನ ನಾವು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ತೀವಿ ಸರ್ ಅಂತ ಹೇಳ್ಕೊಳ್ಳಿ. ಯಾಕಂದ್ರೆ ನಾಳೆ ಅವ್ರ ಪಾಪ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾರೆ. ಅವ್ರು ಏನು ಹೇಳಿದ್ರು, ಸರ್ ತಾವು ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ನಾವು ಲೀಸ್ಟ್ ರೀಕಾಲ್ ಮಾಡ್ತೀವಿ. ಸರಿ CJ ಪರ್ಮಿಷನ್ಗೆ ನಾನು ಮಾತಾಡೋಕ್ಕಾಗತ್ತೆ ಈಗ ಹೋಗಿ? ಬೇಡ, ನಾನು ಬೇಕಾದ್ರೆ ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ತೀನಿ. ಸರಿ ಸರ್, ನಮ್ಮ ಕಡೆಯಿಂದ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಸರ್. ಥ್ಯಾಂಕ್ ಯು.
ಶ್ರೀಮತಿ
ಓ ಅಡ್ವೊಕೇಟ್ ಇದ್ಲು, ಹೆಸರು ಪ್ರಸನ್ನ ಅಂತ. ಕೊಡು ಅಂದ್ರೆ ಕೊಡಲ್ಲ ಅಂದ್ಲು. ಬೇಡ ಅಷ್ಟೊತ್ತಿಗೆ. ಯಾರು ಇವಾಗ ಮಧ್ಯಾಹ್ನ ಈಗ್ಲ? ಅಯ್ಯೋ ಬತ್ ಕಳ್ಸಪ್ಪ, ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟೆ ಹೆಂಗೆ ಮರ್ತ್ಗಿರ್ತ ಹೋಗ್ಬಿಟ್ರೆ ಬಿಡ್ತಾರ ನಮ್ಮನ್ನ? ನಾನು ಆ ಅಮ್ಮನ ಕೈಗೆ ಕೊಡು ಅಂತಾನು ಒಂದೇ, ನಿಂಗೆ ಅವ್ರವ್ರ ಕೈಗೆ ಕೊಟ್ಬಿಡು. ಏನಂತ? ಅಯ್ಯೋ ಅವ್ರ ಕೈಗೆ ಅಂತದಿದ್ದಾಗ ನೀನ್ ಡಿಸಿಷನ್ ತಗೋ. ಇವ್ನ್ ಯಾವನ ತಲೆ ತಿಂದ ಅಂತ ಹೋಗಿ ನನ್ನ ಸಾಹೇಬ್ರಿಗೆಲ್ಲ ಹೇಳಿದ್ದಾಯ್ತು. ಏನಂತ ಬರೀಬೇಕು? ಏನಂತ ಬರೀಬೇಕೀಗ? ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 10ಕ್ಕೆ ಬರೆಯಕ್ ಆಗಲ್ವಲ್ಲ? WP ಏನಿದು? ಅದ್ ಸರಿಯಪ್ಪ, ಇದು WP RF ಏನೂ ಇಲ್ವಲ್ಲ? ಇಟ್ಕೊಂಡ್ ಬೆಳಿಗ್ಗೆ ಬರೀ. ಏನಂತ ಕೊಡ್ಲಿ ಈಗ ನಾನು? 10ಕ್ಕೆ ನಾನ್ ಬರ್ದು ನೀನ್ ಬರ್ತರು ಏನ ಹಿಡ್ಕಂತ ತಿರ್ಗಾ ನೀನ್ ಹೆಂಗ್ ಬರ್ದೆ 10ಕ್ಕೆ RF? ಸುಮ್ನೆ ಇಟ್ಟಿರ. ಅಲ್ಲೆಲ್ಲ ಫೋನ್ ನಂಬರ್ ಐತಾ ಅಲ್ಲಿ? ಮತ್ತೆ ಇದನ್ನ ನಾವ್ ಹೆಂಗಪ್ಪ ಇಟ್ಕೊಳ್ಳೋದು ಈಗ? ನನ್ನ ಹತ್ರನೇ ಇಟ್ಟಿರ್ತೀನಿ, ತಲೆನೋವು. ರಮೇಶ್ ಬಂದ್ರಾ? ಬರ್ತಾರಂತಪ್ಪ. ಅವ್ನ್ ಬೆಳಗ್ಗೆಯಿಂದ ನಾನು ತಲೆ ತಿಂತಾ ಇದ್ದಾನೆ. 2 ಗಂಟೆವರೆಗೂ ನೀವು ಇಲ್ಲೇ ಇದ್ದೀರಾ? ನೀವು ಹುಷಾರ್ರಿ.